Serial number 55. National E-assessment. Yaru? Mr. Sud, Mr. M. Tirumalesh is directed to accept notice for the respondent. Counsel for the petitioner is directed to serve a complete set of the writ petition to the learned counsel for the respondent. ಅದ್ಯಾರು ಹುಬ್ಳಿಗೆ ಒಂದು ಸರ್ವ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರಲ್ವಾ ಅವರು? The petitioner shall also serve a copy of the writ petition to the Hubli office at Navnagar. Hubli office of the respondent at Navnagar. Yes. Interim order granted early is extended till the next date.
Lordship 53.
53.
53, currently week's time, my lord, I am in out of station, my lord. There is interim order, Lordship.
No, boy, why you people don't want to argue?
No, my lord, the morning I came Bangalore, my lord, some person. So, kindly next week, my lord, and
You're in Bangalore.
yes, my lord.
Why are you in Bangalore?
Some on the matter is just principal bench.
Principal bench matter there.
Sir.
Learned counsel for the petition seeks time list on. Yes.
56 also, sir. Same matter.
56.
Swami. Adrallo interim order ಇದೆ. ಎಲ್ಲ ಒಂದೇ issue ಇದೆ, 16(4) issue ಇದೆ.
List the learned counsel for the petition seeks time list on so and so. List this petition along with serial number 53.
Please, Lord.
60 and 63, my lord. There is some 60 and 63, my lord. Today I am not there, my afternoon. There is some personal inconvenience, my lord. Any date.
Yes, this is suit.
Suit is of 18, my lord.
2018.
First, my lord. I had argued twice, my lord, in book. Today afternoon I am not there. There is some personal inconvenience.
Learned counsel for the petitioner seeks time. List on date for interim order granted early extended to the next date. 63 same order.
63 interim order is not there, my lord.
Learned counsel for the respondent number 1C seeks time. List on date.
Obvious.
$65. ಯಾಕೆ ಯಾರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿಲ್ಲ ಯಾಕೆ?
Your Lordship, serial number 65. I am appearing for the R6, Your Lordship. My name has to be deleted as she has filed a wakalat for.
Directed to delete the name of Mr. Chaitanya Kumar CM.
Well, Ajay Kumar AK.
Ajay Kumar AK, sorry.
Already.
Ajay Kumar AK. And continue the name of Mr. Sharan Gowda V. Patil.
Much obvious.
Counsel for R6. Counsel for the respondent number 6 seeks time. List on interim order idya?
No.
ಎಷ್ಟನೇ ಇಸ್ವಿ ಸೂಟು? ಸಿದ್ದಾಪುರ್ಕರ ಆಗಸ್ಟಿನ್. ಎಷ್ಟನೇ ಇಸ್ವಿ ಸೂಟು? ಸೂಟ್ ಎಷ್ಟನೇ ಇಸ್ವಿ ಇದು ಅಂತ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟನೇ ಇಸ್ವಿ ಸೂಟ್? ಇಫ್ ಇಟ್ಸ್ ಅ ಓಲ್ಡ್ ಸೂಟ್, ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ಅಲ್ರಿ ರಿಟ್ ಪಿಟಿಷನ್ 23. ಚೆಕ್ ಮಾಡ್ರಿ ಯಾವ ಸೂಟ್ ಎಷ್ಟನೇ ಇಸ್ವಿ ಸೂಟ್. ಎಸ್ ನೆಕ್ಸ್ಟ್.
My Lordship, serial number 74, 75, my Lordship. And SLP is,
suit.
it is of 2024, my Lordship matters.
Sir.
Oh, yes. This is not the.
MVC ಎಷ್ಟನೇ ಇಸ್ವಿ ದಪ್ಪ?
This is regarding the WP, my Lordship. MVC is of 23, my Lordship, I think. 23 and 2018, my Lordship. MVC is of.
Why 2018 MVC should be kept pending?
Because of, my Lordship, section 166 of MV Act, my Lordship. There is a bar on filing the claim petition, my Lordship.
Therefore, we'll decide the case. Why should the claimant be waiting?
Yes, my Lordship, an SLP is filed, my Lordship, before the Honorable Apex Court, my Lordship. And it is postponed on 25 to 2025, my Lordship.
Learned counsel for the petitioner seeks time.
26 is also same matter, my Lordship, identical matter, my Lordship. Serial number 26, my Lordship.
74 and 75, list on date.
26.
List
Serial
is
number
petitions along
26.
with serial number 26. ಸರಿ ಲೈವ್ ಇದೆಯಾ ಅದು ಹೇಳ್ಬೇಕಲ್ಲ ಹಾ ಬಂದಿದ ತಕ್ಷಣ ಹೇಳ್ಬೇಕು
My lord, no, my lord, the objection is, my lord, the other side has no, government has not served. My lord, they already served.
My lord, may I submit, my lord? I am for the petitioner. Lord, the office objection is already complied with, my lord, and government has been already served all yesterday itself, my
What
lord.
is the office objection?
Only, my lord, that fixing the welfare stamp,
No,
and that has been already done. And my lord, with regard to serving the copy on the government, my lord, that has also been done, my lords.
ಮಾಡಿದಾರಾ?
Yes, my lord.
Yes.
My lord, the matter relates to my lord's transfer. Have gone and reported to the present place on 18/6/2024, my lord. Now, my lords, all of a sudden, my lords, on 16/1/2025, my lord, the third respondent is accommodated in the place of petitioner, my lord, who is on deputation, my lord. The third respondent, my lord, he is in the cadre of first division assistant, who was discharging as a first division assistant at the Kalaburagi Parihara Nirashita Kendra. My lord, I was posted there on 18/6/2024 as a superintendent grade 2. Lord, I am originally in the cadre of head warder. My lord, the provision itself is not there for deputation. My lord, the third respondent, who is a deputationist, my lord, who is in the cadre of first division.
Is it a case of deputation or transfer?
My lord, the third respondent is a deputationist. My lord, I have been disturbed prematurely, my lord, posting me to the Dharwad as a head warder, and he has been given an in charge additional post of superintendent grade 2. My lord, the C&R rule says, my lord, there is no provision for deputation to the post of superintendent grade 2. I am the employee of the second respondent.
Mister, you are a head warden.
Yes, my lord. Yes, my lord.
You are only holding an additional charge of
Yes, my lord. I am
superintendent
also
grade.
holding an additional charge, my lord.
So therefore, whether this head warden and first division assistant are of the same cadre,
No, my lords. No, my lords.
how do you say that?
Lord, kindly come to page 46, my lords, the C&R rules.
46,
Yes, my lord. Superintendent grade 2, item number 5, my lords.
You're not, that is additional charge, mister.
Please, my lord, please, my lord. I
Ask
have
you a simple question, whether
Yes,
head
lord.
warden and
No, my
this
lord. No, my lord. The both are not equal cadre, my lord.
Dorsey.
Lord, the first division assistant of social welfare department, my lord, he is an employee of social welfare department. I am an employee of committee, second respondent committee, my lord, central relief committee. Lord, my only question is this, my lord. My lord, I am a holder of master's degree in sociology. My lord, so as per the superintendent grade 2, the qualification required for holding that post is, my lord's master's degree in sociology. Or, my lord, kindly come to, my lord, page 46. For the promotion, my lord, for direct recruitment must be holder of master's degree in social work, MSW, or sociology. I am the holder of master's degree in sociology, my lord. Lord, I have made a representation. My lord, for a moment, Lord, annexure D may kindly be seen, my lord. Annexure D. Page 66, my lord. This is the promotion order given on 2/1/2017. Lords, kindly come to next page, my lords, page 67. Item number 7, my lords. It is the petitioner, my lords, Mallappa Fakirappa Megade, warder, Nirashitra Parihara Kendra, Belagavi. My lords, he was given promotion as head warder, Nirashitra Parihara Kendra, Belagavi, Adhikshakara Huddege Hetsuri Prabhara. My lords, from 2017, my lords, I am discharging as a superintendent grade 2. On the basis of my lord, at the time of granting promotion itself, my lords, I was given an additional charge of head warder, superintendent grade
From
2.
2017, you have been there.
Yes, my lord. Not I was working in Belagavi, my lords. I was working in Belagavi. On 18/6/2024, my lords, I was transferred to Kalaburagi.
No, you have been working from the last 7 years or 8 years.
Yes, my lord.
Please make your way.
My lord, not that point, my lord. On one more submission, which is annexure E. Annexure E may kindly be seen. Annexure E may kindly be seen. This is the passing certificate. I have completed master's degree in 2011 itself,
So,
my lord, I'm eligible to be promoted or directly recruited to the post of superintendent grade 2. I have made a
it's
representation,
all
my lord.
right. When there's a DPC constituted, they will consider your case.
That's correct, my lord. That's correct, my lord. And one more submission is this, my lord. My lord, the posts, my lord, there are vacancies available in the second respondent committee, my lord. I have produced the vacancy list at Annexure K, page 77. For a moment, my lord, for a
No,
moment.
no,
May
state,
be
you've been
permitted, my lord.
working for the last 7 years, Mr.
Lord,
Make
he is
way.
also not eligible to
I
hold
know
that
it
post,
is
my lord.
something like, ನೀವು ಒಂದ್ ಕಡೆ post ಮಾಡ್ಬಿಟ್ರೆ ಅಲ್ಲೇ ನಿಮ್ permanent
Illa,
ಆಗಿ
illa.
posting
That is not the, that is, my lord, my representation is there, my lord. Kindly come to my
No
representation.
entry order. AG is directed to accept notice for.
Lord,
respondent
Annexure
number
H, my
one.
lord. Annexure H for a moment, my lord. Annexure H for a moment. Page 75.
Ah,
Lord, kindly see, my lord, that this is the representation given in 2022 itself, my lord. For,
hmm.
as I am holding the qualification and I am eligible to be promoted to the post of superintendent grade 2. My lord, on the basis of qualification, my lord, they have not considered so far. And
Yes.
on the basis of qualification only, my lords, I have been continued in the post of my lord, superintendent grade 2.
No, please vacate the place.
Lord, my lord,
Issue
that-
AG is directed to accept notice for the respondents.
Lord, there is no provision for deputation also, my lord.
Respondent number 2 ಗೆ 2 ನೀವೇ ತಗೋತೀರಾ? Beggary Act, Prohibition of Beggary Act ಅಲ್ಲಿ Central Relief Committee ನೀವೇ ತಗೋತೀರಾ? AG is directed to accept notice for respondent number 1. Where is the order of deputation? Annexure?
Lord, Annexure L and M, my lords, are the orders. Page 79 and 80, page 79 and 80, my lords. My lord, this is just an act, my lord, the order
Please read.
accommodating the third respondent. to
You're
hold-
not allowing me to read the Annexure
Please,
L.
Lord.
Please
Annexure
read.
L, page 79, my lords.
Very good.
ಪ್ರಕಾಶ್ ಎನ್ ಪವಾರ್ ಪ್ರಥಮ ದರ್ಜೆ ಸಹಾಯಕರು ಇವರಿಗೆ ಕಚೇರಿ ಅಧೀಕ್ಷಕರ ಹುದ್ದೆಗೆ ಪ್ರಭಾರ ನೀಡುವ ಬಗ್ಗೆ he is also given an additional charge, my lord, where there is no provision itself. He
Yes.
is on deputation, my lord.
Please
There is
read.
no provision for deputation itself.
Please read.
ಪ್ಲೀಸ್ ನೋಡ್ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಅಧಿಕೃತ ಜ್ಞಾಪನ ದಿನಾಂಕ 18/6/2024ರಲ್ಲಿ ಶ್ರೀ MF ಮೇಗಡೆ ಹೆಡ್ ವಾರ್ಡರ್ ಪ್ರಭಾರ ಅಧೀಕ್ಷಕರು ನಿರಾಶ್ರಿತರ ಪರಿಹಾರ ಕೇಂದ್ರ ಬೆಳಗಾವಿ ಇವರನ್ನು ಕಲಬುರಗಿ ನಿರಾಶ್ರಿತರ ಪರಿಹಾರ ಕೇಂದ್ರದಲ್ಲಿ ಖಾಲಿ ಇರುವ ಅಧೀಕ್ಷಕರ ಹುದ್ದೆ ನಿಯೋಜನೆ ಮಾಡಿ ಆದೇಶಿಸಿರುವುದನ್ನು ಮಾರ್ಪಡಿಸಿ ಇಟ್ ಇಸ್ ಅ ಮಾಡಿಫಿಕೇಶನ್ ಡನ್ ಟು ದಿ ಆರ್ಡರ್ ವಿಚ್ ಇಸ್ ಇಂಪ್ಲಿಮೆಂಟೆಡ್ ಇನ್ 18/6/2024 itself, my lord. I have gone and reported there. Now they have come with modifying the order, my lord, sending me to the Dharwad.
The AG is directed to accept notice for respondent number 1, issue emergent notice to respondent number 2 and 3. The posting of the respondent number 3 as in charge of superintendent grade 2 is subject to the result of this writ petition.
Lord, let there be an interim order of stay, my lords, my lord. He is also not eligible to hold the post, my lord.
No, it's all right.
Lord, I am working on the basis of my qualification, my lords. I have.
Please vacate, sir. You have been working as from the last 8 years. That is enough.
There are no, my lord, kindly see the vacancies available, my lord. There are nobody in the
Mr.
committee to
Council,
hold the
it
post,
is
my
an
lord.
in-charge post. It's an in-charge post. You have no right to remain in
He
the.
has also no right, my
I
lord.
have no right. What is your right?
It
You
is
are only a head
it
warden. You have
manifest
been given a
intentions, my lords, to just to accommodate third
Sorry, yes,
respondent, my lords,
next.
in the post of superintendent grade 2, where I am already qualified and eligible to hold the post.
You cannot, you are being given 2 posts. One is
Lord.
head warden and another superintendent. You're neither doing this nor that.
My lord,
Therefore, the
discharging my
government
duty, my
feels
lord.
that
I'm
there
just
should be one
obeying.
person.
I have obeyed the order of the authority, my lord, and gone and reported and discharging. This is modification made to the
Government wants
order
one
which is
person.
already implemented, my lord.
Next.
It is already implemented.
Other Khan.
Lord, let the-
Subject to the result, Mr. Vijay.
My lord, the writ has
Sorry,
become infructuous. I'm filing a memo.
The learned counsel for the petition has filed a memo stating that the writ petition has become infructuous. The memo is taken on record and the petition is dismissed as having become infructuous. A. Ramachandra. 1 week time is granted to ಎಷ್ಟನೇ suit ನೋಡಿ ಏನು objection ಏನು
Weeks time.
Yeah, what are the objections? Just ಕೊಡ್ರಿ ಇಲ್ಲಿ ಕೊಡಿ ಇಲ್ಲಿ 2020 Injunction is challenged. Grant of injunction is challenged, huh? Bank of parties, pin code, GPA to get us. 1 week time is granted to do the needful. Sandeep Vijay Kumar. Suit is filed in which year? Two thousand 21. 1 week time is granted to do the needful. PK Hiramat, same order.
In this case, my withdrawn liberated to the fresh file.
Huh?
Like a promotion, but sir, liberated to the fresh file.
Promotion, no?
Promotion is sir, so modify again. But endorsement code is sir, liberated to the fresh file.
Memo is filed by the learned counsel for the petitioner to dismiss the writ petition as not pressed due to changed circumstances. Fresh filing ಏನಕ್ಕೆ?
ಅಲ್ಲ ಅದು ಪ್ರಮೋಷನ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಡಿ ಸರ್ ಮತ್ತೆ ಸೀನಿಯರಿಟಿ ಮೇಲೆ ಅದಕ್ಕೋಸ್ಕರ ಮತ್ತೆ ಮಾಡಿ.
Stop. If the petitioner is entitled to, full stop. The petitioner is sought for permission to file a fresh writ petition without disclosing whether he needs the permission to file a fresh writ petition on the same cause of action or otherwise. Full stop. If there are changed circumstances, the petitioner is entitled to file a fresh petition in view of the changed circumstances
Macho.
and not on the same cause of action. Yes. A letter dated so-and-so, addressed by the so-and-so, letter dated 17/12/2024, addressed by the Principal District and Sessions Judge Vijaypura to this court is perused. The time for disposal of OS number 23 of 2012 is extended by another 3 months from the date of receipt of a copy of this order. Manjunath Rayappa.
ಪಾಸ್ವರ್ಡ್ ಮೈಲಾಡ್
Password.
230 ಅಮೌಂಟ್ ಕಟ್ಟಿದ್ದೀನಿ ಮೇಲೆ
So caste title amendment ಮಾಡ್ರಿ.
ಕಟ್ಟಿದ್ದೀನಿ ಮೈಲಾಡ್
Caste title amendment,
ಖಂಡಿತ
non-filing of amended caste title, ಅದೇನೋ ಮಾಡಿ.
ಖಂಡಿತ
Kindly weeks time.
2020 ಏನಿದು suit ಎಷ್ಟನೇ ಇದು? Suit is filed in which year?
Kindly password, I don't have file.
ನೀವು ಫೈಲ್ ನೋಡ್ಕೊಂಡ್ ಬರ್ತಿದ್ರೆ I told juniors, all advocates, ನೀವು ಅಡ್ಜಮೆಂಟ್ ತಗೊಳ್ಳಿ ಏನಾರ ಮಾಡಿ ಫೈಲ್ ಓದ್ಕೊಂಡ್ ಬನ್ನಿ.
Kindly password, I will go through.
Suit is filed in 2010. 14 years have gone by. No adjournment. Please argue the matter.
Kindly password, Mela, I will agree to be. Kindly password.
Pass over. No adjournment. Ramchandra K. ಎಷ್ಟನೇ ಇಸ್ವಿ ಸೂಟು?
2017.
ಏನ್ ಹೇಳ್ರಿ ಕೇಸ್? ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ IA copies to issue notice on LRs of deceased respondent. What is the case?
Petitioners are the defendants in the present suit, my OS number 113 of 17 mailer. The respondents filed a suit for possession and damages. In respect of same suit scheduled property, the petition number 2 earlier filed OS number 149 of 16, suit for specific performance of contract. Therefore, the petition number 2 filed IA under section 10 of CPC for staying the further proceedings of present suit till disposal of the earlier suit of filed by the petition number 2.
313 filed for?
Sorry?
OS number 313 ಏನಕ್ಕೆ ಹಾಕಿರೋದು?
Petition number 2 filed for suit for specific performance of contract.
OS number 313 is for what?
This is suit for possession and damages filed by the respondent plaintiffs.
ಎಲ್ಲಿದೆ plaint ಎಲ್ಲಿದೆ? 313. This is for possession
Yes,
and damages.
yes.
Which is the other suit filed by the respondent?
No, petition number 2, suit number OS number 149 of 16.
This is for specific performance.
Yes,
What is the application now filed?
under section 10 of CPC, Staying the further proceedings of present suit OS number 113 of 17, 313 of 17 filed by the respondent plaintiff Miller.
Now
Till
this,
disposal of the earlier suit filed by the petition number 2, which is rejected by the trial court without considering the facts involved in the both the suits. So the suit properties are same, parties are same, but only
party.
annexure F Miller, the impugned order.
ರೇವಣ್ಣ ಸಿದ್ದೆ respond number 2.
Only on the observation that the relief sought by the in both the suits are different and issues framed in the both suits are different. On that ground, the application filed by the petition number 2 is rejected, Miller. But with the suit property is same, parties are same in both the suits. Which is not considered.
No, but this 313 is filed on the premise that you are a tenant. 313,
Yes.
OS number 313 is filed on the averment that you are a tenant in the premises.
They agreed to, there is an agreement of sale, Miller.
OS number 313 is filed on what ground? OS number 313 of 2017 is filed on what facts? That you are a tenant in the premises.
Yes, Miller, they agreed to sell that property, Miller.
First, let me understand the
Yes,
facts.
yes, please.
OS number 313 of 2017 is filed on what facts? On yav grounds ಮೇಲೆ ಫೈಲ್ ಮಾಡೋದು OS number 313. OS number
Yes, yes, yes.
313 ಯಾವ grounds ಮೇಲೆ ಓದಿ page number 22 ಬನ್ನಿ. Paragraph number 4 ಓದಿ.
Please. That the defendant number 2 had approached the plaintiff during the month of October 2013, along with the defendant number 1 seeking the above mentioned suit premises described in the para number 2 of plaint on lease to
So
run a
it is on
business.
lease. So he says that you have taken the premises on lease. Now you say that it was agreed to be sold. So you have filed a suit for specific performance. So therefore you want this suit to be stayed.
Earlier to this present suit, the defendant number 2 filed a OS number 149 of 16.
Let both the suits be tried together.
Better.
Let both the suits be tried
Yes.
together for court. It's before the same court.
No, different courts suits are pending, my lord.
Illi
The suit for
ಒಂದು
possession
is filed pending before which court? Suit for possession is pending before which court? Nodi madam, OS number 313 of 2017. Fourth additional civil judge in JMFC Kalaburagi. ಮತ್ತೆ
Yes.
OS number 149 of 2016. Civil judge senior division Kalaburagi. ಎರಡು ಒಂದೇ ಕೋರ್ಟ್ ಇದೆ ನೋಡಿ.
No, the suit for specific performance pending before the senior civil judge Kalaburagi.
Is there only one senior civil judge in Kalaburagi?
Additional courts are there.
And what about this?
Second additional,
What about this 313?
second additional.
Second additional.
Yes.
Very
Yeah.
good. Petition is filed by the defendants in OS number
Yes.
149 of 2000, sorry. Defendants in 149 of 2016,
Sorry, fourth additional, my lord.
149 of 2016.
313 is
313 of 2017.
fourth
313 of 2017. Pending on the file of the fourth additional
additional.
civil judge and JMFC Kalaburagi. Challenging an order dated so and so by which an application filed by them under section 10 of Code of Civil Procedure for stay of further proceedings in OS number 149 of 2016 was rejected. Next paragraph. A suit in OS number 313 of 2017 was filed by the respondent herein for eviction of the petitioners from the suit scheduled property. The respondent claimed that the petitioners were inducted as tenants in the suit property and that they had failed to pay the rent at the rate of rupees 12,800 per month as a check drawn by them towards payment of the rent was dishonored. Full stop. The defendants in the suit had earlier filed OS number 149 of 2016 for specific performance of an agreement of sale purportedly executed by the respondent herein.
Voice number 313 of 17, Nagangowda. Plaintiff.
Dated 3/1/2014.
Ah,
Full
yes.
stop.
Petition.
The respondent contested the suit filed by the petitioners for specific performance. Next paragraph. The defendants in OS 313 of 2017 were therefore advised to file an application under section 10 of the Code of Civil Procedure to stay further proceedings in OS number 149 of 2016. Full stop. The trial court, in terms of the impugned order, rejected the application on the ground that the relief sought for in both the suits were different, though parties were the same and the suit property was the same. Full stop. Therefore, it held that the suit filed in OS number 313/2017 was not for the same reliefs that was sought for in OS number 149 of 2016. Full stop. Being agreed by the said order, the defendants in OS number 313 of 2018 are before this court. 17 and
No, 18. There is a typical error, Malad. 313-17.
Full stop. The learned counsel for the defendants petitioners submitted that the question whether an agreement of sale was executed or not is pending consideration in OS number 149 of 2016, and therefore any finding recorded in the said suit would have an effect on the suit filed in OS number 313 of 2017. Therefore, he contends that the said suit
149 and 16.
for possession, therefore he contends that OS number 313 of 2017 has to be stayed.
Kalaburagi. Aste.
Next para.
One Kalaburagi.
As rightly held by the trial court, the relief in both the suits are different. Full stop. While the respondent sought for possession and damages in OS number 313 of 2017, the petitioners filed OS number 149 of 2016 for specific performance of an agreement of sale allegedly executed in their favor in respect of the suit property. Full stop. Therefore, section 10 of Code of Civil Procedure was strictly not applicable, and the suit filed by the respondent in OS number 313 of 2017 could not be stayed, cannot be stayed. Full stop. However, having regard to the relief sought for in both the suits and also having regard to the contentions urged by the petitioners in OS number 149 of 2016, and 149 2016 and 313 of 2017, it is appropriate that both the suits are tried by the same court together.
149 of 6
Stop. Hence, this petition is disposed of, directing the suit invoice number 313 of 2017 to be transferred to the suit where OS number 149 of 2016 is pending consideration. Full stop. Both the suits shall be called together and both the suits shall be tried independently and a common judgment shall be passed in both the suits. Yes, writ
Please.
petition stands disposed of on the above terms.
Please.
Suit is filed in which year?
2012, Your Lordship.
Yearly, fact said.
Suit for declaration and injunction, Your Lordships. Document that is labeled as agreement for sale has been impounded, Your Lordships. Challenging that order and deficit stamp duty and penalty has been imposed.
Where's the agreement?
Your Lordship. Agreement starts at page 46, Your Lordships.
46.
46. Typed copy is at page 50.
46 or 54?
ಇಲ್ಲ ಎರಡಿದಾವ್ ಸ್ವಾಮಿ ಮುಂಚೆ ಏನಾಗಿತ್ತು the previous agreement for sale,
No, which is the agreement which is impounded now?
both the agreement of sale has been impounded.
What is mentioned in the agreement?
Your Lordships, in the clause 6, it is mentioned that Your Lordships portion has to be delivered before registration of sale deed. It is because of that at clause 6, Your Lordships, at page 48, Your Lordships. The first party immediately after receipt of the balance consideration amount shall hand over all his title deeds of his above described land to the second party and also place in actual possession of the said land with second party before registration of the sale deed.
So possession is not delivered,
Not delivered.
then which is the other agreement?
In fact, Your Lordships, the previous agreement for sale was in respect of 4 acres. A survey was conducted and it was found that Your Lordships, the vendor is in possession of only 3 acres 6 guntas. And for that reason, Your Lordships, another agreement for sale has been entered into. It is at page 54, Your Lordships. Same clause is there at Your Lordships, clause 7 at page 56. It is suit for declaration and Your Lordships injunction.
You're not sought for possession.
Your Lordships, I am not the plaintiff. I am the defendant number 1. Plaintiff has filed a suit,
Plaintiff has not sought for possession.
not sought for possession.
Has he at least said that he is not in possession?
He says that Your Lordship, he is in possession.
The plaintiff.
Yes. At para 2 of the plaint, Your Lordship, at page 21. If I'm permitted to read, Your Lordship. That plaintiff is lawful owner and possessor of the suit land, which detailed in the schedule. It is ancestral property of the plaintiff. As per the previous family partition, it was fallen to the share of plaintiff's father. Though the D1 illegally got mutation and tried to sell the suit land, as such, the plaintiff filed suit in OS number 23.
But where does he say that he was placed in possession under this agreement?
Your Lordships, he is not the beneficiary of this agreement, Your Lordships.
Who is the beneficiary?
Defendant number 1 is the beneficiary. Defendant number 2 has executed an agreement for sale.
Where does the defendant number 1 say that he was placed in possession under the agreement?
He is, Your Lordships, claiming possession and title on the basis of Your Lordships partition and a compromise decree.
Has he anywhere stated that possession was delivered to him under this agreement?
No.
Then
Your Lordships, he has not stated that Your Lordships possession has been delivered. If I may clarify the facts, Your Lordships. Plaintiff filed a suit for declaration and injunction against defendant number 1.
Yes.
Defendant number 2 and father of plaintiff are real brothers. The father of plaintiff is defendant number 3. He has been laterly impleaded, Your Lordships. And Your Lordships, I have filed a written statement contending that defendant number 2, claiming as a owner of the property, as his name is reflected in the revenue records, has entered into an agreement of sale with defendant number 1. And I have filed a written statement, Your Lordships, saying that.
Please read your written statement.
Yes. From para 2, if you
Yes, please read.
that the contents of para number 2 of the plaint that the plaintiff is the absolute owner and possessor of the suit land and it is ancestral property of plaintiff. And as per previous partition, it is fallen to the share of the plaintiff further. And the defendant number 2 is illegally got mutated and tried to sell the suit land are all false and incorrect. Hence, this defendant is denying the same specifically as false and incorrect. On the other hand, it is the suit land survey number 279 measuring 8 acres of Mudgal has been purchased by the father of defendant number 2. And thereafter, the father of defendant number 2 has transferred the land to an extent of 4 acres in the name of defendant number 2 by relinquishing his rights for the same under mutation number 52 on 17/12/1994. Since then, the defendant number 2 had become the absolute owner and possessor of the suit land, and he being the absolute owner of the said land with an intention to sold out the same for his family and legal necessity. And in that regard, he has approached this defendant number 1 and sale talks were held and concluded in between defendant number 1 and 2 in the presence of family members of defendant number 2. So also the other witness and the defendant number 2 has executed the deed of agreement of sale on 2/5/2008 by receiving the part consideration amount of rupees 2,10,000 out of sale consideration amount of rupees 22 lakhs. And thereafter, the defendant number 2 by receiving an amount of rupees 3 lakhs and executed the consent agreement of sale deed on 8/8/2008. And thereafter, the defendant number 1 and 2 have moved the application for survey of the land for preparation of EMAP in order to execute the registered sale deed before the survey authorities. Then only the defendant number 1 came to know that the land in question, which is in possession of defendant number 2, measures only 3 acres and 6 kuntas, and the map was prepared. Accordingly, as per the map prepared by the competent authority, again the defendant number 1 and 2 have settled the amount of sale consideration for rupees 17,32,500 for alienation of the land to an extent of 3 acres and 6 kuntas on 2011/2009. And on the same day, this defendant number 1 has paid the amount of rupees 10,72,500 to the defendant number 2. And in addition, the defendant number 1 has paid the amount of rupees 40,000 to the defendant number 2 as per the say of elders and delay caused in getting the registered sale deed. And the defendant number 2 by admitting the receipt of previous payment of rupees 5,10,000 from the defendant number 1 has executed deed of agreement of sale before so and so at Lingasugur. That these being the real facts as suppressed by the plaintiff in bringing the suit. Hence, the question of bringing the suit against the defendant number 2 by the plaintiff does not arise at all. The very compromise decree alleged to have been brought by the plaintiff and defendant number 2 is fraudulent as both of them have colluded with each other and illegally succeeded in getting the compromise decree by suppressing the above mentioned material facts. And their main contention is only to cheat the defendant number 1. Hence, the very approach of the plaintiff before the honorable court is without clean hands and they have suppressed the material facts. And as such,
Where have you said that you are in possession?
no, Your Lordship, we are not stated that we are in possession.
So we'll record that you are not in possession.
Yes, Your Lordship. The agreement for sale is, in fact, is without possession.
For good. Your other side, yaru?
Your Lordships, in fact, the counsel for defendant number 1 is no more, Your Lordships.
R3. Anyway, petitioner, the sons are there on record. They are R3, yaru? Sangappa. So the defendants 1 and 2 are the legal heirs.
2 is the brother, Your Lordships. Defendant number 2 is the brother of defendant number 3. And Your Lordships, defendant number 1 is the, respondent number 1, who is the plaintiff in the present writ petition, is the contesting party.
ಏನಪ್ಪ ಹೆಸರುಗಳು ನೋಡಿ ಪಂಪಣ್ಣ ಜಿಡಿ ಸಂಗಪ್ಪ ಜಿಡಿ plaintiff and defendant number 1 are cousins.
Plaintiff and defendant number 1 are not related. Plaintiff and defendant number 2 are cousins.
Plaintiff and defendant number 2
Are cousins. Yes, yes.
Cousins.
Yes, yes. Plaintiff is the brother son of defendant number 2.
Cool. Where is the impugned order?
Yes.
Other side, yaaridaru? Defendant number, respondent 1 yaru?
Is
Nanag.
Mr. Gurraj Rao Kakkeri is representing Your Lordships. He is no more, Your Lordships.
Gurraj Rao Kakkeri is no more.
Yes.
Cool. The counsel for the respondent number 1, where is the impugned order?
Yes, sir.
Is expired. Therefore, office is directed to issue court notice to the respondent number 1, informing him to engage the services of another advocate if he is interested to contest this writ petition. Really, where is the impugned order?
Page 70 is the typed copy, Your Lordships. 68, your lordship. 12/4/2021 order. Is at page 66, your lordship. Typed copy is at page 70.
In addition, comma, the learned counsel for the petitioner is directed to serve the learned counsel who represents the respondent number one before the trial court. List down on date code. Allow ಮಾಡ್ಬೇಕಾಯ್ತು, but the other side is not.
Mr. Ganesh Nayak, your lordship, he is from the same office.
Yeah,
If I may
but
request
if
him,
he is willing to accept notice, let him take it.
yes. If it could be passed over, your lordship, I will inquire.
Sure ಮಾಡ್ತೀನಿ.
Yes.
AGA,
There is an interim order operating.
see number 11, the interim order granted is extended to the next. AGA. One learned counsel, 1 week time is granted to do the needful, failing which the petition shall stand dismissed. Pass over. Shivkumar Kallu. Pay the process, mister.
I'll do the needful. I'll do the needful.
Now. Pass over. You have not done it from the last 2 years. Next. Act of regular appeal, non-taking of hand summons, PF periodical necessary application. ಏನು? Serial number 14.
Lord, in this case, suit for decree for specific performance was decreed and injunction order was granted by the court below. And first execution petition was filed by the petition.
You have not served the copy of the petition to the advocate.
Lord, he is refusing to take the,
File an affidavit, will ask the advocate to come to the court to explain why he has refused it. Affidavit file ಮಾಡಿ refuse ಮಾಡಿದ್ದಾರೆ.
no, I will try once again, my lord, request him to get the notice out.
You sent
This
it
is
by
second,
RPAD, there are so many ways and means. RPAD ಕಳ್ಸಿ, you not even accepted the hand summons.
In fact, the contesting respondent is already represented. my lord. Yes.
Correct, hand summons ಕೊಡಿ ಅಂತ ಕೇಳಿದಿರಿ. Issue ಮಾಡಿದೀವಿ. You have not
ಹೌದು.
received the hand summons from the office.
I'll take it.
1 week time is granted to do the needful.
Each time R2 is reported to be dead.
R2 ಯಾರು? R2 is the plaintiff.
R1, R3 to 6 minutes, sir, appears.
ಕೊಡ್ರಿ ಇದು.
Salute, sir.
Suit is filed in which year?
Fair. Now, RA Milord 6/17 application is sought for.
For amending the plaint.
Yes, Milords. RA is of the year 2021.
To Annappa. Who is respondent number 2 in this petition?
Two Milords.
Defendant number 2 and
He is also contesting respondent, Milords.
he is also contesting.
Yes, Milords. All of the parties, Milords. All the respondents.
No, if he files an application, I will take notice, my lord.
Because to all other
R2
respondents
ಎಲ್ಲ
already,
ಇದರ ನೋಡಿ.
to all other respondents. It's
ಅಣ್ಣಪ್ಪ, son of late ನಾಗಪ್ಪ ರೆಡ್ಡಿ. Wife of ಅಣ್ಣಪ್ಪ ರೆಡ್ಡಿ ಇದಾರಲ್ಲ ಇಲ್ಲಿ. R6. ಇದು 58 years to 72 years.
for children, Makladare, sir. Reddy.
1 week time is granted to take steps to bring the legal heirs of deceased on number 2, failing which the petition shall stand abated against respondent number 2, and consequently, the petition shall stand abated in its entirety.
Yes.
1 week, Saka?
2 weeks, Milords, because.
2 weeks.
Yes, sir.
Yes.
Interim order may be extended.
Order granted is extended to the next set of you.
Please.
Sandeep,
Kindly 2 days time you can get, my lord, for payment of process of fee.
serve it to the Advocate Standing Counsel, Mr. Tirumalesh. R1 yaru? Mr. M. Tirumalesh is directed to accept notice for the respondent number 1. The petitioner is also, the learned counsel for the petitioner is also directed to serve the Office of the Income Tax Department at Navnagar, Hubli.
There is interim order, ma'am.
The order granted rejection to the next.
Obliged,
period. Venkatesh Mallabadi,
Appearing for the petitioner, my lord.
what is this office objection? Put it.
No idea, my lord. I'll ask our local counsel to just
What
give.
is this office objection, Mr.?
Lord, the same is not available on the website also, my lord.
Here the office objection. Legible copy of annexure F2, F6. Office objection is overruled. Office objection serial number 1 is overruled. Yes, please argue. What is the matter?
Lord, suit for permanent injunction was filed before Civil Judge Junior Division Baswan Bagewadi, my lord, in OS number 182 of 2023.
Yes.
Originally, my lord, the petitioner is a licensee under section 164 of Electricity Act, my lord. ಈ ಟ್ರಾನ್ಸ್ಮಿಷನ್ ಲೈನ್ ಹಾಕೋದಕ್ಕೆ ಹೋದಾಗ ಇವರು ಅದನ್ನು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿ ಸೂಟ್ ಫಾರ್ ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ಹಾಕೊಂಡು ಆರ್ಡರ್ 39 ರೂಲ್ 1 and 2 ಕೆಳಗಡೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ಸ್ ಪಾಸ್ ಮಾಡಿದ್ರು ಮಲಡ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ಜೂನಿಯರ್ ಡಿವಿಷನ್. Since it is a project of central government, my lord, and we had a deadline at that point of time to commission the project within the time frame, we had preferred this writ petition, my lord, against the order on IA number 1 under order 39 rule 1 and 2, my lord. Right of way issues have to be dealt with in accordance with Telegraph Act, my lord. Section 16 of the Telegraph Act. Annexure K provides for the proceedings before the deputy magistrate where amount of quantum of compensation was already decided, my lord.
Where is it decided?
My lord, annexure K, my lord.
Annexure K.
Yes, my lord. Page number 77, my lord. Idರಲ್ಲಿ quantum of compensation already decide ಆಗಿತ್ತು. We had actually deposited the amount before the Assistant Commissioner Vijaypura District, my lord. In spite of which they had disputes regarding the compensation. They were not ready to take it. ಅದಕ್ಕೆ ಅವರು suit prefer ಮಾಡಿದ್ರು. But civil suit ಇದರಲ್ಲಿ maintainable ಅಲ್ಲ, my lord. 16(3) ಅಥವಾ 16(4) ಅಲ್ಲಿ ಅವರು ಸಿವಿಲ್ ಮಿಸ್ಲೇನಿಯಸ್ ಪೆಟಿಷನ್ ಹಾಕಬೇಕಾಗಿತ್ತು. We had brought this to the notice of the learned trial court judge, but without considering the same in annexure A, my lord, he had passed an order.
The trial court has said that you have not paid any compensation, so therefore you cannot barge into somebody's property.
My lord, their contention specifically in page number 26 of the writ petition, my lord, paragraph 8, my lord. ತದರಿ ಪ್ರತಿವಾದಿಯರು ವಾದಿಯ ದಾವಾ ಜಮೀನಿನಲ್ಲಿ ಯಾವುದೇ ವಿದ್ಯುತ್ ಗೋಪುರ ಹಾಗೂ ವಿದ್ಯುತ್ ವಯಾರ ಅಳವಡಿಸಬೇಕಾದಲ್ಲಿ ಭೂ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಗಳನ್ನು ಪೂರ್ಣಗೊಳಿಸಿ ಇಲ್ಲವೇ ಜಮೀನು ಮಾಲೀಕರಿಗೆ ಅನುಮತಿ ನೋಟಿಸ್ ಕೊಡದೆ ವಿದ್ಯುತ್ ಗೋಪುರಗಳನ್ನು ಅಳವಡಿಸಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲ. ಈ ಕಂಟೆನ್ಷನ್ ಮೇಲೆ ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್ ಗ್ರಾಂಟ್ ಆಗಿತ್ತು, my lord, under order 39 rule 1 and 2.
Yes.
Annexure.
Where have you said that you deposited the compensation?
My lord, annexure L, my lord.
Lapa, where have you said in your statement that you deposited the compensation? Have you filed a
My lord,
written
ಇವಾಗ
statement or not?
already, my lord, subsequent to filing of this writ petition and after the interim order of this court, my lord, the project was completed and the matter was settled. 5 ಲಕ್ಷ ಈಗ ಆಲ್ರೆಡಿ ನಾವು ಅವರಿಗೆ ಅಮೌಂಟ್ ನ ಕೂಡ ಡೆಪಾಸಿಟ್ ಅವರಿಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ my lord. 2,59,516 and 16 rupees and 20 paise is already given to them, my lord.
5 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ.
My lord,
ನೀವು 3 ಲಕ್ಷ ಕೊಟ್ರೆ ಅದನ್ನ ಬೇಕ್ರಿ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ. No, please tell us whether the lines are drawn or not.
it's already commissioned,
If the
my lord.
lines are drawn, then you have permitted them to do it. You have received some compensation. If you're interested, you can seek enhancement, do whatever you want. Huh? Totally angry urge ಮಾಡ್ತೀರಾ? Discrimination ಮಾಡಿದ್ರೆ ಸೂಟಲ್ಲಿ ಹೆಂಗ್ ಅರ್ಜ್ ಮಾಡ್ತೀರಪ್ಪ? Why don't you file some writ petition? Why do you waste people's time, mister? File a writ petition. Writ petition file ಮಾಡಿ ಅವ್ರಿಗೆ ಇಷ್ಟು ಕೊಟ್ಟಿದ್ರೆ ಇವ್ರಿಗೆ ಇಷ್ಟು ಕೊಟ್ಟಿದ್ರೆ ನಮ್ಗೆ ಕೊಡಿ ಅಂತ ಕೇಳಿ.
My lord, in fact, 30 times the amount has already been paid, my lord.
Therefore, you file a writ petition. Look at that Nagpur improvement case ಯಾವ್ದೋ ಒಂದು judgment ಇದೆ ನೋಡಿ 1976 Supreme Court. Please go through the judgment. You might be entitled for higher compensation. ಅದನ್ನೇಪ್ಪ ನಾನು ಹೇಳ್ತಿರೋದು, ನೀವು 8 ಲಕ್ಷ ತಗೊಳ್ಳಿ, ಬಟ್ ನೀವು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗಿ 8 ಲಕ್ಷ ಕೇಳಕ್ ಆಗಲ್ಲ.
Jurisdiction ಬರೋದಿಲ್ಲ, my lord.
So therefore, you ask him, RTA ನಲ್ಲಿ ಕೇಳಿ ಯಾರ್ಯಾರಿಗೆ ಎಷ್ಟೆಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಕೇಳ್ಬಿಟ್ಟು ಕೊಡ್ಸಿ ತಗೊಳ್ಳಿ. ಅದು ಬಿಟ್ಬಿಟ್ಟು why do you want to ಬರ್ಕೊಳ್ಳಿ. The defendants 1 and 2 in OS number so and so on the file of so and so are before this court challenging ex parte order, right? Then
Ex parte order,
ex parte order of interim injunction restraining the defendants from laying electric poles or drawing electric lines over the land bearing survey number 348/2 of Yavuru Muttigi village, Basavana Bagewadi Taluk. Next para. The respondent herein contended that he is the owner of the land bearing survey number 348/2 of Muttigi village, Basavana Bagewadi Taluk. He alleged that the defendants in the suit were trying to install electric poles to draw electric lines in his property without paying compensation, and hence sought for perpetual injunction to restrain the defendants from entering his property and from laying any electric lines or poles. From laying any electric poles or drawing any electric lines. Full stop. An application for interim injunction was also filed for similar relief. The trial court, after considering the fact that the plaintiff had specifically pleaded that no compensation was paid before the defendants laid the electric poles and drew the electric lines, granted an ex parte order of injunction restraining the defendants from laying the poles or drawing the lines over the property of the plaintiff. Being agreed with the said order, the defendants 1 and 2 have filed this petition. Next para. The learned counsel for the defendants contended that the defendants are implementing a central government project and that they are a telegraph authority under the Telegraph Act 1942, no 40,
1885.
1885, and that they have a right of way to implement a right of way over the property of the plaintiff, and they have a right to lay the towers and draw the electric lines. He also contends that the compensation payable in respect of the land used up for laying the electric poles are already determined. Full stop. He contends that after the impugned order was passed, the plaintiff has received compensation and has permitted the defendants to install poles and draw electric lines
Consent letter has already been given.
and has consented for the same. Full stop. The learned counsel for the plaintiff, however, the learned counsel for the plaintiff, though admits that the defendants have drawn the line and have paid compensation, contends that the compensation paid to the plaintiff is far less than the compensation paid to others. Hmm. 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 How many, what is the extent of land used up, we do not know. ಏನಾಯ್ತು? Far lesser than the compensation paid to others. He therefore contends that the interim order granted by the trial court be continued until the defendants redress the grievance of the plaintiff and pay compensation on par with others. Full stop. Next para. Since the defendants do not dispute the fact that since the plaintiff does not dispute the fact that the defendants are permitted to lay the electric poles and draw the lines over the land of the over the land of the plaintiff, the interim injunction granted by the trial court deserves to be modified. Full stop. If the plaintiff has any grievance over the quantum of compensation paid to him, or if he is aggrieved by the quantum of compensation paid to, if he is aggrieved by the fact that higher compensation is paid to others, the plaintiff is bound to work out his remedy in the manner known to law. He certainly cannot obstruct the defendants from laying the poles or drawing the lines, since he has already received the compensation. Full stop. In that way of the matter, this writ petition is allowed. The impugned order passed by the trial court restraining the defendants from laying the electric poles or the lines or drawing the lines is set aside. Liberty is reserved to the plaintiff to work out his remedy in accordance with law.
Much obliged, Lord.
Prakash Jadhav,
I'm seeking 1 week time to comply.
here maintainability, what is the impugned order?
This is an OS judgment, my lord. OS judgment passed by the bulky
So
senior division.
what have you challenged?
That is the OS judgment, my lord.
What have you challenged, madam? Cost the impugned decree and judgment passed in OS number 7.
Yes, my lord.
For them, ಯಾಕೋಬೇಕಲ್ವಾ?
There was a delay, my lord. The order was passed in 1998.
But OS decree, how can you challenge it in a writ petition? Huh? OS decree, how can you challenge it in a writ petition? Prakash Jadhav. What you are saying is, ನೀ ಒಂದು ಸೂಟ್ ಹಾಕಿದ್ರಿ ಅಂತ.
Yes, ma'am.
OS number 7/17 ನಲ್ಲಿ ನೀವೊಂದ್ ಸೂಟ್ ಹಾಕಿದ್ರಿ, ಆ ಸೂಟ್ ಡಿಕ್ರಿ ಆಯ್ತು.
ಅದಾದ್ಮೇಲೆ
ಗವರ್ಮೆಂಟ್
previously
ಸೂಟ್
got-
ಹಾಕಿದ್ರು, ಅದು ಡಿಕ್ರಿ ಆಗಿದೆ ಅಂತ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ. ಅದು ಆರ್ಎ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಲ್ವಾ?
delay.
ಅಷ್ಟೇನಾ? ಬರ್ಕೊಳ್ಳಿ. The petitioner has challenged a judgment and decree passed in OS number 7/1998. Full stop. Office has raised an objection regarding maintainability of this writ petition as an appeal is permitted under section 96 of the Code of Civil Procedure. Full stop. Next para. A perusal of the records, perusal of the writ petition shows that what is questioned in the writ petition is a judgment and decree passed in OS number 7/1998. In view of the remedy of an appeal available to the petitioner, he cannot approach this court in proceedings under Article 226 of the Constitution of India. Hence the office objection regarding maintainability of this writ petition is upheld and the writ petition is dismissed. Office is directed to return the certified copy of the impugned judgment and decree to the learned counsel for the petitioner. The time consumed in pursuing this petition shall be deducted while calculating the time of limitation applicable to an appeal before the appropriate court. Raise Rosa.
I appear. What's the office objection in regard to filing of a certified copy of annexure A, my lords? ಅದು ನಮಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದಾರೆ ಅವರು ಪೇಜ್ 39 ಅಲ್ಲಿ.
Page
39. It's communicated to the petitioner. The office is insisting to file a certified copy. Now apply
Office objection is overruled. Office objection at serial number
19.1. 19.
is overruled. Yes, what is the
Lords,
issue?
the annexure A impugned order is a appealable order, my lords. Now I'm told that, my lords, the appellate tribunal is not constituted. It lords, 2 weeks time may be granted, my lords. In the meantime, if
My lords, in this case, I appeal for the respondents, my lords.
Yes,
My lords, taking into consideration of the GST appellate tribunal not constituting, my lords, so the honorable court was pleased to pass
No,
an
it is
order of stay, my lords. I
constituted.
need to complete these pleadings, my lords. Statement of objections to be filed.
Now, whether the appellate tribunal is constituted or not.
My lords, it is constituted, my lords, but it is not started functioning, my lords.
Then you file your
So pleadings,
objections.
please, my lords,
File your objections then.
please, my lords. Kindly
Is
press
there-
4 weeks time to file statement of
Is there any stay?
interim order is there, my lords.
Interim order granted.
operating. my lords.
Learned counsel for the respondent seeks time to file statement of objections. Hence list after 2 weeks, interim order granted at least extend till the next day.
My lords, 4 weeks, my lords.
Yakre,
My lords, I had to secure the paravise comments, my lords, thereafter statement of objections.
you're all professionally driven
Please, my
departments.
lords.
So therefore you file it within 2 weeks. Everything is on your,
Please, my
Online.
lords, I'll file.
everything is online. Next,
Obliged.
a memo is filed to withdraw the writ petition. In
Much-
view of this memo, the petition is dismissed as withdrawn. Await Ramchandra K. R1. Yeah.
For the
Mr.
respondent,
Mr. Tirumalesh,
my lords, I have not received copy, however,
learned counsel for the respondent submits that he has not received a copy of the petition. The learned counsel for the petitioner is directed to serve a copy of the petition after serving the office of the income tax officer at Navanagar, Hubli.
Yes.
Yes.
Commissioner of Income Tax, Navanagar, Hubli.
Commissioner of Income Tax, Navanagar, Hubli.
And even the prayer says that this repetition is not maintainable at all. Prayer
Anyway,
as per,
first receive the copy. You don't even have the copy, you say prayer.
the online prayer is available.
First receive a copy.
Yes.
Next,
Please.
Muqtadir. Abdul Muqtadir. R1, who is? Huh? Yaar R1 yaar,
R1.
he is not contesting.
Yes, sir, the cop.
No more. You are the LRs. ಬರ್ಕೊಳ್ಳಿದ್ದಾರೆ. The respondents 2 to 6 are the LRs of the defendant respondent number 1. Correct. But whether respondent number 1 is she is the mother of the other respondents. ಏನ್ ಮಾಡಬೇಕಾಯ್ತು? 2 to 6 ಅಥವಾ ಎಲ್ಲರೂ
1 to 6 are the LRs.
respondents 2 to 6 are the LRs of respondent number 1 who has now expired. Full stop. Since the legal representatives of R1 are already on record, the formality of filing an application to bring them on record is dispensed. Counsel for the petitioner is directed to make appropriate entries indicating the death of respondent number 1 and that respondents 2 to 6 are the LRs of R1. In case, ಎಷ್ಟನೇ ಇಸ್ವಿದು? Eviction of tenant. He is a tenant. Yes, Mr.
Delivery, the bailiff, court bailiff reporter was, there was a measurement issue, my lords.
Measurement pretty. Now there's a decree of eviction.
We have filed an objection also, my lordship.
Huh?
We have filed an objection IA number 3 in EP.
Let him argue. Yes,
We have filed an objection IA number 3 in EP, my lordship.
ಇಲ್ಲಿ the page number. Thirty-four.
Page number 34, my lordship.
ಓದಿ.
The petitioner has moved the present application for staying the EP proceeding as per the provision of order 21 rule 29, wherein the suit is pending any court against the holder of degree of such court or a degree which has been executed by such court on the part of the present person against whom decree was passed. The court may on such terms and the as to security or otherwise that it thinks fit stay execution of the degree until the pending suit has been decided in the present case. Intentionally filed without any right over the suit shall be property already decided by Honorable District Court and also Honorable High Court in RA 85/2005 and RSA 7197 of 2009. Therefore, the stay of execution does not arise. The conditions of affidavits are also false, that the suit of decree holder is belong to house bearing Pura Panchayat number 2-9-166 and 2-9-211 situated at Chavani Lingsur with boundary.
ಏನಾಯ್ತು? RSA ಏನಾಯ್ತು?
RSA got dismissed.
There are no proceedings pending. There are no proceedings pending. You have now filed one more suit. Yes, filed, 79 of 2024 in.
The identification of property is not correct, my lordship. The delivery warrant issued by the court.
ಏನ್ ಯಾವಾಗ ಖಾಲಿ ಮಾಡಿ ಕೊಡ್ತೀರಾ?
The boundaries has not been correctly identified, my lordship. Measurement and boundaries.
Have you taken a contention in the suit about the boundaries?
In
Measurement?
present petition we have filed.
ಹಾ. ಏನ್ ಹೇಳ್ತೀರಿ ಹೇಳಿ? ಖಾಲಿ ಮಾಡಿ ಕೊಡ್ತೀರಾ? ಟೈಮ್ ಕೊಡ್ತೀನಿ.
Some time may be granted, my lordship.
ಎಷ್ಟು?
2 weeks time may be granted, my lordship.
ಖಾಲಿ ಮಾಡಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕಲ್ಲ. ಖಾಲಿ ಮಾಡಕ್ಕೆ ಎಷ್ಟು ಟೈಮ್ ಬೇಕು ಹೇಳಿ?
I did not get any directions from my senior, my lordship. That's
Please
why.
ask your senior.
Okay.
Pass over.
Course I take the steps for answer.
R6, you are unclaimed R6.
6, yes.
Whether they are necessary parties.
The R15 is not necessary party, he is the one of the plaintiff, my lord.
R,
15. Vijayalakshmi.
what about R3? Refused.
That is a contesting party.
Barcode. The notice issued to the respondent number 6. He is not claimed. The address of the respondent number 6, as mentioned in the cost title of the writ petition, corresponds with the address mentioned, corresponds with his address mentioned before the trial court. Hence, notice to the respondent number 6 is held sufficient. Office is directed to show his name in the cause list and also indicate that notice to him is held sufficient.
15 dispense.
The notice issued to the respondent number 3 is refused. Hence, notice to the said respondent is held sufficient and office is directed to show his name in the cause list. The respondent number 15 is a formal party to this writ petition and no relief is sought for against the respondent number 15. Hence, notice to respondent number 15 is dispensed. Heltira?
Yes, ma'am.
Ready?
Yes.
Heli.
Petitioner has filed the application before the trial court for amendment of the petition, my lord. We have not mentioned the area, declaration stating that we have mentioned only north-south distance, my lord, 4 feet. We have not
For
mentioned
what? Suit is for, mic
for
use my,
declaration and injunction. Declaration and injunction, my lord.
suit is for declaration injunction.
Yes, ma'am.
What is the application now filed?
Application number.
What is the
Annexure
application?
C, my lord. Annexure C, page number 30.
Annexure C, na?
Yes, ma'am. ಅರ್ಜಿ ಆದೇಶ 6
ಯಾವ ಸ್ಟೇಜ್ ಫೈಲ್ ಮಾಡಿದ್ರಿ ಅಪ್ಲಿಕೇಶನ್?
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಟ್ ದಿಸ್ ಟೈಮ್ ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಏನ್ ಕೇಳಿದಿರಾ?
ಸೊ ವಾದ ಪತ್ರ ಪುಟ ನಂಬರ್ 3 ಪ್ಯಾರಾ ನಂಬರ್ 3 6ನೇ ಸಾಲಿನಲ್ಲಿ ಉತ್ತರ ದಕ್ಷಿಣವಾಗಿ 4 ಫೂಟ್ ನಂತರದಲ್ಲಿ ಪೂರ್ವ ಪಶ್ಚಿಮವಾಗಿ 28 ಫೂಟ್ ಅಂತ ಸೇರ್ಪಡೆ ಮಾಡಿಕೊಳ್ಳಲು ಅನುಮತಿ ನೀಡಬೇಕು ಎಂದು ಪ್ರಾರ್ಥನೆ ಇರುತ್ತದೆ. ವಾದ ಪತ್ರ ಪುಟ ನಂಬರ್ 4ರಲ್ಲಿನ ಪ್ಯಾರಾ ನಂಬರ್ 7ರ ಪ್ಯಾರಾ ನಂಬರ್ 4ನೇ ಸಾಲಿನಲ್ಲಿ ದಕ್ಷಿಣವಾಗಿ 4 ಫೂಟ್ ನಂತರ ಪೂರ್ವ ಪಶ್ಚಿಮವಾಗಿ 28 ಫೂಟ್ ಅಂತ ಸೇರ್ಪಡೆ ಮಾಡಿಕೊಳ್ಳಲು ಅನುಮತಿ ನೀಡಬೇಕೆಂತ ಪ್ರಾರ್ಥನೆ ಮಾಡ. ಬೌಂಡ್ರೀಸ್ ಕರೆಕ್ಟ್ ಮೆನ್ಷನ್ ಆಗಿಲ್ಲ. ಪೂರ್ವ ಪಶ್ಚಿಮ ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇದು ಕೊಟ್ಟಿ ಪೂರ್ವ ಪಶ್ಚಿಮ ಕೊಟ್ಟಿಲ್ಲ, ಉತ್ತರ ದಕ್ಷಿಣ ಅಷ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ.
ವಾದ ಪತ್ರದ ಪುಟ ನಂಬರ್ 3 ಪ್ಯಾರಾ ನಂಬರ್ 3ರ 8ನೇ ಸಾಲಿನಲ್ಲಿ 1, 2, 3, 4, 5, 6, 8. 4. ಉತ್ತರ ದಕ್ಷಿಣ 4 ಫುಟ್ ಮಾಡಿದ್ರೆ ಉದ್ದ ಯಾಕಬೇಕು, ಪೂರ್ವ ಪಶ್ಚಿಮ ಯಾಕಬೇಕು?
ಅಂದ್ರೆ ಈಗ
ಅಲ್ಲ ಮೇಡಮ್,
ಎಸ್ ಮ್ಯಾಮ್,
ಹಾದಿಯ ಹಾಯ್ವಳಿ ರಸ್ತೆಯ ಉತ್ತರ ದಕ್ಷಿಣವಾಗಿ
ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ರಿಗಾರ್ಡಿಂಗ್ ಇದು 4ನೇ ಪ್ರತಿವಾದಿ ಅತಿಕ್ರಮಣ ಮಾಡಿ ಉತ್ತರ ದಕ್ಷಿಣ ಮತ್ತು ಪೂರ್ವ ಪಶ್ಚಿಮ ಇದು ಪ್ರೇಯರ್ ಮೈಲರ್ ಐ ಆಮ್ ಟ್ರೇಡಿಂಗ್ ದಿ ಪ್ರೇಯರ್ ಆಫ್ ದಿ ಪ್ಲೇಂಟ್.
ಹೌದಮ್ಮ, 4 ಅಡಿ ಅಂತಂದ್ಮೇಲೆ
ಈಗ ಪೂರ್ವ ಪಶ್ಚಿಮ ಉತ್ತರ ದಕ್ಷಿಣ ಈ ಸರ
4 ಅಡಿ ಸಾಕಲ್ಲ. ನಿಮ್ದು ಎಷ್ಟಿದ್ಯೋ ಅಷ್ಟಾಗಲ್ಲ, ನಿಮ್ದು ಪ್ರಾಪರ್ಟಿ ಎಷ್ಟಿದ್ಯೋ ಅಷ್ಟಾಗಲ್ಲ. ನಿಮ್ದು ಇರೋದು ಎಷ್ಟು ನೋಡಿ, ಪೂರ್ವ ಪಶ್ಚಿಮ
26 ಪೇಜ್ ನಂಬರ್ 26 ಮೇಲೆ ಪಕ್ಕದಲ್ಲೇ ಇರೋ ರೋಡ್ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ನಮ್ಮ ಮನೆ ಪಕ್ಕದಲ್ಲೇ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ ಅದಕ್ಕೆ.
Will you undertake that you will not lead any evidence?
No, sir. We are not leaving any evidence.
ಬರ್ಕೊಳ್ಳಿ. The plaintiff in voice number ಎಷ್ಟು ಕಾಸ್ಟ್ ಎಷ್ಟು ಕೊಡ್ತೀರಾ? ಕಾಸ್ಟ್ the plaintiff ಎಷ್ಟನೇ ಇಶ್ಯೂ ಸೂಟ್ ಇದು?
2011 ಮೇಡಮ್.
2011 ಸೂಟ್.
ಎಸ್ ಮೇಡಮ್, 2011.
ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಗೆ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಿರಿ. ಕಾಸ್ಟ್ ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಹೇಳಿ? The plaintiff in voice number so and so. Plaintiffs
Plaintiff died, madam. They are the LRs of the
Sorry, the
plaintiff.
LRs of the deceased plaintiff in OS number 523 of 2011 on the file of so-and-so. I have filed this petition challenging the correctness of an order dated so-and-so by which an application filed with them and order 6 rule 17 of CPC was rejected. Next para. The suit in OS number 523 of 2011 was filed for declaration of title and for perpetual injunction
Yes, madam.
and for recovery of and for mandatory injunction to direct the defendants to remove the
Construction.
construction put up by them by encroaching into the suit property. Full stop. The suit was contested by the defendants 146 who denied the claim of the plaintiffs, who inter-alia denied the claim of the plaintiffs and also denied that the plaintiffs were entitled to the relief sought for. Based on these contentions, the suit was set down for trial. Based on these contentions, the trial court framed issues and set down the case for trial. After the evidence was adduced and the case was set down for arguments, and at the stage of reply arguments of the defendants, an application was filed by the deceased plaintiff, by the LRs of the deceased plaintiff to amend the plaint to incorporate the area of area encroached by the defendants. Full stop. The said application was contested by the defendants and the trial court in terms of the impugned order rejected the said application primarily on the ground that the application was belated and filed at the stage when the suit was set down for defendant arguments. Being agreed with the same, the plaintiff has filed this petition. Next para. The learned counsel for the plaintiff contends that the plaintiff had mentioned that the defendant had encroached into the suit property that measured east to west, measured north to south 4 feet. And therefore, the extent of land measuring east to west had to be mentioned. He submits that the plaintiff therefore sought for an amendment which was very innocuous, but was relevant for the purpose of deciding the dispute between the parties. He contends that this defect would not be noticed until the case was set on for arguments. Full stop. The respondents, though served with the notice of the petition, have not appeared, and therefore this court does not have the benefit of their submissions. Next para. The trial court has noticed that a commissioner was appointed by it to identify the property claimed by the plaintiff, LRs of the plaintiff and the defendants, and that the court commissioner had submitted a report which was treated as part of the record of the trial court. Full stop. The trial court noticed that when the suit was set down for the arguments of the defendant, the instant application is filed. Therefore, the application was not bona fide. Full stop. Besides this, it also held that the amendment sought for was not necessary for the effective adjudication of the suit. Full stop. Next para. It appears that the plaintiff, the LRs of the plaintiff intend to clarify that the area encroached into by the defendant measured east, north to south 4 feet and east to west 28 feet,
Yes, ma'am.
28 feet. Full stop. This was definitely an innocuous amendment sought for by the plaintiff. And therefore, the trial court ought to have allowed this application as in the contemplation of the plaintiff, ought to have allowed this application so as to liquidate any grounds that the plaintiff may urge in any appeal that may be filed by him before the higher court. Be that as it may, since the learned counsel for the plaintiff submits that she would not, that the plaintiff would not, that the LRs of the plaintiff would not lead any further evidence on the amendment sought for,
Yes.
this writ petition could be disposed of by permitting the plaintiff to amend the, plaint as sought for in the application for amendment. Subject, however, to payment of cost and also to the condition, and also subject to the condition that the plaintiff shall not lead any evidence. Full stop. In view of the above, the writ petition is allowed. The impugned order passed by the trial court is set aside. The application filed by the plaintiff and Order 6 Rule 17 of CPC is allowed. And the LRs of plaintiff are permitted to amend the plaint subject to payment of cost of rupees 10,000 payable to the defendants before the trial court on the next date of hearing. Full stop. The plaintiff shall not lead any evidence and the trial court shall not frame any issue and frame any additional issue, but shall proceed to dispose of the suit in accordance with law. Full stop. Having regard to the fact that the suit is filed in the year 2011, the trial court is requested to consider and dispose of the suit as early as possible at any rate as provided under the Karnataka case flow in subordinate court rules 2005. R.S. Siddhapurkar.
Back to appear. Plaintiff's writ petition, suit for declaration and injunction in respect of an open plot, bearing number 57 in survey number 20/2. The defendants have no concern, they try to interfere. Therefore, I filed a suit for declaration injunction. Defendants come and set up a plea that they have purchased the plot number 33 in the same layout by some other person. The trial court, considering my sale deed and also the khata extract, etc., granted me injunction order. The first appellate court, my lord, has reversed it on the ground that there is a dispute of identity of the property between these two, because I am claiming ownership in plot number 57. They are claiming in 33. That order of the first appellate court, my lord, I have challenged.
So you are claiming 57.
57. They are claiming 33. They also have got the sale deed. My sale deed is in 2013. Their sale deed is in 2022.
Notice order ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಆಗ್ಬೇಕು.
ಬರ್ಕೊಳ್ಳಿ issue notice.
Emergent notice.
Issue emergent notice.
I may be permitted to serve a
In
copy.
addition, the learned counsel for the petitioner is directed to serve the learned counsel who represented the respondents before the trial court.
Please.
Parties are directed to maintain status quo in respect of the suit property. Neither the petitioner nor the respondents are permitted to change the nature of the suit property or encumber or induct any third party in possession of the suit property till the next date of hearing. List on date.
Public.
This case, I pray for a week's time, Lord, and along with that, I am permitted to serve the copy of the writ petition on the counsel appearing for the decree order before the.
Time is granted to do the needful. In addition, learned counsel for the petitioner is directed to serve. The learned counsel represented the respondent number 2 before the trial court.
Interim order may kindly be extended.
Interim order granted a delays extent to the.
Please.
Subhash Mallapur.
In the previous matter, my lord, there is some office objection. I have not produced the copy of the appeal memo, MA.
Office
is not
objections
necessary.
are overruled.
Public.
Serial number. Office objection over. Yes. List after service of notice to respondents 1 to 6.
Copy has been served on the council.
Who is the counsel?
He has appeared. Mr. R.N. Rao is, R.H. Rao is the council.
Kalaburagi law.
ಹಾ.
ಬರ್ತಾರ ಇಲ್ಲ ಹೈಕೋರ್ಟ್ಗೆ?
ಬರ್ತಾರೆ ಸರ್.
ಹಾ?
ಬರ್ತಾರೆ.
ಇಲ್ಲ ಬರಂಗಿದ್ರೆ ಅವ್ರ ಹೆಸರು ತೋರ್ಸೋಣ. If he appears before the High Court,
he is not a regular feature here, but he does come.
Then we'll show his name in the cause list.
Yes, R.H. Rao ಅಂತಿದೆ.
Full ಹೆಸರೇನು? What is his full name?
R.H. Rao.
R. Hanumantarava? Huh?
Hanumesh Rao. I'm sorry.
Office is directed, the learned counsel for the
Hanumesh.
petitioner submits that copy of the writ petition is served on Mr. R. Hanumesh Rao, who is the counsel who represents the respondents before the trial court. Hence, office is directed to print his name in the cause list. List on yavat ಬೇಕು?
Interim order, because tomorrow the matter is listed.
ಅವ್ರು
Last time
ಸರ್ವ
your lordship
ಬರ್ದೇ
heard
ಹೊರ್ತಾ without hearing I can't.
ಅಲ್ಲ, last time your lordship heard this matter.
ಆಯ್ತು, list it tomorrow.
Serve ಮಾಡ್ಬರ್ರಿ ಅಂತ.
List it tomorrow.
List it.
I direct the lawyers to serve it so that service of notice becomes
easier.
easy. ಅಷ್ಟೇ. Don't think that just because I say that the notice is to be held sufficient. Sorry. Only to ensure that the parties appear before the court, ಅದರ ಮಾಡೋದು. And the High Court rules permit that.
Tomorrow.
List tomorrow. And don't, ಈ ತರ ಎಲ್ಲ statements ಮಾಡಬೇಡಿ. You have told us to serve it, we have served it.
Submission was
I
that. Last time
direct
your
you to
lordship
serve
heard
it so that service becomes easy.
Last time your lordship heard the matter, told let the parties be informed, keep them informed.
Correct, sir. ನಾನು ಹೇಳ್ತಿಲ್ವಾ?
In
I
fact,
direct you to serve the lawyer so that service becomes easy. ಅಷ್ಟೇ.
ಈಗ ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂತ ಅದಕ್ಕೆ.
So therefore, you don't get a right to get an interim order just because you have served and they have not appeared before the court. So don't make ನನ್ನ ಮೇಲೆ ತಪ್ಪು ಹೊರಿಸ್ಬೇಡಿ. Don't make me feel guilty of a.
Lordship should not mistake me. I am not trying to blame the court. I am just trying to.
He's
I
already
am
served.
just trying to recreate the scene on the last issue.
Right, he's already served ಅಂದ್ರೆ ಏನು? He is not appeared before the court.
Okay, tomorrow.
ಅಲ್ಲ, ನೀವೇನೋ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡುವಾಗ ಸ್ವಲ್ಪ ನೀವೆಲ್ಲ ಸೀನಿಯರ್ಸು ಯೋಚನೆ ಮಾಡ್ಕೊಂಡು ಹೇಳಿ ನೀವು. Yes, IA 1/24 is filed for condemnation of delay of 240 days in filing the application to recall the order dated zones. The cost shown for the delay is perused. Cost shown for the delay is perused. And the same is accepted. This IA 1/24 is allowed. Next, IA 2/24 is filed to recall the order date 16/2/2024. The cost shown for not appearing before the court on the, and not a complaint, non-compliance of office objection. The cost shown for not being present on the, before the court on the said date is condoned subject to payment of cost of ₹500 payable to the Advocates Association, Kalaburagi Unit, Bangalore, Gulbarga, Kalaburagi.
My lord, the matter pertains to LR applications filed, my lord. The same is dismissed by the court below.
Yeah, the Praveen Kumar High Court is.
Please.
We have restored the petition. You please pay the cost.
Please, I'll do it.
Vinayak Apte.
Matter was listed before the judicial registrar, my lord, second time for carrying out office objections.
Barkoli, IA 1/23 is filed to recall the order dated 16/2/23. The cause shown for not complying the office objections is perused and is accepted. Hence, IA 1/23 is allowed and the order dated 16/2/23 is recalled. 10 days time is granted to comply the office objections, failing which the petition shall again stand dismissed
Obliged.
without reference to bench.
Obliged.
Chavishetty,
Hearing for the petitioner.
Ah.
The petitioner filed this application seeking direction to the respondent university to declare the result of the students appeared for the examination matters. Your hardship may kindly see matters by interim order of this honorable court matters dated 14/3/2023. This honorable court directed the university to permit the petitioner college to admit the students for the academic year 2022-23 maths. Accordingly, I admitted the 100 students, 100 intake, as earlier directed by the university. Your hardship may kindly see maths. The respondent university directed me to deposit a sum of rupees 17 lakhs to 20,000 maths towards the eligibility fees for having admitted the students maths.
yes.
I have paid the said sum. I have paragraph 4 of my application maths. Total 17 lakhs 20,000 I have paid. Annexures G2, G3, G4, G5 to G11 maths. Total amount of rupees 17 lakhs 20,000. Thereafter, the respondent university permitted the students to appear for the first to fourth semester examination maths of B.Ed course. And they have accepted the examination fees. We appeared for the examination in the year 2000.
Really? Who is the answering respondent? Gulbarga University, Sudarshan? M. Sudarshan? Pasor? Kumar Kallu? Ambekar?
I'm told your lordship heard this matter on the last occasion.
I don't remember.
This is regarding the amendment of the return statement which I had filed, that is rejected by the trial court. I am before this court.
What is the suit for?
Suit is for my lord ejectment.
Ejectment.
Yes, my lord, tenant. Saying that I am the tenant of the property. Now the question is, my lord, this is a running institution, my lord, wherein the nursing schools and other schools are there. They gave it on the lease for about 30 years, my lord. That period came to be expired. Thereafter, we tried for negotiation for renewal of the said lease. My lord, they refused it, my lord. What happened? They immediately filed this ejection petition. Now, my lord, about 1 month back, my lord, we held a negotiations. They arrived for a settlement for 10.5 crores. We agreed for it at Bangalore itself. And when they came back to Raichur, these persons, my lord, they started negotiating with third parties. That is why I had to make an application for temporary injunction before this court. This court passed an order granting temporary injunction not to alienate the property. Now the question is, my lord, he is not a trustee. Original trustee was one Mallappa Kollur. My lord, thereafter he created a trust in the year 2002. Once again, another trust was created, wherein the name of this person does not find place in the said trust. In spite of this, my lord, he files a suit. I have explained in my application for amendment at page number 55. How they, my lord, page. Annexure C, my lord, that is my amendment application. Giving all the particulars how they are going to play the fraud.
No.
And we have given the particulars about the registered trust deeds. This is nothing but a clarificatory, my lord, amendment, which I wanted to bring it to the notice of the trial.
No, but you are only a tenant.
Yes, my lord.
So therefore,
The question is, if this person is not utterly managing trustee, as per the deed, the suit itself will not be maintainable.
yes.
So that is why, my lord, what I'm requesting this, your lordship knows, my lord, Supreme Court judgments about amendment of written statement, even if I take inconsistent statements in the pleadings, my lord, that can be allowed. There are 2 or 3 judgments.
Yes. No, but amendment should be necessary.
Yes, my lord, that is necessary
take
because I want to
inconsistent-
bring to the fact to the notice of the trial court about by making such an amendment.
Yes. Please point out how this amendment is necessary.
Yes, my lord.
What is this? Where is the plaint?
My lord, plaint is at page number. Just a minute. Page number 11, annexure A.
Founder is Kolluru Mallappa.
Yes, my lord.
Sole trustee. Said Kolluru Mallappa is new trustees.
In my written statement at page number 29, annexure B,
Hmm.
I have stated about this registered, the trust deeds.
What is mentioned in the written statement? Please.
My lord, they kindly come to paragraph 8 of my written statement.
Yes. Hello. First read your para 2 of your written statement.
Written statement. Yes, my lord. Head office so and so, it is denied, Kallur created a trust and he sold the trustee and trust dated so and so, it is false. The state Kallur Mallappa appointed new trustee to the trust dated 23/6/2003. And accordingly, the above C. Prabhakar is appointed as my lord, managing trustee of the plaintiff. My lord, this may I request your lordship to just skip off this, my lord, and come to paragraph 8, my lord. Appointment of the new trustee of the Janta on retirement of sole trustee in exercise of the power of this deed was created on 27/2/2002, retiring Mallappa and admitting 9 new trustees. They are under so name, my lord. Name has been mentioned. In this, my lord, the name of this person, Prabhakar, does not is not reflected. My lord, kindly come to the next. This deed of, my lord, all the resident of Anandra Circle, this deed is registered on 27/2/2002, registered in sub-register office, Bangalore. This deed is retirement of sole trustee Kallur Mallappa and appointing 9 trustees. In this deed, the new managing trustee is one Kariyappa, a son of Chanbasappa. When this is so, how the plaintiff could designate himself as a managing trustee in question to be proved by the plaintiff. Indeed, the mentioning of the name of C. Prabhakar in this said trust deed. When he is not a trustee, he is not acting as a managing trustee. Therefore, all the pleadings are false. This fact has been not pleaded by the plaintiff, which are necessary pleadings to determine the questions in controversy. All these facts are suppressed by the plaintiff to have wrongful gain. The suit is filed to take hostile decree from this court, which is not permissible under the law. Therefore, suit is liable to be dismissed. It is further brought to the notice after the deed 27 to one more document, that is 3/6/2000 was registered by retiring original sole trustee and appointing 5 new trustees is made by Mallappa Kollur, who is already retired, and from the deed dated 27/2/2002 and from the trust by appointing 9 new more trustees as to in this deed 2000, there is no mention of removal of the 9 trustees and appointing 5 new trustees. When once the original sole trustee created appointment of 9 trustees by retiring himself from the trust, he has no occasion for him to once again retire and appoint new trustees. Therefore, there is a fraud fled on all the trustees named therein, and the same is against the trust. So this fact, my lord, I want to elaborate in my amended,
The same
plate.
thing again and again.
That can be, my lord,
That can be allowed. Please point out what is something new which is not mentioned in the earlier written statement.
yes, my lord.
ಅದನ್ನೇ ತಿರುಗಿ ಪುನರಾವರ್ತನೆ ಮಾಡಿದಿರಿ ಅಷ್ಟೇ. What is there anything new that you have mentioned in the amended?
Just a minute, huh? My lord, may I request your lordship kindly come to page number 39, that is annexure C.
Both.
The suit is filed by the present plaintiff is not maintainable as they have no locus standi to file the suits or create the lease deed for the properties of the trust. After the death of C. Prabhakar, who filed the present suit, is died during the pendency of the suit, and the suit being continued by Rupesh by reconstituted the trust deed dated 1/7/2021 is also void, and having no recognition under law is void document. The present plaintiff Rupesh has designated himself as a managing trustee, filed his chief examination affidavit, as he is being appointed as a managing trustee, is also opposed to law. The plaintiff under the impression that the trust is a private trust of the family, and they can act and they deems fit is totally wrong concept. On going through the wrong original trust deed, the trust is created for the public purpose, and it is all income will go to the trust, not to the trustees. The original trust deed is read over, it is the public interest, and the beneficiary are the general public. The act of the plaintiff is questionable in law. Till today, they did not kept any accounts, or the trust is audited by the auditor. Further, the act of the plaintiff in filing the suit is tainted with malafide and fraudulent and full of illegality, is liable to be determined by this court. The suit is to be dismissed, and the plaintiff ought to have no right to file the suit. Further, the continuation of the suit by reconstituted the trust after the death of Prabhakar dated 1/7/2021 in the office of the sub-registrar Malleshwaram is also void document having no force, and the Rupesh P, who has filed this chief examination affidavit, is also not having any right under law to continue the suit. So what I'm submitting is, they produced once again 2001 trust deeds. 2002 and 2003, the name does not reflect. So they could not relied upon this old document, my lord, which is 2021, and he could not have continued, my lord. That is what I wanted to bring to the notice of the trial court by way of amendment of the written statement. So you know the hardship would be caused to him, my lord, if such an amendment is allowed. I'm not going to make any more, my lord. It is only an extension of, my lord.
The defendants in OS number
There are two judgments, my lord.
287 of, please pass on the judge.
Yes.
287 of 2015
Court of.
on the file of so and so or before this court, challenging an order dated so and so by which an application filed by them under order 6/17 of CPC was rejected. Next para. Issues in a frame ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಕೊಡಿ, ಇದೆಯಾ ಕಾಪಿ?
Issues ಇದೆ produced.
Produce ಮಾಡಿದ್ದಾರೆ.
Issues ಇದೆ page number.
In fact, they, my lord, entirely, my lord, they agreed for compromise.
There is nothing on record, my lords.
The advocate, my lord, everything has been recorded. Copy.
The suit in OS number, suit in OS number 287 of 2015 was filed for ejectment of the defendants from the suit share property and for mean profits at the rate of rupees 25,000 per month. The suit was based on the contention that the plaintiff is a trust registered in accordance with law, and that it was the owner of certain property in survey number 20, 22, and 36 of Rampur village, Raichur Taluk. The defendant number one is also a trust duly registered. And was constituted to defendant number one is also a trust duly registered with with its aims and objectives for imparting education. Full stop. The plaintiff claimed that since the objects of the plaintiff and the defendant number one were similar, comma, it allowed the defendant number one in the suit property as a tenant in terms of a lease deed dated 8/11/2011. Full stop. The lease expired on 30th of September 2014, and no steps were taken for renewal of the lease. It was alleged that the defendants were irregular in the payment of monthly rents, and several checks issued by them were dishonored. The plaintiff therefore terminated the tenancy and called upon the defendants to quit and deliver vacant possession. And on they failing to comply with the notice demand, the instant suit was filed for ejectment and for recovery of main profits. Next para. The suit was contested by the defendants who denied the constitution of the plaintiff as a trust. They also denied that the founder trustee had created the trust in terms of a deed dated 16/8/1993. They also claimed that the lease was created not in accordance with law. And they contended that a civil suit was pending. Civil suit was filed by the other trustees in OS number 192 of 2006 against the managing trustee, against the person who claimed to be the managing trustee of the plaintiff in OS number 192 of 2006. It is alleged that the lease in favor of the defendant number one was executed without the consent of the other trustees and against interest of the trust. It is also claimed that the person who claimed to be the managing trustee of the plaintiff trust had misused the rent and alleged that he had no independent right over the trust property. They also denied that a miscellaneous petition was filed that a case was filed in miscellaneous petition 89/2005 before the court in Bangalore for removal of Mr. C. Prabhakar. Thus it was contended that the managing trustee, Mr. C. Prabhakar, had usurped the office of the managing trustee and was a self-styled managing trustee.
The present managing trustee is Rupesh, who is the son of C. Prabhakar.
Statement ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು ಅದನ್ನ ಬರಿತಾ ಇದೆ.
ಅಲ್ಲಲ್ಲ ಇದು ಹೇಳ್ತಾರೆ ಯಾಕಂದ್ರೆ this person died.
Subsequent. Whatever you have mentioned in the
Yes,
statement, I am recording.
These are subsequent developments, so that's why.
They also contended that the trust was created by one Mr. Mallappa Lingappa Kallur, And it was thereafter amended by a supplementary deed on 4/6/1979. Full stop. Thereafter, Mr. Mallappa Kallur retired and 9 more trustees were admitted, which was evidenced by a trustee dated 27/2/2002. Therefore, it was contended that the said Mallappa Kallur would not have executed another trustee reconstitution deed on 3/6/2003. By which 5 new trustees were added, including Mr. C. Prabhakar. The defendants admitted the tenancy, but contended that the lease was created in violation of Section 5 of the Karnataka Land Reforms Act. And that it is only the only the land tribunal constituted under the provisions of the Karnataka Land Reforms Act that alone has the jurisdiction to try the dispute and not the civil court. It also contended that it was a tenant under the plaintiff in terms of a lease deed dated 7/10/2005 for a period of 3 years. And after the lapse of the said period, it requested Mr. C. Prabhakar to extend the lease period, and that the said Mr. C. Prabhakar extended the lease period for 30 years from 30/9/2008 to 1/10/2011. However, he thereafter changed his mind and registered it for only 3 years. With these and other contentions, the defendants denied the claim of the plaintiff. Next, issues idya? Based on these contentions, the trial court framed issues and set down the case for trial. Evidence shuru agidya?
Evidence ಆಗಿದೆ.
Long after the evidence of the parties was adduced.
No, only PW1 was examined.
After PW1 was examined.
Chief examination ಆಗಿದೆ.
After
Further cross examination of PW1.
After PW1 was examined, and when the suit was set down for further cross-examination, an application was filed by the defendants under Order 6, Rule 17 to incorporate the following on page number 37, 38, 39, and 40. This application was opposed by the plaintiff, who contended that the amendment sought for was wholly unnecessary for adjudication of the dispute, and that it was designed to protract the proceedings. Full stop. The trial court, in terms of the impugned order, held that the suit is filed in the year 2015, and that the defendants did not show any good reason as to what prevented them from filing the application for amendment before the issues were framed. It also held that the defendants were bound to establish that despite exercise of due diligence, they could not seek the amendment at the earliest point in time. Full stop. The trial court thus rejected the application in terms of the impugned order. Being agreed by the said order, the defendants are before this court in this writ petition. Next para. The learned counsel for the defendants contended that the plaintiffs intend to bring on record the falsity of a trust deed, the falsity of a reconstituted deed set up by the son of Mr. Prabhakar, named Mr.
Rupesh.
P. Rupesh,
Son of yes.
who purportedly was inducted as a trustee in terms of a reconstituted deed dated 1/7/2021. Now, submits that the execution of the reconstituted deed was a subsequent fact which was not within the notice and knowledge of the defendants, and therefore the trial court must have permitted the defendants to plead this fact. Stop. Per contra, the learned counsel for the plaintiff contended that the defendants have not disputed that they were inducted into the suit property in terms of a lease deed duly registered. He contends that the defendants have also not disputed the fact that Mr. C. Prabhakar, who was the earlier managing trustee, had executed a lease deed in their favor.
In capacity as managing trustee.
As managing
trustee.
Full stop. He therefore contends that whatever is sought to be pleaded by way of an amendment is already there on the written state, is already there in the written statement filed by the defendants. He submits that the subsequent reconstitution after the death of Mr. C. Prabhakar and the induction of his son, Mr. P. Rupesh, does not alter the nature, does not alter the deed and shall not affect and cannot affect the suit filed. Full stop. Therefore, he contends that the amendment sought for is not necessary for the purpose of adjudication of the suit. Besides this, he contends that a large portion of the amendment sought for is a repetition of the pleadings already on record, and the defendants have filed the application only to protract the proceedings and keep the litigation alive. Full stop. He submits that in view of the proviso to Order 6 Rule 17 of CPC, no amendment can be allowed if after issues are framed, unless the defendants and unless the party seeking amendment is able to establish that despite exercise of due diligence, he or she could not seek for the amendment at the earliest point in time. Full stop. Next, I have considered submissions made by the learned counsel for the plaintiff and the learned counsel for the defendants. Next para. The suit is filed for ejectment on the premise that the property belongs to the plaintiff trust and that it inducted the defendants as a tenant in terms of a lease deed duly registered. The defendant did not dispute the fact that the suit property belonged to the trust and also that it was inducted as a tenant under the trustee duly registered. The defendants have taken a mutually destructive plea in their written statement. While on the one hand, they contended that Mr. C. Prabhakar was a stranger to the trust and that he was not inducted as a trustee, but on the other have claimed that the said Mr. C. Prabhakar had executed a lease deed in favor of the defendants. Full stop. Now, by virtue of an application filed by the defendants under Order 6 Rule 17, the defendants seem to reiterate whatever that was already stated in the written statement. Full stop. They only new statement that is sought to be incorporated in the written statement is regarding the falsity of the reconstituted trust deed dated 1/7/2021, in terms of which the son of Mr. C. Prabhakar was inducted as a trustee who was conducting the litigation on behalf of the trust. Full stop. As stated above, the application filed for amendment of the written statement is replete with the facts which are already stated in the written statement, and therefore were not really necessary for the purpose of considering the suit on merits. Full stop. As regards the request of the defendants to permit them to plead about the falsity of the reconstituted deed dated 1/7/2021, that too may not arise for consideration, since the defendants had admitted that Mr. Prabhakar C. had executed a lease deed in favor of the defendants, which thereby meant that Mr. Prabhakar C. was also a member of the trust deed, also a trustee under the reconstituted deed. And upon his demise, his son has been inducted as a trustee. Also, the trial court has carefully considered the pleadings on record and has rightly held that the application is designed to protract the proceedings and keep the litigation alive. Full stop. The trial court was therefore justified in holding that the amendment sought for was not bona fide and cannot be allowed, as it fell foul of the proviso to Order 6 Rule 17 of CPC. Full stop. Next paragraph. The reliance placed by the learned counsel for the petitioner in the case of Ram Niranjan Kajaria, year 2016, All India AR Civil 30, and Suresh Kumar Jain and others versus Javeri Lal Mandot and another. And the judgment of this court in Suresh Kumar Jain and others versus so and so, HCR 2015 Karnataka 245 are clearly distinguishable on facts. In the judgment relied upon by the petitioner in Ram Niranjan Kajaria, in judgment in Kajaria, the apex court was considering a set of facts where one of the defendants had sought to place on record a relevant and crucial fact regarding the independent establishment of business which was recorded before an arbitrator, independent business, as well as the relinquishment executed, which fact was recorded before the arbitrator. Full stop. In that circumstance, comma, the full bench of the Honorable Apex Court held that the application for amendment ought to have been allowed, as the same was relevant for the purpose of deciding the dispute between the parties. Full stop. Insofar as the judgment of a coordinate bench of this court in Suresh Kumar Jain and others, comma, this court held that the defendant is entitled to raise alternate or even inconsistent pleas, which in the instant case is not the situation. Therefore, both the judgments relied upon by the learned counsel for the petitioner, learned counsel for the defendants, is not applicable to the fact situation in this case, and hence the petition lacks merit and is dismissed.
It is,
Suit may be directed to
may I
expedite.
request your lordship one thing.
10-year-old ejectment suit.
Since the suit is filed in the year 2015,
15.
the trial court is requested to dispose of the suit as early as possible and in accordance with the Karnataka case flow in subordinate court rules 2005.
Yes. My lord, one submission.
After the Allahabad judgment, we can't issue directions.
One submission, my lord. Under section 105 of the CPC, I may be permitted to raise these objections.
It is always,
My lord, is that
however, it is always open for the, liberty is reserved to the defendants to raise this as a ground in an appeal that may be filed against any judgment that may be passed in the suit.
Yes.
Yeah, ನಾವು ಹೇಳಿದ್ರು ನಿಮ್ಗೆ CPC-ನೇ ಕೊಡುತ್ತೆ right. Even if you don't say, CPC gives you. Ravindra Reddy. Ambekar.
Please.
Objections ಹಾಕಿದ್ದೀರಾ?
On the last occasion, my lord, it
Hakidaರೆ.
was urgent
This is
today.
only in regard to, Lord, the age, enhanced age of for retirement. Lord, the UGC regulations will not provide 65 years of retirement age, and now it has been enhanced to 70 years. And as well as, Lord, NMCI, that is.
There are several matters pending before.
Yes, larger bench.
That may
Larger
not be
bench.
applicable. It's a deemed university. The respondent herein is a deemed university.
In the case of deemed university, Lord, that itself, the matter which was single judge had passed order in this honorable court, Lord. In one of the case, Lord, in the case of Bharati Sai Kumar and.
University, how does the
Ah,
situation change?
deemed university, my lords, and we don't take any amount from the UGC.
Like,
And
you
in
may not
fact,
take, but UGC regulations are applicable to you also.
UGC also says that retirement age is 70th Madilla. It says maximum 70th you can permit. Discretion is left to the respective universities. In fact, other medical institutions all over Karnataka, some have adopted KCSR at that point of time. Retirement age is 58. Some have adopted the amended KCSR and their retirement age is 60 years. We have said 60 years.
No,
It is-
but the MCA has issued guidelines or UGC has issued guidelines.
We are not this thing, my lord, concerned with, we are only concerned with MCA guidelines, which gives discretion to the university, but it says that above 75, you can't take any person. So we have fixed 60 years.
ಅಲ್ಲ, ಎಲ್ಲ ಕಡೆ 65 ಮಾಡಿದಾರಲ್ಲ.
Pardon, my lord?
In all universities, the retirement age is enhanced to 65.
No, my lord, that is the maximum prescribed.
Correct.
Above that, we can't this thing, but below that, we can fix.
ಇವರೇ ಮಾಡಿದ್ದಾರೆ. They have issued appointment order, subsequent appointment orders. Not I have able to get one appointment order wherein specifically mentioned age of retirement is 65 years.
ಇದೆಯಾ?
Now they cannot say that.
ಯಾರು?
They themselves mentioned 65 years.
19.
Lord, and moreover, Lord, in regard to UGC regulations and NMC regulations, Lord, they are binding upon them because the bylaws
Will
itself.
get instructions.
I'll take it.
Learn counsel for the respondent number 4 to 6 seeks instructions.
Short date, my lord.
Regarding the age of retirement of teaching staff.
Teaching staff in the deemed
The
university.
respondent number
4 to 6.
4 to 6. Yes.
Yes.
Interim order is-
Kumar, interim order granted release extension.
Short, 8 months, next week.
How ಬೇಕಾದ್ರೂ ತಗೊಳ್ಳಿ,
Next
whichever
week.
date.
Please,
The subject, Lord,
Please.
petitionally order ಆಗಿದೆ.
29.
Yeah?
29.
Someone court passed order, not those orders were challenged in writ appeal. It has been referred to the larger bench on the same issue,
We
very
list
same
it
issue.
on 31st, ಅವತ್ತೇನ್ ಬೇಕೋ ಹೇಳಿ ಅವ್ರು.
Please.
30 whatever. ಸಂದೀಪ್ ಕುಮಾರ್ ಅರ್ಜನ್ ಆಗಿದ್ಯಾ? ಸಂದೀಪ್ ಕುಮಾರ್ ಏನೋ ಊರಲ್ಲಿಲ್ಲ ಅಂದ್ರಲ್ಲ. ಸಂದೀಪ್ ಕುಮಾರ್. MDP Vijay Kumar. There is no representation for the petitioner.
Lordship, serial number 33.
33.
Yes, appearing on behalf of Sandeep Patil, your lordship.
Ah,
Kindly a week's adjournment.
The request is made for an adjournment. The request is made by the learned counsel for an adjournment. List on. Is Ravindra Reddy.
Obliged.
Regard to, Lord, GST demand, my lord, made. Petitioner is the government institution, Lord, the university, wherein, Lord, section 7 of the GST Act, wherein there is a exemption. Government institutions cannot be made liable to.
Yes, Mr. Yes, government.
Girish Hulimani is appearing for these matters.
Of the learned counsel for Mr. Girish Hulimani.
Hulimani.
Hulimani is directed to accept notice for the respondents. Counsel for the petitioner is directed to serve a copy of the writ petition along with all enclosures to Mr. Girish Hulimani.
Take
Date
notice
may be fixed,
R5.
Lord, covered by judgment.
R5.
Neva, AGA is directed to accept notice for R5. Nevidira.
Lord,
Yes.
date may be fixed, Lord.
List on whichever date. ನೀವು ಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಕಲ್ಲ.
Yes.
35. Gang Shetty Patil. Yeah.
The brief facts of the case is that
Mike Munde.
earlier, the respondent number 1 was filed the suit against the present appellants, petitioners. And after filing the suit, the subject matter of the suit is that, my lord, suit for purpose injunction restraining the defendant from interfering or obstruction without position. As the present petitioners is in actual physical position since several years. After filing the suit, my lord, the respondent number 1 migrated to Hyderabad and he shifted to Hyderabad. And in the COVID period, he was dead. And after the knowledge, the petitioner reported to the honorable court. But unfortunately, after reporting the death of the respondent number 1, the respondent number 2 filed an application for impleading as defendant number 2, by plaintiff number 2. And thereafter, the said application was not allowed, and thereafter he was filed one more application, Order 23, Rule 1, for withdrawal of the suit. But actual, who is the original plaintiff is not appeared before the trial court. And he stated that he is alive. Then you have to produce the respondent number 1. This question is asked by the honorable court, Your Honor, my lord. And lastly, the impleading application and order withdrawal application, both applications were allowed. Thereafter, the present petitioner approved this under court seeking the writ And in the writ, Your Honor, my lord, the stayed application of the present petitioner was allowed in writ petition number 21116 of 2023, dated 21st June 2023. But thereafter, the matter was returned to the Honorable Trial Court, and the Honorable Trial Court was not considered the direction issued by this Honorable Court. And thereafter, the respondent number 2 filed a memo for withdrawal of the suit and seeking permission to file a fresh suit. And that application, that memo was allowed by the Honorable Trial Court. Thereafter, the present writ petition is filed, my lord, and at this juncture, my prayer is that to issue notice to the respondents 1 and 2, and further proceedings will continue.
Take out notice, sister. Show emergent notice to the respondents. No, but if this plaintiff number 1 is dead,
Plaintiff number 1 is dead. I intimated, and after a detailed inquiry, I submitted a affidavit before the trial court. Because death certificate was not available, and the respondent number 2 was directed by the trial court to produce the respondent number 1. But he failed. And lastly, he filed a memo for withdrawal
notice
with the permission to file a fresh suit. That also allowed. That order is under consideration by the Honorable Court.
I don't know how we will serve. Please take out notice, issue emergent notice.
Yes.
Sanjay Kumar Patil.
This writ petition is by the defendant number 2 and 3, wherein Lord plaintiff is the wife of the defendant number 1 has filed a suit for bare injunction, claiming that my lord, one of the property is standing in her name, and sought injunction against her husband, and also my lord brother of defendant number 2 and 3 are the brother of defendant number 1. Lord, we taken a contention that this is an ancestral property of our father Somappa, and we are all, no partition has taken place, and we are in the joint possession of the property. But however, trial court, my lord, and appellate court holds that since the record of rights stands in the name of defendant number 1, the injunction has been granted by the my lord trial court and confirmed by the appellate court. My contention is that my lord, there is a collision between defendant number 1 and the appellant.
But anyway, it's, if the revenue records stand in her name,
But
there's something to show that she is in possession.
that is the only my lord record of rights. But my case is that my lord, both the defendant number 1 and her wife violating each other, my lord, transfer without any my lord mutation entry or any consent of this defendant 2 and 3.
Work out a remedy in the suit. Work out. The defendants 2 and 3 in OS number 282 of 2022 on the file of so-and-so are before this court challenging an order dated so-and-so by which the trial court granted interim injunction restraining them from interfering with the possession of the plaintiffs. Full stop. The defendants are also aggrieved by an order passed by the appellate court in MA number so-and-so. MA number 22 of 2023, by which it confirmed the order of injunction. Next para. The suit in OS number 282 of 2022 was filed for perpetual injunction in respect of a land bearing survey number 149/*4 of Nelal village, Raichur Taluk and district, and survey number 2113 of Nelal village, Raichur Taluk and district. The plaintiff claimed that she was the wife of the defendant number 1 and that plaintiffs 2 and 3 were their children. Well, you know, 2 and 3 are?
They are the children of my lord plaintiff and the defendant number 1.
They are the children of, and that the plaintiffs 2 and 3 are the children. Full stop. She claimed that
Her father-in-law has.
that she was thrown out of the family in the year 1994. And defendant number one contracted another marriage. Full stop. Thereafter, a panchayat was held, whereat the suit properties were made over for the maintenance of the plaintiff and her children. The plaintiffs claimed that they were in possession of the suit property from the year 1994, and that revenue documents were transferred to their names. They alleged that the defendants tried to dispossess them from the suit property and thus sought for perpetual injunction. Along with the suit, they filed an application for interim injunction to restrain the defendants from interfering with their possession. The suit was contested by the defendants, who contended that the suit properties who contended inter alia, that the suit properties were ancestral properties of the family, and that they were in possession of the suit properties. The application for injunction was also opposed on similar lines. The trial court, after considering the material on record, held that the plaintiff is entitled to injunction and is entitled for an order of interim injunction, as the revenue records of the suit property stood in the name of the plaintiff number one. Stood in the name of the plaintiff number one. ಶಿವಪ್ಪ ಅಂತಿದ್ದಲ್ಲಿ ಯಾವ್ದಿದು? Plaintiff number one as on the date of the suit.
That is different number 3.
And therefore it held that the plaintiff had made out a prima facie case that she was in possession of the suit property, and hence allowed the application in terms of the order dated 9th August 2023. Feeling aggrieved by the said order, the defendants 2 and 3 filed MA 22/2023. The appellate court secured the records of the trial court, and after hearing the parties, held that the defendants 2 and 3 did not dispute that plaintiff number one was married to the defendant number one, and plaintiffs 2 and 3 were their children. It also perused the revenue mutation proceedings, which showed that the name of the plaintiff number one was entered in the revenue records, and the RTC for the year 2020-21 stood in the name of the plaintiff. Consequently, it held the plaintiff had made out a prima facie case for grant of injunction, and hence passed the impugned order dated 9th July 2024, dismissing the appeal and confirming the order of injunction. Being agreed with the said order, the defendants 2 and 3 are before this court in this writ petition. Next, for the learned counsel for the defendant submitted that the suit properties were ancestral properties of the family, for the plaintiffs were not entitled to seek perpetual injunction to restrain the defendants from interfering with their possession, as the defendants are also deemed to be in possession of the suit properties. He contends that the question whether the suit properties were made over to the plaintiff number one for her maintenance is a question of fact which has to be adjudicated after a full-fledged trial, and therefore the trial court could not have granted interim injunction, which had the effect of dispossessing the defendants from the social properties. Next para. A perusal of the impugned order passed by the trial court and the appellate court shows that that both the courts held that the name of the plaintiff number 1 was entered in the revenue records pursuant to the acceptance of the mutation. And as on the date of the filing of the suit, the name of the plaintiff number 1 appeared in the RTC. It therefore held that the claim of the plaintiff number 1 that the suit properties were made over to her towards her maintenance at the panchayat held in the year 1994 is probable, and a triable case is made out by the plaintiff number 1. Full stop. The trial court, therefore, in order to maintain status quo of the property pending disposal of the suit, had directed the defendants not to interfere with the possession of the plaintiff. There is no error committed by both the courts in granting an order of injunction warranting interference in this writ petition. Hence, the petition is dismissed. Shivkumar Patil.
Lord should kindly grant 2 weeks time.
Yaru, other side, yaru.
Other side is government.
7 minutes. AGA is directed to accept notice for respondents 1 and 2.
Let this
List on.
serial number 37 concerned jurisdiction is comes Dharwad High Court.
Dharwad.
Now, this impugned order annexure B is in Waspet authority under the Motor Vehicle Act.
But R1
Appellate
is,
authority is a jurisdiction.
Joint
for,
Commissioner is at Kalaburagi RTO also.
Appellate authority is not, jurisdiction, only the appellate authority.
The original authority is Kalaburagi.
Yeah, no, original authority is annexure B, my lord. It's Waspet
Koppal.
authorities, Koppal district.
Koppalada algobekalla.
Please, my lord. It's a jurisdiction is Dharwad, my lord. 37 and 41 is jurisdiction.
We'll send it to Dharwad.
Anyhow, there is no serious on the refund amount in this they are asking.
Only for refund.
Only refund, there is no serious. Their motor is scrap and they are not running, therefore they paid the registration amount, they want refund amount.
The impugned order is passed with the regional transport officer, Koppal.
Not Koppal, Waspet, my lord, annexure B, page number 19.
Hospete raste Koppala antide.
Koppal.
Yes, please.
Koppal. And therefore, the Koppal and an appeal is filed against the order. Appeal is filed against the said order before the Joint Commissioner Kalaburagi of Transport, Kalaburagi. It is stated that this writ petition has to be tried before the bench at Dharwad as the original authority as the respondent number 2, which had passed the initial order, lay within the limits of the Dharwad bench. Full stop. This is not disputed by the learned counsel for the petitioner. Hence, office is directed to place this petition before the Dharwad bench for appropriate orders. For statistical purposes, this petition is treated as closed in this bench. It is serial number 37 and
41, my lord.
41, same order.
Please.
38, Shivanand Patil.
For the petition.
Hmm.
Application under 7 Rule 14 lots seeking to produce certain documents.
At what stage?
Lots, the stage of arguments. The reason being, lots being delayed application lots that she could not lay hands on certain documents.
What certain documents?
Lots of documents I haven't produced in the petition. I'm permitted to produce it along with the
They
memo.
don't even say what are those documents.
Document lots pertinent to a sale deed executed by the defendant
Hmm.
in favor of one person named
How is that relevant Please place on record all those
No,
documents.
no, I have I have memo.
Please, Marty.
So I may be permitted because
Oh.
tomorrow is the
Good.
hearing date before trial court.
Suit is for what?
Suit is for declaration and injunction loads
Hmm.
as against the defendant, the respondent only. Notes in the suit, she claims to be in possession of land survey number 18/1, measuring 6 acres 28 guntas and 18/2 measuring 5 acres 24 guntas.
Hmm.
She has succeeded to that property after the death of her husband. Earlier, the suit properties were standing in the name of her husband. Further, my lords, she has succeeded to that property and is in possession of the property. In furtherance, my lords, the defendant files a written statement contending that he has a share in that suit property, in those two suit properties. Now, my lords, by virtue of these documents, my lords, I would like to introduce it to the court that there is earlier partition. In that partition, my lords, he has been allotted the adjacent land, 18/3, survey number 18/3, which measures 9 acres.
Why you did not know about this document earlier?
My lords, I did not have possession of that document.
Okay.
Subsequently, my lords, I got.
It is executed by you only.
No, that is not executed by me. That is executed by the defendant. Defendant number 1. In para 17, page 17, lots WS, para number 7. Further clearly, he claims that he has a share in the suit properties.
And along with the ಬೇರೆ documents ಏನೇನೋ ಹಾಕ್ತಿದ್ರಲ್ಲ.
ಬೇರೆ document not stating that earlier my husband, yes, notes.
What are these taxpayer receipts that you want?
That is by husband of the petitioner number 1. Earlier that land were standing in the name of the husband of the petitioner.
I could issue emergent notice. In addition, learned counsel for the petitioner is directed to serve the learned counsel who represents the respondent before the trial court. Interim stay of further proceedings before the trial court.
Yes.
Till the next date of hearing. List on.
31.
See number 39.
Much obligation.
Anand Jagirdar.
Petitioner here in Manoj.
Ah.
The petitioner is a registered dealer under the GST Act. There is a credit in the electronic ledger to an extent of around 49 lakhs. While filing the returns for the month of March 2021, the outward supplies was shown by the petitioner. However, there was a cess amount which was required to be paid to an extent of around 47.4 lakhs, which was not shown in the returns. So later on, subsequently, this omission was rectified by making the adjustment from the electronic credit ledger by filing this form DRC3. Now the authority has issued notice stating that there is a delay in payment of the cess, and therefore interest and penalty would be levied. In fact, the electronic credit ledger is, this is a payment and adjustment of the ITC, and therefore the entire amount is with the government already. It is only a question of adjustment at the time of filing returns. There are two decisions of High Courts of Madras and the Honorable High Court of Gujarat especially, which has taken note of the other judgments of the different High Courts and have held that when ITC is to be adjusted, it is nothing but the amount which is already lying with the government is only adjusted in the accounts. And therefore, there is no question of any levy of interest or penalty.
Is there any appeal against this order?
No, there is no appeal. Sir. This is only a notice for the purpose of interest. I am required to show the interest.
Where is the demand? Where is the demand?
Annexure D. Page 21, Annexure D. There is a demand of interest and penalty of.
If ITC was lying with you, then.
R4 million. For the respond number 4 only.
Correct, but what was the ITC lying with them?
49 lakhs, 49.07 lakhs was the ITC lying. I have produced the returns also to show that that was the ITC. And then
49 or 41? Na?
49. 49.07 approximately is the ITC lying in the electronic ledger, and 47.44 odd is the amount which I have now paid. There is no dispute about the payment of the cess. Cess is paid to an extent of 47 lakhs, and that is also by way of the adjustment from the ITC.
It was the ITC for which period?
That was for March 2021. Cess is also for that era of March 2021.
Yes, government. Purple. AGS,
R form.
yaar baro
Sudhir Singh, my lords, for respondent number 1 ASG. For
Sudhir-
respondent number 4, my friend will take the notice. For respondents 2 and 3.
Millets, with the permission, millets of this court, I
Ah.
take notice for respondent number 2 and 3, millets. Central
Mr.
tax,
Mr. Girish
Hulmani, millets.
Gulmani
Please, millets.
is directed to accept notice for respondents 2 and 3.
Please, millets.
1 and 4 avashyakate idya.
Millets, one is
a
the Union
formal
of India, millets.
Formal part. It's
ಏನಕ್ಕೆ
only.
ಬೇಕು? Notice to respond 1 and 4 is dispensed. Interim stay of the impugned demand,
Annexure D.
bracket annexure D. Till the next date of hearing. List on, when do you want it?
Millets, 2 weeks, millets.
List on date.
Please.
Much blessed.
Deepak Bharat.
That's annexure E and H are in question.
Annexure
E and H, my lord.
E and H.
Yes, my lord. This, the respondent number 1 has filed a suit for possession against the petitioner and other respondents, my lord, before the trial court. My lord, the defendant number 1 had produced the documents in along with the IA number 14, my lord. My lord, and IA number 16 was for impleading the municipality, my lord. The earlier point of time, my lord, the IA number 14 and 16 were commonly ordered by trial court, and IA number 16 was questioned before the this honorable court, my lord. That was rejected, and on the findings on IA number 14, with regard to the production of documents, were not given on trial court, my lord. And now subsequently, my lord, the IA number 25 has been produced by the defendant number 1 for marking of the documents which were produced along with the IA number 14.
No, whether the court says that these documents are not necessary.
No, it's necessary because, my lord, I have taken a
Whether
specific.
the court says that it is not necessary.
No, my lord, may I take to impugned order of the court? The reasons given by the court, trial court, is that, my lord, I have not challenged the IA number 16, which is wrongly shown, my lord. It's actually for IA number 14. My lord, may I read page 45, my lord? Page 45. May I read? In the affidavit in support of IA number 25, it is stated that the case is posted for further chief of DW1, that is for the marking of documents which have been filed before the honorable court. The defendant have filed IA number 15 for impleading the government as a party to the suit, and knows to support the IA number 15. Further, the defendant have filed IA number 16 with separate list of documents. Upon hearing on IA number 15 and 16, the honorable court was pleased to reject IAs. But the said documents are part and parcel of the file, and the said documents are being public document, just and proper to file the marker. Hence, they prayed to allow the application. Per contra, the plaintiff has filed counsel for the plaintiff has filed objection to IA number 25, stating that the contents of the petitions are false, and further denied the document. They stated that on 6/1/24, the honorable court rejected the application, imposing further relied upon the counsel for defendant is not relevant. Hence, not made the application applicable to the present case in hand. Further, it is relevant to note that the defendant is filing one or the other application to drag the matter, and by counsel for the plaintiff. My lord, this application, IA number 14, may I take to page? Annexure E, my lord.
Annexure C is IA number 14.
Yes, my lord. Lord, the entire suit property is a municipal. I have taken a specific stand in the written statement, my lord. May I take to
Correct,
page?
The survey number, what is the suit property?
Suit property, my lord, is
Yeah,
a
suit.
CMC number,
Ah.
my lord, measuring 16 into Lord, 16 into Lord, 16 into 18, my lord. 16 into 28 feet land, my lord, which is temporarily shed has been page 16.
The survey number 4 of our.
Entire land is survey number 4, my lord. I have taken specific stand in a written statement. May I take to page 21, my lord? Page 21 of written statement, para 4, page 21. It will be relevant, my lord. Third line, my lord. The alleged Aisha Begum, my lord, third line of the written layout, page 21, my lord. Third line, alleged Aisha Begum layout was in dispute before the Honorable High Court of Karnataka. Same was known to be a Muhammad Sadiq, who is also one of the party to the said dispute, wherein held the said entire land belongs to the municipality. Neither Aisha Begum was the owner of the entire land, and she have any right to give the part of the land to her son, and her son no right to sold the mother, the plaintiff. The concocted document not valid in the eyes of law. We have taken a specific stand in the written statement, Lord. It is a government land which pertains to the.
This petition is only in respect of IA number 14 or 16?
IA number 16, my lord, which was with the impleading, my lord. And my lord, moreover, the reasonings given, page 58, my lord, page 36. 36.
This is IA number 14. Where is
Yes.
IA number 15?
No, it's no. IA number 14 and 16 were clubbed together, my lord. That has wrongly
Where is
stated.
IA number 16?
IA number 16 was for impleading.
16 already. 15 was for impleading.
No, may I take to page 32, my lord?
Please read page 32.
Page 32. Provisions under the application is IA number order under 8 rule 1 of CPC, order 1 rule 10 of CPC, my lord. 3 IS were filed, my lord, actually.
Oh, the IA number 15 is order 1 rule 10. IA number 14 is order 8
Yes.
rule 1.
Yes, ma'am. That
IA number 16 is order 8 rule 1A. IA number 16 ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಿರೋದು.
may Annexure C, my lord. Annexure C. That has been also production of documents.
This is IA number 14. IA number 16 ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಿರೋದು.
My lord, that along with IA number 14 itself, we have produced documents.
ಎಲ್ಲಿದೆ ಅದು? You have not produced along with the petition.
I have not produced that.
This petition is only in respect of IA number 14 or 16 also?
No, only 14.
Only 14.
14 along with IA number 25.
25, IA number 25 ಓದಿ ಏನು ಹೇಳಿದೆ?
Yes.
Annexure F.
Yes. Affidavit.
ಅಲ್ಲ IA ಓದ್ರಿ.
Yes. That your honor may kindly be pleased to allow the petition, and whereby the defendant may kindly be permitted to mark documents produced in IA number 16, my lord. That is wrong. That's why I have stated in my writ petition, my lord. May I take to specifically stated in the writ petition, my lord, it is wrongly stated that instead of IA number 14, that has been stated is IA number 16, my lord. May I read, my lord?
ಅಲ್ಲಲ್ಲ ಒಂದು IA ಹಾಕಿದ್ರಿ order 8 rule 1 to produce. Fair enough. You file one more application to mark the document.
Because, my lord, that was not challenged, my lord. Till date, it was not challenged. That's why I'm challenging along with that 6124 order is also questioned in this petition.
Correct, Deepak, but once the document ಹಾಕಿದ್ಮೇಲೆ, if the court permits you to produce a document, invariably it will be marked. ಅದಕ್ಕೊಂದು ಅಪ್ಲಿಕೇಶನ್.
ಅದು ರಿಜೆಕ್ಟ್ ಆದ ನಂತರ ಸ್ವಾಮಿ, ಅದು ರಿಜೆಕ್ಟ್ ಆಯ್ತು. IA ನಂಬರ್ 16 ಜೊತೆ ರಿಜೆಕ್ಟ್ ಆಯ್ತು, ಇಂಪ್ಲೀಡಿಂಗ್ ಜೊತೆ. ಅದು ಆದ ನಂತರ ಅದು ಕ್ವಶನ್ ಮಾಡಿಲ್ಲ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್. ಮೇ ಐ ಟೇಕ್ ಟು ಪೇಜ್ 38
ನೋಡಿ ಹೌ ಮಿಸ್ಚೀವಸ್ ಯು ಆರ್ ಅನ್ನೋದಕ್ಕೆ ದಿಸ್ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ವಾಸ್ ಪಾಸ್ಡ್ ಆನ್ ವಾಟ್ ಡೇಟ್? 6/1/24 ಅಲ್ವಾ? IA number 14 ಫೈಲ್ ಮಾಡಿರೋದು ಯಾವಾಗ? 5/12/23.
That was not been taken, my lord. It's not, that, my lord, we are not, that was not taken for hearing and orders were not passed on that IM.
IA number 14 ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲಿ 6/1/24 ಗೆ ಮಾಡಿದ್ದಾರೆ.
Correct.
Yes.
ಅಲ್ವಾ? ನೀವು, where is the need for you to file an application to mark the documents even before it was allowed?
Subsequently, we have filed I number 25.
Subsequent ಇಲ್ಲಿ ಸರ್ 10, 12, 24 ಹಾಕಿರೋದು ನೀವು.
Yes, ma'am. That in January itself is I number 14 was rejected. It is in month of December, ma'am.
December 2024.
It is January 24, ma'am.
ಅಲ್ವಾ?
Yes.
ರಿಜೆಕ್ಟ್ ಆಯ್ತು. ರಿಜೆಕ್ಟ್ ಆದ್ಮೇಲೆ where is the question of filing one more application is what I am asking.
That could not have been.
So you have been filing mischievously one.
That could, the application was not necessary, ma'am.
I will direct the trial court. ಇನ್ನು ಮುಂದೆ ಏನಾದ್ರು ಈ ಮಿಸ್ಚೀವಸ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಒಂದೊಂದು ಅಪ್ಲಿಕೇಶನ್ 10,000 ರೂಪಾಯಿ ದಂಡ ಹಾಕಿ ಅಂತ.
That application could not, Mufasil pleading, my lord, Mufasil.
Mufasil ಸರಿ, ಮುಫಸಿಲ್ಗೆ ಜಾಸ್ತಿ ಬರೆ ಬೀಳ್ಬೇಕಾಗ್ತದೆ. Lawyers also should gear up ಅಲ್ವಾ?
That application could not have been filed.
ಎಲ್ಲಿ ಹೇಳಿದ್ರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 4 ಅಲ್ಲಿ ಬಂದಿದೆ ಅಂತ?
ಇಲ್ಲ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್. Para 4, my lord, may I read? The para number 2 of the plaint are quite incorrect to say that Aisha Begum was absolute owner and possessor of the entire layout and gifted the plot 80 into 51 feet with CMC 9-1-31 to her son Muhammad Siddiq under the registered. This plot has been sold. The mother of the plaintiff, Anik Bashir, wife of Syed Bashirullah Hussain Rizvi, after the defiance of this her mother, the plaintiff has been successor of this plot. When the transaction took place, the entire land survey number 3 of
3 ಅದು 4 ಅಲ್ಲ. 4 ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
My lord, it could have been renumbered. That
renumber ನೀವು ಹೇಳಬೇಕು.
And that has not been stated.
Then ಯಾವ ಸ್ಟೇಜಿಗೆ ಫೈಲ್ ಮಾಡಿದ್ರಿ ಅಪ್ಲಿಕೇಶನ್?
A defendant further evidence. Further evidence of defendant.
How have you said that this survey number, this document is relevant? ಎಲ್ಲೂ ಹೇಳಿ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲೂ ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ IA ಒಳಗೆ ಹೇಳಿದ್ವಿ. I number.
IA ನಲ್ಲೂ ಹೇಳಿಲ್ಲ.
Yes, I have.
ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ, annexure. That's what, no, it's IA number C, annexure C, Milo.
ಎಲ್ಲಿ ಹೇಳಿದ್ರ? How is this relevant ಅಂತ?
Affidavit is very brief, my lord.
ಏನ್ ಮಾಡೋದು?
At the time of filing, may page 27.
Yes.
At the time of filing of written statement, defendant could not secure the aforesaid documents, which is important. One, now the defendant is secured the said documents which is necessary for adjudication of case. Therefore, the same is liable to be taken on record.
Important illalla, illirbeko. How it is important? It's, if it's in the mind, it will be in the mind.
That is not been pleaded.
Then how do you say it is important?
But the in application part, my lord, the entire land survey is pertains to municipality, my lord.
That is not the.
May I take to plaint itself, my lord? How the
ಎಲ್ಲಾದ್ರೂ ನಿಮ್ಮ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಸೂಟ್ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ಎ ಪಾರ್ಟ್ ಆಫ್ ಸರ್ವೆ ನಂಬರ್ 4 ಅಂತ ಎಲ್ಲ ಹೇಳಿದ್ರೆ ಐ ವಿಲ್ ಪರ್ಮಿಟ್ ಯು. ಎಲ್ಲಾದ್ರೂ ಹೇಳಿದ್ರೆ ತೋರಿಸಿ. Anywhere in the written statement.
May I take to one part of the plaint, my lord? I will leave to the court, my lord. Para 2, my lord. How the title derived, how the plaintiff is deriving the title. Lord, there is no conveyance at all of the title. May I take to para 2? May I read, my lord? Para 192, I will read, my lord.
Please read.
The plaintiff is exclusive owner of the suit property, old and new, mentioned in the subject matter of the plaint. The plaintiff has acquired the suit property by a succession of her real mother, Anik Begum, late wife of Syed Bashirul Hassan Razvi. The said Anik Bashir, wife of late Syed Bashirullah Hassan Razvi, died on 16/1/2019. Since then, the plaintiff, being the legal heir and the successor of the suit plot, became the absolute owner of the suit plot. The said Anik Bashir has left behind her only daughter, the plaintiff, to succeed her assets and liabilities. The suit open plot and other one more plot in the name, in the same layout is also left by her at the time of death. Thus, the plaintiff is exclusive, so and so. That one Aisha Begum, wife of M.A. Khalik, was the owner, absolute owner and possessor of the entire layout. The said layout is called Aisha Begum layout. Out of the said layout, she has gifted piece of plot measuring 18 to 50, to which the CMC has been number 9-310 north to her son by name Muhammad Siddiq. And Muhammad M.A. Siddiq registered gift through so and so. Thus, the Muhammad Siddiq become the absolute owner and possessor of the plot. Thereafter, the said Siddiqui has sold the entire plot to Anik Begum, mother of the. There is no conveyance at all. No.
ಏನಾದ್ರೂ ನೀವು ಕೇಸ್ ನಡೆಸ್ಕೊಳ್ಳಿ ಬೇಡ ಅಂತ ನಾವ್ ಹೇಳಲ್ಲ.
At least opportunity of being production of document, at least I will take the hand summons, my lord. Otherwise.
Hand summons, sorry, but how do you say that this document is relevant?
It is a government land, entirely it is government land.
Where have you said in the written statement?
That survey number has been it has been stated.
ಅದನ್ನ amendment ಮಾಡ್ಕೊಳ್ಳಿ ಮತ್ತೆ. You get it amended.
Otherwise, my lord, may I produce the document itself, my lord? I will.
Document?
Along with the IAs which have been produced, my lord.
On counsel for the petition.
Monday.
List on.
Monday.
Whichever date, Monday ಆಗಲ್ಲ.
The problem is that, my lord, is posted for further evidence of.
Please go on with the evidence.
And that's why Monday, my lord, I will produce.
Monday, Friday, next Friday.
Oh, bless.
Kumar Mutt.
I am the petitioner, my lords. FDP proceedings are like appointed court commissioner for demarcation and sharing of the suit properties, my lords. There are standing crops. That's on the strength of the order.
What is it you sought for?
Quashing of IA number 1, my lord.
What is IA number 1?
IA number 1 is that appointment of the court commissioner in a FDP proceedings, my lord. ADLR Devdurga has been appointed as the court commissioner to effect the partition of the suit properties. There are 3 agricultural lands, my lords, and 1 house property.
But we will say that let the partition go on, but no disturbance. Possession will be taken only in execution.
ಇವಾಗ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕ್ರಾಪ್ಸ್ ಡ್ಯಾಮೇಜ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ ಸರ್.
ನೀವು ಮಾಡ್ಕೊಳ್ಳಿ ಬೇಡ ಅಂತ ಹೇಳಿ ಬರ್ಕೊಳ್ಳಿ.
ಇಂತಿರೋ ಕ್ರಾಪ್ಸ್ ಇದಾವೆ ಸರ್. ಗ್ರೌಂಡ್ ನಟ್ಸ್ ಅಂಡ್ ಪ್ಯಾಡೀಸ್ ಆರ್.
Issue emergent notice. The issue emergent notice. In addition, learned counsel for the petitioner.
Hand summons to the.
Is permitted to take. Is permitted to serve.
The counsel appearing before the FDP court.
The advocate who represents the respondents before the decree court.
Senior civil judge and.
Meanwhile, the court commissioner appointed to effect division of the suit properties shall continue to effect partition and suggest a scheme for partition. However, that shall not affect the persons in possession to harvest the crops that they have raised in the properties.
Standing ಇದೆನಾ ಹಾರ್ವೆಸ್ಟಿಗೆ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
ಏನು
ಶೇಂಗಾ ಇದೆ ಸ್ವಾಮಿ.
ಹಾರ್ವೆಸ್ಟ್ ಅಂದ್ರೆ ಏನು? ಬೆಳೆದ ಮೇಲೆ ಹಾರ್ವೆಸ್ಟ್ ಮಾಡೋದು. ಹಾರ್ವೆಸ್ಟ್ ಅಂದ್ರೆ ಏನು? ಈಗಲೇ ಕೇಳಕ್ಕಾಗತ್ತಾ?
Ma'am, pass on before going to merit.
Take it up at 2:30. All of the matters are taken.
Submission.
Yeah.
Serial number 70. May be dismissed for having become infractions. My name may be shown. Instead of.
20. Mallikarjun Saukar.
My name may be shown.
The learned counsel for the Mr. Office is directed to show the name of Mr. Subhash Mallapur.
Yes.
As the counsel for the petitioner. The learned counsel submits that the writ petition has become infructuous. The submission is noted and the petition is dismissed as having become infructuous.
Serial number 17. Our bar council member ಅಷ್ಟೇ.
ನೋಡ್ರಿ ಎರಡು ಎರಡು
Serial number 13 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. 1313. ಅದೇ ಪಿ ಎಫ್ ಕಟ್ಟಿದ್ದೀನಿ. ಹಾ ಪಿ ಎಫ್ ಬೆಂಗಳೂರು ಮಾಡ್ರಿದ್ದು ಸರ್ ಯಾವ ಪಾಸ್ ಓವರ್ ತೊಗೊಂತಾರೆ ಫಸ್ಟ್.
ಮಂಜುನಾಥ್ ರಾಯಪ್ಪ. ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡ್ರಿ ಮುಂದಿನ ಸತಿ ಬರ್ದೇ ಇದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ಬಿಡ್ರಿ. ಮುಂದಿನ ಸತಿ ಬರ್ದೇ ಇದ್ರೆ ಡಿಸ್ಮಿಸ್. There is no representation for the petitioner. Sorry, the learned counsel for the petitioner seeks time. Since the suit is filed in the year 2012, the request for adjournment is not justified. Hence, as a last chance, nonetheless, as a last chance, list on.
Kindly, my lord, my name is deleted, man. My name is deleted.
Okay.
Kindly, my lord.
Well, ನಿಮ್ ಕೆಲಸ ನೀವು ಮಾಡ್ತಿದ್ರಿ, ಅವ್ರು ಬರ್ದಿರ ಏನ್ ಮಾಡಕ. Next.
Kindly.
DP Ambekar, process paid, huh?
By tomorrow, covered by judgment is there.
Yen covered by judgment, CPC matters alli?
Yes. Plaintiffs, my lord, they filed a suit for declaration that the compromise decree entered into between defendants 1, 2, 3. is not binding on their share. And further for partition and separate possession. In the said suit, my lord, so the plaintiffs, my lord, they filed an application seeking to withdraw the suit with liberty to file fresh suit on same cause of action. The application, my lord, it has been partly allowed and only suit is dismissed as withdrawn, but no liberty is granted. It is settled law that suit prayer for withdrawal with permission to file fresh suit, it's a composite prayer, indivisible prayer. It should be either allowed as a whole or rejected as a whole.
Your other side, yaru?
The sir, I'll have to take steps. Sole respondent to that.
Cool. The process
But tomorrow I'll verify the correct address.
1 week time is granted to do the needful.
Please.
Servagidre allow ಮಾಡಬಹುದು. If the notice was served, we could have allowed the petition.
Yes. Judgment ತಂದಿದ್ದೀವಿ.
ಕೊಟ್ಟಿದ್ದಾರಾ? Counsel for the petitioner submits that process is paid.
Needful is done, madam.
Office is directed to check, verify and proceed to issue notice. Yes.
Yes.
Abdul Muqtadir.
Lordship, may kindly the bailiff report may be seen, my lordship.
Pardon?
Bailiff report, my lordship. One small
Bailiff?
bailiff report.
ಎಲ್ಲಿದೆ ಅದು?
Memo of production of documents, page number 9, typed copy of bailiff report.
ಓದಿ.
Judgment chapter none, number 1 and judgment chapter number 2, ಇರುವ ಕಬ್ಜಾ ವಾರೆಂಟ್ ನಲ್ಲಿ ತೋರಿಸಿದ ಚೆಕ್ ಬಂದಿ ಸರಿಯಾಗಿ ಇರುವುದಿಲ್ಲ ಮತ್ತು ಸದರಿ 2 ಮಳಿಗೆಗಳ ಉದ್ದ ಅಗಲ ಅಳತೆ ಇರುವುದಿಲ್ಲ. ಅದೇ ಕಾರಣ ಜಜ್ಮೆಂಟ್ ಡೇಟರ್ ಇವರು ಸ್ವಾಧೀನ ಬಿಟ್ಟುಕೊಡಲು ತಂಟೆ ತಕರಾರು ಮಾಡುವುದರಿಂದ ಕಬ್ಜಾ ವಾರೆಂಟ್ ಬಚಾವಣೆ ಆಗಿಲ್ಲ. ಕಾರಣ ಚೆಕ್ ಬಂದಿ ಸರಿಯಾಗಿ ಗುರುತುಪಡಿಸಿದ್ದಲ್ಲಿ ಮತ್ತು 2 ಮಳಿಗೆಗಳ ಉದ್ದ ಅಗಲ ಅಳತೆ ಗುರುತುಪಡಿಸಿದ್ದಲ್ಲಿ ಹಾಗೂ ಪೊಲೀಸ್ ಸಹಾಯ ನೀಡಿದಲ್ಲಿ ಕಬ್ಜಾ ವಾರೆಂಟ್ ಬದಲಾವಣೆ ಮಾಡಲಾಗುವುದು.
Yeah, what is it?
My submission is, my lord.
My lord, sir.
The property, my lord, it was identified by boundaries in the plaint. That boundaries, my lord, it was specifically admitted in the return statement. Now, my lord, the judgment debtor, he is now raising a new plea before the bailiff.
Anyway, let us read the bailiff's report. ಏನ್ ಹೇಳ್ತಾರೆ?
Not be provided a copy.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ?
Copy ಕೊಟ್ಟಿಲ್ಲ. Now, my lords, they are refused to heed the bailiff's this thing. Therefore, the next step would be to take police aid and vacate them.
No, but if it does not correspond with the decree, ಓದಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ ಓದಿ.
Bailiff report. ನಾನು ಶಂಭು ಲಿಂಗ್ಸ್ ಅಂಡ್ ಸೊ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯ ಲಿಂಗ್ಸೂರು ಇವರು ಪ್ರಮಾಣ ರಿಪೋರ್ಟ್ ಬರೆದುಕೊಡುವುದೇನೆಂದರೆ ದಿನಾಂಕ 6/4/2024 ಲಿಂಗ್ಸೂರಿಗೆ ಹೋಗಿ ಕಬ್ಜಾ ವಾರಂಟ್ ತೋರಿಸಿದ ವಿಳಾಸ DHR2 ಇವರು ಸಮಕ್ಷಮವಾಗಿ ಹೋಗಿ ಹಾಜರಿದ್ದೆವು. ನಂತರ ಕಬ್ಜಾ ವಾರಂಟ್ ಅಲ್ಲಿ ತೋರಿಸಿದ JDR ಇವರಿಗೆ ಸಂಬಂಧಪಟ್ಟ 1 TMC ನಂಬರ್ ಸೊ ಅಂಡ್ ಸೊ ಅಂಡ್ 2 TMC ನಂಬರ್ ಸೊ ಅಂಡ್ ಸೊ ಈ ಮಳಿಗೆಗಳನ್ನು ನೋಡಲಾಗಿ ಸದರಿ ಮಳಿಗೆಯಲ್ಲಿ 2 ಮಳಿಗೆಗಳ JDR 1 and 2 ಹಾಜರಿದ್ದು ನಾನು ಸದರಿ JDR 1 and 2 ಇವರಿಗೆ ಕೋರ್ಟ್ ಆದೇಶ ಬಗ್ಗೆ ಓದಿ ತಿಳಿಸಿದ್ನು. ನಂತರ ಸದರಿ JDR ಇವರುಗಳು ಕೋರ್ಟ್ ಆದೇಶದ ಬಗ್ಗೆ ಮತ್ತು ಕಬ್ಜಾ ವಾರಂಟಿನ ತೋರಿಸಿದ ಮಳಿಗೆಗಳ ವಿವರದ ಬಗ್ಗೆ ತಿಳಿದುಕೊಂಡು ನಂತರ ಸದರಿ JDR ಇವರುಗಳು ಕಬ್ಜಾ ವಾರಂಟ್ನಲ್ಲಿ ತೋರಿಸಿದ 2 ಮಳಿಗೆಗಳ ಚಕ್ಬಂದಿ ಸರಿಯಾಗಿ ಇರುವುದಿಲ್ಲ. ಸದರಿ ಮಳಿಗೆಗಳ ದಕ್ಷಿಣ ದಿಕ್ಕಿಗೆ ರಮೇಶ್ ತಂದೆ ಕೇಶಪ್ಪ ಹಾಗೂ ರಮೇಶ್ ತಂದೆ ಮಾಣಿಕ್ ಪ್ರಭು ಈ ಪ್ರಕಾರ ಚಕ್ಬಂದಿ ಇರುತ್ತದೆ. ಕಬ್ಜಾ ವಾರಂಟ್ನಲ್ಲಿ ತೋರಿಸಿದ ಚಕ್ಬಂದಿ ದಕ್ಷಿಣ ದಿಕ್ಕಿನ ಕಡೆಗೆ ಜಯನಾರಾಯಣ್ ಇರುತ್ತಾರೆ ಮತ್ತು ಕಬ್ಜಾ ವಾರಂಟ್ ತೋರಿಸಿದ 2 ಮಳಿಗೆಗಳ ಉದ್ದ ಮತ್ತು ಅಗಲ ಅಳತೆ ಎಷ್ಟು ಇರುತ್ತದೆ ಎಂದು ಸಂಪೂರ್ಣ ಮಾಹಿತಿ ತೋರಿಸಿರುವುದಿಲ್ಲ ಎಂದು JDR ಇವರು ನಮಗೆ ಸದರಿ ಸರಿಯಾದ ಚಕ್ಬಂದಿ ಹಾಗೂ ಸದರಿ ಮಳಿಗೆಗಳ ವಿಸ್ತೀರ್ಣ ಗುರುತುಪಡಿಸಿದಲ್ಲಿ ನಾವು ಡಿಕ್ರಿಯಾರ್ ಇವರುಗಳಿಗೆ ಬಿಟ್ಟು ಕೊಡುತ್ತೇನೆ ಎಂದು ಹೇಳಿದರು. ಕಾರಣ ಚಕ್ಬಂದಿ ಹಾಗೂ ಮಳಿಗೆಗಳ ವಿಸ್ತೀರ್ಣ ಉದ್ದ ಅಗಲು ಅಳತೆ ಇಲ್ಲದ ಕಾರಣ ನಾವು ಕಬ್ಜಾ ಡಿಕ್ರಿ ಹೋಲ್ಡರ್ ಇವರಿಗೆ ಬಿಡುವುದಿಲ್ಲ ಎಂದು JDR 1 ಇವರುಗಳು ಸದರಿ ಸ್ಥಳದಲ್ಲಿ ತಂಟೆ ತಕರಾರು ಮಾಡಿರುತ್ತಾರೆ. ಆದ ಕಾರಣ ದಿನಾಂಕ 6/4/2024 ಕೋರ್ಟ್ ಆದೇಶ ಪ್ರಕಾರ ಕಬ್ಜಾ ವಾರಂಟಿನಲ್ಲಿ ತೋರಿಸಿದ TMC ನಂಬರ್ ಸೊ ಅಂಡ್ ಸೊ ಮತ್ತು TMC ನಂಬರ್ ಸೊ ಅಂಡ್ ಸೊ ಮಳಿಗೆಗಳು ಡಿಕ್ರಿ ಹೋಲ್ಡರ್ ಇವರಿಗೆ ಸ್ವಾಧೀನಕ್ಕೆ ಕೊಡಿಸಲು ಆಗಿರುವುದಿಲ್ಲ. ಸದರಿ ಕೋರ್ಟ್ ಆದೇಶ ಪ್ರಕಾರ ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ ಇವರುಗಳಿಗೆ ಸ್ವಾಧೀನಪಡಿಸಲು ಸದರಿ ಚಕ್ಬಂದಿ ಸರಿಯಾಗಿ ಗುರುತುಪಡಿಸಿದಲ್ಲಿ ಮತ್ತು ಸದರಿ 2 ಮಳಿಗೆಗಳ ಉದ್ದು ಮತ್ತು ಅಗಲ ಗುರುತುಪಡಿಸಿದಲ್ಲಿ ಮತ್ತು ಪೊಲೀಸ್ ಸಹಾಯ ನೀಡಿದಲ್ಲಿ ಸದರಿ ಕಬ್ಜಾ ವಾರೆಂಟ್ ಅನ್ನು ತೋರಿಸಿದ 2 ಮಳಿಗೆಗಳು ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ ಇವರಿಗೆ ಸ್ವಾಧೀನಕ್ಕೆ ಕೊಡಲಾಗುವುದು. ಕಾರಣ JDR 1 and 2 ಇವರು ತಂಟೆ ತಕರಾರು ಮಾಡಿರುವುದರಿಂದ ಸದರಿ ಕಬ್ಜಾ ವಾರೆಂಟ್ ಬಜಾವಣೆ ಮಾಡದೆ ಈ ನನ್ನ ರಿಪೋರ್ಟಿನ ಸಂಗಡ JDR 1 and 2 ಮತ್ತು ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ 2 ಇವರ ಸಹಿ ತೆಗೆದುಕೊಂಡು ಕಬ್ಜಾ ವಾರೆಂಟ್ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ವಾಪಸ್ ಮಾಡಿರುತ್ತೇನೆ. Property landlords, it is described by boundaries.
Please have a look at the southern boundary, Jai Narayana. Southern boundary ಯಾರಂತಿರೋದಲ್ಲಿ?
Then my lord, it was one Kompal Goindaya in the plaint.
ದಕ್ಷಿಣ ದಿಕ್ಕಿನ ಕಡೆಗೆ ಜೈ ನಾರಾಯಣ ಇರುತ್ತದೆ, ದಕ್ಷಿಣಕ್ಕೆ ಜೈ ನಾರಾಯಣ.
And moreover, both are described by the VPC numbers also. Plus, then it was to the south 25 years back, house of Kompal Goindaya was there towards the south. And that Chakbandi was admitted by the defendants in the written statement.
Yes, Mr.
On order dated 5/6/2024, on order dated 5/6/24, Lordship, last third para, my lords. If that be so, unless the court decide the concerns raised by the court bailiff under section 47 of CPC, the court cannot proceed further. In that view of the matter, unless the concern raised by the court bailiff considered by the executing court, it shall not proceed to execute the decree till the next date of hearing. My lordship, section 47. All the questions relating to the delivery of possession of such property to such purchaser or his representative shall be deemed to be questions relating to CPC. Section 47.
Yes, go on.
All questions relating to the delivery of possession of such property to such purchaser or his representative shall be deemed to be questions relating to the execution, discharge or satisfaction of the decree within the meaning of this section.
ನೀವು ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿ objection ತಗೊಂಡಿದ್ದೀರಾ? The written statement, where have you contended the boundaries are incorrect?
May I pass on pleadings, my lord?
ಇಲ್ಲಿ
Pleadings.
ಹಾಕಿಲ್ವಾ?
Our produce model. This page number 2 flag is on. Plain paragraph number 3 and WS paragraph number 3. Mark. Plain paragraph 3, both the suit properties abutting each other, they are described. That was 25 years back. And in written statement, flag is hatched. There, my lord, they specifically contend, but they say that each other's anyway, Namu event, they are claiming that adverse possession. Therefore, they claim that instead of plaintiff, defendant should be shown, because they claim the title by adverse possession.
ಇದು ಆಲ್ಟರ್ ಮಾಡಿದ್ದೀರಾ, ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ದೀರಾ?
Pardon? ಇಲ್ಲ, ಅವರು ಏನು ಡಿನೈ ಮಾಡಿದ್ದಾರೆ?
Para 4 of the written statement.
Yes.
They have said, or except to the extent of the description of the boundaries as to the west in respect of property number so and so, and east in respect of property number so and so. You have said,
ನೋಡಿದ್ದೀನಿ. ಅದು why they are said like that is, both properties are abutting each other. In the plaint, I have stated towards west of this property, my other land is there. And towards east of this property, my other property is there. Since they are claiming that they are the owners of the property, they say instead of plaintiff, my property is there. So they don't dispute the boundaries. They are saying that since they are claiming adverse to me. ಅವ್ರೇನಂತಿದ್ದಾರೆ, they admit that property number admit ಮಾಡ್ತಾರೆ.
Anyway, should this not be looked into by the executing court?
It can be looked into.
Let
it
the
can be.
executing court decide this.
At the most, it will take assistance of the PDO to demarcate the property, since they are described by both numbers as well as the boundaries.
We will direct the executing court to decide it.
Ascertain the boundaries and proceed.
Number four. The petitioner has challenged. The petitioner was a judgment debtor in EP number 56 of 2023, pending consideration before the senior civil judge and JMFC Linga Subur has filed this petition challenging an order dated 27/3/2024, by which the court entertained an application filed by the DHR under Order 21 Rule 35(3) of CPC and issued a possession warrant. Next part. A suit in OS number 56 of 2000, suit in OS number suit number in
147 of 2001.
447 of
147.
147 of
2001.
Was filed for declaration of title
And in possession.
and for possession, recovery of possession of the suit shall property. The said suit was decreed
On 28/7/2005.
on 28/7/2005.
5.
The decree holder filed EP number,
Judgment debtor.
Huh?
Judgment debtor filed.
EP file ಮಾಡಿದ್ದಾರೆ.
EP. It was confirmed up till RSA.
The judgment debtor, sorry, the decree holder filed EP number 56 of 2023 to execute the decree. Full stop. The executing court issued a delivery warrant which was entrusted to the bailiff for execution. The bailiff visited the property and submitted his report stating that the warrant could not be executed as the judgment debtors opposed, objected, as the judgment debtors objected the execution since the boundaries were incorrect, and also on the ground that the measurement of the property was not mentioned in the delivery warrant. Full stop. Following this, an application was filed by the DHR under Order 21 Rule 35(2) of CPC (35(3) of CPC), which was entertained by the executing court. Which is entertained by the executing court, and the possession warrant was issued. Full stop. Being agreed with the said order, the judgment debtor is before this court. Next para. The learned counsel for the.
One more. The judgment debtor filed I number 3.
Again, they are not challenged it.
No, not.
The learned counsel for the decree holder submitted that once the bailiff submitted a report that the delivery warrant could not be executed in view of the objection raised by the JDR, that the boundaries did not tally and the measurement of the property was not mentioned in the decree, it was the duty of the court under section 47 of CPC to adjudicate the said issue and thereafter issue a possession warrant. Full stop. He therefore contends that the impugned order passed by the executing court issuing a possession warrant without considering the objection, without considering the report of the bailiff is improper, and therefore the impugned order warrants interference. Next para. The learned counsel for the decree holder, on the other hand, contended that the judgment debtor who filed their written statement did not dispute the correctness of the boundaries mentioned in the suit schedule. He contended that the suit was contested on the premise that the boundaries mentioned in the suit schedule were correct. And therefore, the judgment debtor is now stopped from contending that the boundaries mentioned in the delivery warrant did not correspond with the boundaries at the spot. Stop. He therefore contends that the impugned order passed by the trial court is just and proper, the executing court is just and proper, and the same does not warrant interference. Next para. The report of the bailiff, which is placed on record by the learned counsel for the petitioner, shows that an earlier warrant issued by the executing court was returned unserved due to the objection raised by the JDR that the boundaries of the property mentioned in the warrant did not correspond with the actual boundaries at the spot, and that the measurement of the property was not mentioned. Full stop. The court bailiff therefore requested the executing court to incorporate the boundaries and also the measurement so that the delivery warrant could be executed. Full stop. Once such a report is filed by the bailiff, it was incumbent upon the executing court to deal with the objection and thereafter issue a fresh warrant. Full stop. However, the executing court has not resorted to this method, but has entertained an application filed by the DHR for a possession warrant. Full stop. A reading of section 47 of CPC makes it more than apparent that any objection during the course of execution has to be redressed by the executing court, and the executing court cannot gloss over gloss over the objections, cannot gloss over the report of the bailiff. Full stop. In that view of the matter, the impugned order issuing delivery warrant, in that view of the matter, the impugned order allowing the application filed by the DHR under Order 21 Rule 35(3) of CPC warrants interference. Consequently, this petition is allowed. The impugned order is set aside. The executing court is requested to consider the report of the bailiff and, if need be, incorporate the correct boundaries by entertaining any application that may be filed by the DHR and proceed in accordance with law. Since the decree is passed in a suit filed in the year 2001, the executing court is directed to consider and dispose of the proceedings as early as possible, any rate within a period of 6 months from the date of receipt of a copy of this order.
Please.
I think that is a correct procedure also.
ಒಂದು ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರೆ ಮುಗಿದು ಸರ್ಟನ್ or even PDO assistance are taken village ಅಲ್ಲಿ.
It is open for the executing court to take the assistance of the Panchayat Development Officer for identifying the property
PDO or any other officer,
or any other
TMC.
or any other officer to identify the property which is the subject matter of the decree.
Please.
I am appearing for the petitioner.
Sudarshanyam,
I already informed him, man.
My lord, in terms of the, my lord, the interim order of this honorable court, my lord, students are permitted to take examination.
but then
And
the
my lord,
results, what about results?
My lord, results, my lord, if my lord, please is passing any orders, my lord, we further proceed for announcing the results also.
Barcode, IA
Yes.
1 of 25 is filed by the petitioners seeking for a direction to announce the results of the examination, results of the first, second, third, and fourth semester through UUCMS
app under government.
Government of Karnataka, Department of Higher Education, Government of Karnataka. So it is contended in the application that this court granted an interim order dated 14/3/2023, staying the impugned order of the syndicate, disaffiliating the petitioner. Full stop. And the respondent number 1 was directed to permit the petitioner to admit students for the academic year 2022-23. It is contended that the total intake capacity for the academic year 2022-23 was 100 students. Thereafter, the respondent number 1 directed the petitioner to pay the eligibility fee, and accordingly, the petitioner paid a sum of rupees 17,20,000 towards eligibility fee, and the same is acknowledged by the respondent number 1. Thereafter, the students admitted had taken up the first, second, third, and fourth semester full stop. It is contended that since the petitioner has complied with all the norms prescribed by the respondent number 1 and has also received the eligibility fees, and the students of the petitioner have also faced the examination, the results may be announced. Full stop. Next paragraph. The learned counsel for the respondent number 1 submitted that pursuant to the order passed by this court, the petitioner has paid a sum of rupees 17,20,000 towards eligibility fee, and all the students of the petitioner had taken up the examination. Full stop. Since full stop. In view of the aforesaid submission of the learned counsel for the respondent number 1, and also since the petitioner has met all the criteria to enable it to admit students, it is only appropriate that the results of the examination of the students of the petitioner in respect of first, second, third, and fourth semester is announced through the UUCMS app by the Department of Higher Education, Government of Karnataka. Consequently, IA 1 of 25 is allowed, and a direction is issued to the respondent number 1 to forthwith announce the results of the students of the petitioner concerning first, second, third, and fourth semester through UUCMS app of the Department of Higher Education, Government of Karnataka. Within,
Within, my lord, next 10 days.
within 10 days from the date of receipt of a copy of this order.
Please, my lord, may I request, my lord, one more
Petitioner
word.
dispose ಮಾಡಬಹುದಲ್ವಾ?
ಅದ್ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ ಅದನ್ನು ಬಟ್ ಅಂದ್ರೆ ಡಿಸಫಿಲಿಯೇಷನ್ ರಿಲೇಟೆಡ್ ಮಿಲೋಡ್ Lord, if that is the case, after 10 days, my Lord, announcement of results, we come back, my Lord. And my Lord,
However, the results announced shall not confer any equity on the students and
Please.
shall be subject to the outcome of this writ petition.
Much appreciated.
Interim order granted in the writ petition may kindly be extended.
Interim order granted earlier on so and so is extended till the next.
My Lord, may I request, my Lord, UCMS, my Lord, it is always, my Lord, with the kind support of, my Lord, government. So, my Lord, government may also be directed to, my Lord, and give any access to, my Lord, university for such, my Lord, any difficulty.
Communicate to the US government.
But our direction idrane ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. If any such is a difficult technical difficulty.
The state government shall provide all access to the respondent number 1 to enable it to announce the results.
Please, much.
UCMS app.
Publish much, please.
Venkatesh Malwadi.
For injunction is filed by the petitioner and others, my lord. May I pass on, my lord, for a moment?
Hold.
My lord, suit annexure FJ is, my lord, challenge in this petition. Petitioner, my lord, as per annexure A, had filed suit, my lord, against the respondents 1 to 4 for perpetual injunction, claiming, my lord, that the respondents, my lord, defendants are, my lord, encroaching upon the village road.
What is challenged here?
IA order I passed on IA number 2, my lord, wherein injunction is granted to the defendants against the plaintiffs over the suit, the property of the defendant number 3, which is plot number 182, based on an alleged hakku patra.
So what is the appeal hakilwa?
Illa.
MA hakilla.
MA illa.
MA hakbekalwa?
Not the problem that has now, it is the injunction, my lord, which is granted against the against the plaintiff. Thereafter, a police protection is IA is sought. Annexure FLA.
No, that is right. Even then you have to file an appeal alwa.
Illa. A suit for injunction.
Whatever it is, order 43 rule 1R note. I will look at order 43 rule 1R.
An order under rule 1, rule 2, rule 4 or rule 10 of the order 39. Order 39, rule 4 or rule 10.
Rule 1, 2, 4,
Yes.
2A, yen
But now, if till my lord, if the appeal is filed, if what is the urgency is, my lord, it's a village road. May I just point out to, on the alleged, I have filed a memo, my lord, along with the Hakku Patra based on which he is claiming, which is a sham document. Kindly see, my lord, there is a water line. Status quo is ordered by the very same court as for IA number 1 filed by the plaintiffs.
That is for the, what you call the road.
This is also road. Now he claims, my lord, there is a water tank, there is a water line. This is a road only. He claims, my lord, based on an alleged Hakku Patra, very same 1972 Hakku Patra antare, which is also, if your lordship could keenly observe that, my lord, one for a moment. The page number 3, the Hakku Patra, Mysore Sarkara anta ಹೇಳ್ತಾರೆ, ಮಧ್ಯದಲ್ಲಿ government of Karnataka anta seal ಆಗ್ತಾರೆ.
ಏನ್ ನೋಡಿ ಯೋಚನೆ ಮಾಡಿ ಏನ್ ಮಾಡ್ಬೇಕು?
My lord, I'll file an appeal, my lord, since the order is there. Till then, my lord, if injunction is granted, This is the, problem is that law and order problem issue ಆಗ್ತದೆ. Road ಇರೋದ್ರಿಂದ, there are my
But
lord.
there's an injunction in your favor.
No. Injunction is granted to the defendant.
There's one injunction noted.
That is, my lord, the status quo to be maintained.
Okay, status.
That very same court, my lord, IA number 2 is filed by defendant number 3. Injunction is granted to defendant also.
That is in respect
Thereafter,
of-
my lord, police protection is granted, taking advantage of that. Now they are, my lord, trying to put up, with the aid of police, they are coming and encroaching upon the road. There is in fact, there is an Panchanama and PDO report also that it's a road. There is no plot number 182 as alleged in the Hakkupatra.
ನೋಡಿ, ತಪ್ಪಾಗುತ್ತೆ. I mean, it may not be correct if I pass any order.
Till then, interim arrangement anta heli it could be disposed of, my lord, with
Can I
liberty.
pass any interim arrangement without hearing them? I'm disposing of the writ petition and also granted interim relief. ಯೋಚನೆ ಮಾಡಿ.
Please.
Yes. AM Nagar.
It's appearing for the petitioner.
Preliminary hearing.
Annexure notes. Annexure E is the order passed on IA number 15.
Annexure E na?
E, page 24.
Hmm.
Is the order 6 rule 17 application came to be rejected. Reason for rejection is, my lord, it is filed after 9 years.
Yeah, what is the suit for?
Suit for specific performance, my lord.
Hmm.
Plaintiff, my lord, is not stated about the, my lord, ready and willingness to perform is part of contract. Para 5 ಆದ್ಮೇಲೆ ಅದು add ಮಾಡ್ಬೇಕಂತ ಕೇಳ್ತಾರೆ. Application is at annexure C, page 19.
ಇಲ್ಲ ಯಾವ ಸ್ಟೇಜ್ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
Defendant's evidence, cross of defendant number 1.
Cross of DW1.
Yes.
ಎಲ್ಲಿದೆ? Where's the application?
Application is page 19, annexure C.
ಓದಿ ಏನು ವಾದಿ ಯಾವಾಗಲೂ ಒಪ್ಪಂದ ಭಾಗದ ಕಾರ್ಯಕ್ಷಮತೆ ಏನೋ
ಅಫಿಡವಿಟ್
ಹೇಳೇ ಇಲ್ವಾ?
ಹೇಳಿಲ್ಲ.
ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ ಹೇಳೇ ಇಲ್ವಾ?
ಹೇಳಿಲ್ಲ. ಪ್ಯಾರಾ 5 ಆದ್ಮೇಲೆ plaint is at page number 9.
ಹೇಳಿದ್ರಲ್ಲ
ರೆಡಿ ಅಂಡ್ ವಿಲ್ಲಿಂಗ್ನೆಸ್ ಹೇಳಿ.
ವಾದಿಯು ಸಾಕಷ್ಟು ಸಾರಿ ಖರೀದಿ ಕರಾರು ಪತ್ರದ ಪ್ರಕಾರ 1 ತಿಂಗಳ ಅವಧಿ ಒಳಗಾಗಿ ಖರೀದಿ ನೊಂದು ಮಾಡಿಕೊಡಬೇಕು ಅಂತ ಕೇಳಿಕೊಂಡರೂ ಹಾಗೂ ಊರಿನ ಹಿರಿಯರ ಮೂಲಕ ಹಾಗೂ ಖರೀದಿ ಕರಾರು ಪತ್ರಕ್ಕೆ ಸಹಿ ಮಾಡಿದ ಸಾಕ್ಷಿದಾರರ ಮೂಲಕವೂ ಹೇಳಿಸಿದರೂ ಪ್ರತಿವಾದಿಯಿಂದ ಖರೀದಿ ನೊಂದಿ ಮಾಡಿಸಿಕೊಡುತ್ತೇನೆ, ನಾಳೆ ಮಾಡಿಸಿಕೊಡುತ್ತೇನೆ ತಳ್ಳಿ ಹಾಕುತ್ತಾ ಬಂದಿದೆ.
ವಾದಿಯು ಯಾವಾಗ್ಲೂ ಒಪ್ಪಂದದ ತನ್ನ ಭಾಗದ ಕಾರ್ಯಕ್ಷಮತೆಯನ್ನು ನಿರ್ವಹಿಸಲು ತಯಾರು ಇದ್ದೇನು ಅಂತ ಹೇಳಿಲ್ಲ ಅಂತ.
ಹಂಗೆ ಹೇಳಲೇಬೇಕು, ಅದೇ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹೇಳ್ಬೇಕು ಅಂತಿದ್ಯಾ? ರೆಡಿನೆಸ್ ಅಂಡ್ ವಿಲ್ಲಿಂಗ್ನೆಸ್
53
readiness and willingness can be gathered from the circumstances. Yeah. I issue notice, interim stay. In addition, so and so, interim stay of the proceedings before the trial court till the next date of hearing. List on date put. 16 C ನಲ್ಲಿ plead and prove ಅಂತಿದೆ. ಪ್ಲೀಡ್ ಅಂದ್ರೆ ಅದೇ ವರ್ಡ್ ಯೂಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ಏನಿಲ್ಲ.
Petition being agreed by the order at annexure, wherein application under order 26 rule 9 has been rejected in first appeal, my lord. On the ground that there is no any proper pleading or for what purpose the court commissioner has to be appointed. My lord, the plaintiff had filed a suit for, petitioner is the plaintiff before the trial court. Plaintiff had filed a suit for declaration and injunction against the defendants in respect of survey number 1/AA/2 measuring 7 acres 14 guntas. My lord, the alleging that the defendants are trying to encroach the property of the plaintiffs. The suit was dismissed on the ground, my lord, that I have failed to prove my title as well as the interference of the defendants.
Suit is for injunction, huh?
Suit both declaration and injunction, my lord. Declaration and injunction. If lordship looks at the reasoning assigned by the trial court at page 68. It says I have not stated anything, any genuine reasons in the affidavit to support the application. I sought for appointment of ADLR so that he is the proper person who can,
Airport notice issue, emergent notice. In addition, the learned counsel for the petition is directed to serve the learned counsel who represents the respondent number.
all respondents, totally respondent number 1 to
All the respondents,
all the response common,
the respondents before the trial court. Yeah, ಯಾವ stage ಅಲ್ಲಿ ಇದ್ದಾರೆ?
argument, my lord. It's
Final argument.
only argument, yes.
The further proceedings in RA number so and so is state till the next date of hearing. This
Please.
on date. Gopal Krishna Yadav.
Yep.
Your Lordship, I am appearing for the petitioner, Your Lordship, in this matter. This is an income tax matter, Your Lordship. Actually, against the Annex A, the petitioner has filed the appeal before the Commissioner Appeals NFSC, Lordship. But since the assing officer is demanding the impugned demand to make the payment, so requesting for the stay, we have requested before the assing officer also, he has rejected my stay. And for the PCIT for next respondent number 2 also we have filed the petition that also been rejected, but they have given the installment payment to me to make the installment payment. But genuine hardship is there, Your Lordship, with the assessee. Assessee could not able to make the payment. So with regard to that, yes, Your Lordship.
There is an assessment order.
Yes, Your Lordship.
If you want to challenge it, you challenge it in the manner known to law.
No, Your Lordship, appeal has been filed. It is pending with the Commissioner Appeals NFSC, and we are not getting the hearing notice also. So it is not getting disposed of, and there is a huge demand, Your Lordship, in this case. It has been made on the GP issue, has been they made the demand. So that impugned that 20% of the demand also very huge for the assessee. We have enclosed the bank statement also assessees.
How much will you deposit?
As of now, nothing has been deposited, Your Lordship. So I'm requesting that till the disposal of the appeal.
Madam, you can't get a blanket stay. Come up with some terms.
Minimal, we can. No, Your Lordship, is actually before the CITP is 20% is there. When appeal is pending before the CITP is 20% has to make the payment. But that also they are unable to make the payment.
Then what can be done, madam?
Just requesting, Your Lordship, till the disposal by the CITPs can be kept in abeyance, Your Lordship.
Madam, the consequences has to follow. Either you deposit. Yes, Mr. Tirumalesh.
No, notice is not served on me. And apart from that,
Mr. M. Tirumalesh is directed to accept notice for the respondent.
Interim prayer, Your Lordship.
Madam, let the other side get an opportunity.
Copy may be sent to the Commissioner.
If a grant is stayed, it's as good as allowing your petition.
No, Your Lordship, at least some still hearing notice gets assessee get the little time to make the arrangements, Your Lordship.
Please serve a copy.
Prayer can be.
Please serve a copy to the other side.
Prayer can be.
Copy may be sent to the Commissioner at Navanagar also, my lord. Copy may be directed to be sent to Navanagar office.
In addition, the learned counsel for the petition.
Yes, we'll send
a copy of the petition to the
Commissioner of Income Tax,
Navanagar, Hubli. Yes, please serve
Yes,
it.
Your Lordship.
List
We'll
on when do you want it? Next week?
2 weeks, my lord.
2 weeks, Your Lordship.
2 weeks.
But interim prayer can be considered, Your Lordship.
It is considered.
Just humble request. Next date of writ petition, next date of year, at least 2 weeks, Your Lordship.
It can't be
The interim prayer can be considered.
No, it can't be unconditional.
No, at least it's assessee petitioner will get some time to make arrangement. It's a huge amount, Your Lordship. It's around 4 crores that there is a demand.
What is the tax liability?
There is additions as 4 crore
is the-
35 lakhs, Your Lordship.
4 crores.
There is, yes, Your Lordship, that's
Ah.
the reason assessee, Miss Petitioner is unable to make the payment.
It's all
So
right.
at least one interim payment can be considered.
If you're willing to deposit 20%, I can consider. 20%, Mr. Tirumalesh.
My lords, they have not paid until now. Let me see the file. They have not, nothing has happened to them until now. And
No,
I don't know what
Your
is.
Lordship, I have enclosed the bank statement also. There is a genuine hardship is there, Your
Yes,
Lordship.
it's all right.
There,
Please let
so
it come on, let it come on 7th. 7th, I what? 7th.
13th, my lords.
Your Lordship,
7th is
till
a
that
Friday.
time, the
All
interim prayer
income
can
tax
be
matters
given.
will come on Fridays.
I see, okay, ma'am.
Yes.
Your
Is
Lordship,
Jyoti
till
SK?
that time, interim prayer can be considered.
No, madam, no interim order. Jyoti SK? There's no representation for the petitioner. List on date. Mahantesh Patil.
This writ petition is by the plaintiff.
Huh?
This writ petition is by the plaintiff in the suit
Ah.
for permanent injunction. The application under Order 39 Rule 1 and 2 is filed. But one submission, there is a mistake that I have filed instead of written statement, written arguments were filed.
Suit is for injunction.
Suit is for permanent injunction.
What is suit property?
Suit property, my lords, is an agriculture land.
Agricultural land.
Agriculture land.
Based on title or possession?
Based on the, my lords, title, what the court is, I'm not saying that my acquisition of title, that there was a GPA was executed by the mother of the, my lords, defendants, registered irrevocable GPA. Then possession was handed over. In the year 2017-18, there was a registered sale deed by the GPA holder in favor of the present plaintiff, my lords. Now the court is relying on the, my lords, the judgment of Suraj Labs. It is held that since GPA sales are not recognized under law, therefore, but however, my possession, my lords, kindly see the revenue records. Up to,
what has happened to the application for injunction?
that is rejected, my lords. Both the courts have. The entire findings were not based on the judgment of Honorable Apex Court in the Suraj Labs. Nothing has been considered regarding my possession. At page number 61, my lords. A trial court order. Para 18. 1859. Page number 59 also. But consideration of with respect to the my possession, the revenue records as on the date of the filing of suit and also earlier, there is no consideration.
Will issue emergency notice. In addition, learned counsel, so. Learned counsel for the petitioners directed to serve. The learned counsel who represents the respondents before the trial court till the next date of hearing, the parties are directed to maintain status quo in respect of the suitable property insofar as it relates to possession and the nature of the suitable property and the nature, possession and the nature. And as regards alienation, yes. Ganesh Kalaburagi.
I'm appearing for the petitioner.
So petrol dealership is permitted in favor of the petitioner as per Annexure L. There seems to be a complaint given in pursuance of the complaint of the respondent number 5. Annexure L, page 78, on 8th of October 2024, an internal correspondence between the authorities happens, where what is noted is there is a complaint saying that there is an encroachment over government land by the petitioner. And therefore, immediately there is a communication saying that it shall be, kindly see page number 78. ಸ್ಥಳ ತನಿಖೆ ಕೈಗೊಂಡು ನಿಖರವಾದ ವರದಿಯನ್ನು 3 ದಿವಸದೊಳಗಾಗಿ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿದೆ. This is the communication on 78, at page 78, on 8/10/2024, where I am not yet notified. Then on 21/10/2024,
conversion.
I have a conversion. I am the owner of the property. I have the,
Please read this document.
this says, ಮೇಲ್ಕಂಡ ವಿಷಯ ಸಂಬಂಧಿಸಿದಂತೆ ಬೀದರ್ ತಾಲೂಕಿನ ಸೋ ಅಂಡ್ ಸೋ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 3191 ಭೂ ಪರಿವರ್ತನೆ ಮಾಡಿ ಸರ್ಕಾರಿ ಜಮೀನು ಅಕ್ರಮವಾಗಿ ಅತಿಕ್ರಮಣ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ, ಭೂ ಕಬಳಿಕೆ ಮಾಡಿ ಕಾಂಪೌಂಡ್ ನಿರ್ಮಾಣ ಮಾಡುತ್ತಿದ್ದಾರೆ. ಅದೇ ರೀತಿಯಾಗಿ ಸದರಿ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಜಮೀನನ್ನು ಅಕ್ರಮವಾಗಿ ಎನ್ನೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಕೂಡಲೇ ಪ್ರಭಾವಿ ವ್ಯಕ್ತಿಗಳಿಂದ ಹಿಂಪಡೆದು ಅವರ ನಿರ್ಮಾಣ ಮಾಡಿಕೊಳ್ಳುತ್ತಿರುವ ಕಾಂಪೌಂಡ್ ಸ್ಥಗಿತಗೊಳಿಸಬೇಕೆಂದು ಹಾಗೂ ಖಾದರ್ ನಗರ್ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಅಕ್ರಮವಾಗಿ ಜಮೀನು ಪರಿವರ್ತನೆ ಮಾಡಿಕೊಂಡಿರುವುದನ್ನು ರದ್ದುಪಡಿಸಿ ಸಂಬಂಧಪಟ್ಟವರ ಮೇಲೆ ಸೂಕ್ತ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕೆಂದು ಉಲ್ಲೇಖಿತ ಮನವಿ ಮೂಲಕ ಕೋರಿರುತ್ತಾರೆ. So accordingly, a report is called for. In fact, the order of conversion is not even challenged. Thereafter, again, the very same respondent number 5 files another complaint on 21/10/2024 at Annexure M, page 79, before the Deputy Commissioner. In pursuance of this, at Annexure N, page 83, the notice for appearance is given to the petitioner on 3/1/2025 to appear on 9/1/2025.
Yes.
Now kindly see, my lords, the order at page number 88, the order sheet at page number 88.
Yes.
9/1/2025, complainant present, respondents filed, I think it is VK, Wakalatnama, VN Wakalatnama. Complainant submitted that complaint is only for encroachment removal from the government land. Office had, based on survey report, asked Tahsildar to remove encroachment from the government land. Report on the same has not been received. Send reminder to the Tahsildar and CPI for encroachment removal from government land. Regarding any approval, complaint submitted that mutation is done on 21/12/2018, whereas any order was passed on 20/12/2018. Respondents to submit objections and documents, if any, case to call 23/1/2025. So I am now asked to go into inquiry, participate in the inquiry. But before that, there is a direction to the Tahsildar and the CPI to demolish a compound wall. On the basis of a report which is not even given to me, no notice is given.
Mister, when will you give the report? ನಿಮ್ಮ ಹತ್ರ report ಬಂದಿಲ್ವಲ್ಲ?
ಇಡೀ ಎಲ್ಲ report received, my lord.
Correct or not? From the report on the same has not been received, send reminder to
Kindly see page 84, my lord.
84, ಓದಿ.
Fourth, my lord. ಖಂಡಿಕ 3 ಮಾನ್ಯರ ನಿರ್ದೇಶನದಂತೆ ತಹಸೀಲ್ದಾರ್ ಬೀದರ್ ಹಾಗೂ ADLR ಬೀದರ್ ಅವರಿಗೆ ಪತ್ರ ಬರೆಯಲಾಗಿ ದಿನಾಂಕ 10/10/24ರಂದು ADLR ಅವರು ಸದರಿ ಜಮೀನಿನ ಸ್ಥಳ ತನಿಖೆಯಂತೆ ಸರ್ವೆ ನಂಬರ್ 319/1 ಜಮೀನಿನ ಭೂ ಮಾಲೀಕರು ಸರ್ಕಾರಿ ಸರ್ವೆ ನಂಬರ್ 320 ಅಲ್ಲಿ 8 ಗುಂಟ ಜಮೀನು ಅಕ್ರಮವಾಗಿ ಮಾಡಿಕೊಂಡು ಕಾಂಪೌಂಡ್ ನಿರ್ಮಾಣ ಮಾಡುತ್ತಿದ್ದಾರೆ ಎಂದು ವರದಿ ಸ್ಕೆಚ್ ನಕಾಶೆಯೊಂದಿಗೆ ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಪ್ರಯುಕ್ತ ಮಾನ್ಯರ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಕಡತಮ್ಮ
ಸಮ್ಮುಖದಲ್ಲಿ ಮಾಡಿದ್ರಾ?
ಇಲ್ಲ, ಇದು ನನಗೆ ಏನಿಲ್ಲ,
whether the whatever report that they have done was in the presence
it is in the presence of petitioner.
No.
I have no idea.
This is, my lords, dated 10/10/2024. Notice of the proceeding is given to me on 3/1/2025.
Whether the survey was conducted in your presence?
No, not at all, not at all. Kindly see even this, the record itself will show that there is nothing to show that.
Based on internal.
That's an internal, I don't know how they entered my property without my knowledge.
AG is directed to accept notice for the respondents.
1 to 4.
1 to 4. Issue emergency notice to respondent number 5. The learned senior counsel for the petitioner submits that the respondent number 2 has instituted an inquiry to identify the government land which is allegedly encroached by the petitioner. And even before finalizing the said inquiry, he has directed the respondent number 3
And
to-
4.
and 4 to take steps to remove the compound wall constructed by the petitioner allegedly on government land encroached by him as per the report of the ADLR. Yes. The senior counsel submits that the report was not prepared in his presence and a copy of the report is not furnished to him. Full stop. In that view of the matter, the order passed by the respondent number 2, directing the respondent number 3 and 4 to demolish the compound wall constructed by the petitioner enclosing the property bearing number 3, bearing survey number, bearing converted survey number 319/1 and 2, na?
Bore 1,
No,
measuring
1
3 acre 23 guntras.
319/1 of Khadar
Khadar
Nagar
Nagar's,
village.
Khadar
Khadar
Nagar.
Nagar village,
Ila-
Kamtana, Hobli, Bidar Taluk and district is state.
My lord, both survey number, my lord. In page 87, 319/1,
319/319.
2 ಇದೆ, my lord. 1 ಎಕರೆ 19 ಗುಂಟೆ ಒತ್ತುವರಿ ಮಾಡಿ
319/1 and 319/2. Yes, list down on date. Put.
Seeking for hand delivery of this order.
Yes. Is what happened to that Illi?
Election.
Election matter. Illi, ಊರಲ್ಲಿ AG. Amaresh Rosa. What is your answer to that section 23? Section 23 of the Municipal Corporation Act. No, it is not akin to RPI. What?
Can be made up to the last date for making nomination. That's how, that is the emphasis in this subsection, in the second provision to section 23. That's not in dispute. They can, whether they can make an amendment or not, is not in dispute. What they have once not issued as voters list. The MLCs cannot now say that I am now today staying in this place. Therefore, I am my name. This has to be added as per the registration of electoral rules. My lord, that to read. First of all, section 23 deals with the electoral role of the corporation. Now, what is the voter list for the purpose of the mayor and deputy mayor's election? Is the number of members of the corporation. So, it has to be 7, not section 23 alone. Section 7 defines the constitution of the corporation.
Yes.
Section 7, unlike my lords, the voting that will happen for the purpose of electing a corporator, section 7 is the provision which deals about who are the persons who constitute the corporation. And for the purpose of voting further for choosing the mayor and deputy mayor. Section 7 says the corporation shall consist of, if I come to D, the members of the Council of State and Legislative Council who are registered as electors within the city. So this registration has to happen under the Registration of Electors Rules 1960. Now, this registration is not factually also not happened at all. Their names under Rule 23 of the relevant rules and the RP Act. Once I will also read to your lordships the relevant provisions of RP Act. It says that unless you make an application to strike off your name from the earlier constituency, and then there is a procedure saying that you have to make an application here, you will have to show that you are ordinarily resident of this region, this constituency. Then the chief electoral officer will.
He's got all the particulars.
File tandiದ್ದಾರೆ sir. My lords, as regards, there are 6 MLCs were registered, my lords. 6 member of legislative councils were registered, my lords.
Including the 4?
Including the 4.
When?
My lords, the 11/10/2024 application was filed, my lords. 23/12/2024 it was approved. There are different dates, my lords. May I take the name of Keshav Prasad, my lords, ward number 29. Applied on 11/10/2024 for registration, my lords, under the registration of election rules 1960. Lords, Ravi Kumar, my lords, ward number 12, applied on 9/11/2024. Approved on 16/12/2024.
16/12.
12.
What about Keshav?
The Keshav Prasad, the ward number 29, 23/12/2024 was approved, my lords. Tippadna Kamaknur, ward number 5, applied on 12/12/2024. Approved on 24/12/2024. Balkish Banu, Jagdev Gutedar, A. Vasant Kumar, all threes were applied on 17 and approved on 24/12/2024.
Applied on 17th.
17/12/2024.
Bilkis Banu and the 4 others.
Bilkish Banu, Jagdev Gutedar, A. Vasant Kumar.
Who is the other one? Who's the other one?
Tippanna Kamatnur, 12/12/2024, approved on 24/12/2024.
Yeah, why did this name not, why was this name not found in the electors list?
Let's kindly see, my lords. On 24/12/2024, Annexure E, my lords, wherein Commissioner forwarded a voter list to the regional commissioner, including Keshav Prasad and Ravi Kumar, my lords. 2. The 4 were left out, my lords. Later, my lords, they made an application saying that these 4 also got it registered under the rules 1960, therefore requested to include their name also. Please, my lords. ಅವ್ರು ನಿನ್ನೆ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಹಾಕಿದ್ರು, ಅದರಲ್ಲಿ ಇತ್ತು.
Additional documents.
4 ಜನದ ಸೇರಿಸ್ರಿ ಅಂತ.
Memo filed yesterday by me. Document number 5 is what is referred to by my friend.
They requested to include their name, my lords. Therefore, my lords,
Where is document of 5?
Document number 5, page
5.
8. It's the typed copy of that page number 7.
6-1 ಅಂತಿದೆ, 24.
This is Karnataka Pradesh Congress Samiti.
Samiti.
What is the date? 6-1.
6/1/2025.
6/1. 6/1. Lords, on 7/1/2025, lords, Commissioner included these 4 names and forwarded to the regional commissioner.
Where is that document to show that these people have applied and it was considered?
Please, lords, there is entire file.
And whether their names were deleted from the other places where they were found?
Lords, as regards other places is concerned,
I have filed another memo showing their names are continued. As on 8th of January 2025.
It goes to show that your stage managed the whole thing.
I am told that, my lords.
Will include ಮಾಡಕ್ಕೆ order ಮಾಡಿದ್ರೆ, you said it was approved.
Please.
On 24/12. If it was approved on 24/12, corresponding steps must have been taken for deletion of their names in the other places.
Please, lords.
Whether it's
Out
taken.
out of these 8 MLCs, my lords, except Ravi Kumar, in all other cases, my lords, the objection was filed, matter was heard, later approved, my lords. I am told that.
ಕೊಡಿ ಅದೆಲ್ಲ ಇದ್ರೆ ಕೊಡಿ.
My lord, in this case, made application by the concerned party, that along with an application I'm submitting, my lord, they
I
accepting
think the
this.
matter needs to be heard. Will permit you to vote, but it will kept separately.
My lord, my submission, my lord, in this case, the permitted is anyhow, that's a declaration by the state concerned, my lord. This all the voter, they are entitled. So that's what ultimately we are expecting.
Permit the election, the voters to exercise the.
Yes, ma'am.
There is-
In the connected matter, my lords, there was a direction, my lord, directing me to serve the copies of the writ petition and, my lord, through the commissioner. That order has been complied, my lord.
ಯಾವ್ದಲ್ಲಿ?
In the connected matter, WP number 203601,
ಹಾ.
previous hearing date, my lord, your lordship was pleased to direct that notice, my lord, be served to the individual corporators through the commissioner, my lord, of CM.
Yes, sir.
That is, my lord, done.
My lord,
Acknowledgement, my lord. 3 or 4 of them have refused. I have sent, my lord, the notice by RPID, my lord.
Yeah,
my lords,
you save your skin.
My lord.
You save your skin.
lords, whether these 6 recently included MLCs, whether they are eligible to vote in the ensuing mayor and deputy mayor elections or not, lords, but my submission before this court is the corporators who are now, lords, elected, they are not, lords, they have no, lords, not continued to be a corporators of the corporation by virtue of section 18 and 19. Section 18, lords, it states that, lords, within 1 month from the date of taking of office, lords, they have to take oath of allegiance. Section 19(2), lords, it contemplates that within one month from the date of taking, lords, office, lords, they have to declare their assets and liabilities before the corporation. Both these conditions have not been complied. And they, by operation of law, my lord, they cease to, lords, continue as the members of the corporators of the 4th respondent corporation. My lords, I may kindly be permitted to read section 19(2), lords.
How many corporators have not taken oath according?
None of them.
None of them.
Yes, none of
35.
all the 35.
All.
Tondilla, Swami. And lords, and none of them have declared their assets. Section 19, lords, I will first take my lordship to section 19. Every councillor referred to in clause A of subsection 1 of section 7 shall, not later than 1 month after commencement of his term of office and in the same month of each succeeding year, file with the mayor a declaration of assets owned by him and any members of his family. Such declaration shall form part of the corporation records. If any councillor fails to file the declaration referred to in subsection 1 or files the same knowing it to be false or incorrect, he shall cease to be a councillor. So within 1 month, all the corporators, they have to, my lords, declare their assets.
When were they elected?
9/1/21, 9/1/24, they took, my lords, assumed the office. So before 9/2/2024, they should have submitted details of their assets with the corporation.
Yes.
And lords, and in every succeeding year, lords, they should have again, lords.
Yes, Sachin.
My lord, 9/1/2024, my lord, oath has been, my specific instruction is, my lord, on 9/1/2024, oath has been administered, my lord, to all the members. Insofar as assets and liabilities are concerned, my lord, they are collecting the details. As soon as, my lord, they get the details, my lord.
It is a matter of record.
ಮತ್ತೆ ಇರ್ಬೇಕಲ್ವಾ?
Instruction, my lord, to me is, my lord,
Now, whether you lodge any complaint or anything like that before the.
I have given representation to the commissioner in the month of November. No action is initiated. And there is one judgment of the, and my lords, permitting them despite being aware of the fact they have ceased to be the members, it is an offense under the act.
Yes.
They cannot be do, my lords, one judgment of this honorable court where similar question arose. Yes. Now, my lords, 35 ineligible corporators, my lords, they are electing mayors and deputy mayors who are also ineligible. My lords, I may be permitted to read from page number 7, paragraph 2. As the above prayers make out, the learned counsel for the petitioner submitted that all the private respondents are liable to be ousted from the office of councillors of respondent municipal corporation, that is BBMP, since their membership ceased on its own in terms of section 19 of Karnataka Municipal Corporations Act 1976. They having failed to declare all assets owned by them and any members of their family. He further submitted that at least in the alternate, the officials respondents are liable to be mandamus to consider his client's representations, copies whereof avail at Annexure F dated so and so and Annexure J dated so and so, wherein he has requested to immediately disqualify all the councillors considering violation under KMC Act 1976 and to immediately stop the disqualified councillors from holding the elected office.
Let them vote, we'll keep everything in suspended animation. Vote madli, ella separate idli. We'll consider the whole case.
Milords, it is a, Milord, one small submission, Milords, one small submission. Filing of, Milord, submission of declaration of assets is a matter of record. It is not that, Milords, they can get it by tomorrow morning, Milords, and if it is there, Milords, matter could.
Because we have submitted the authority consent. We have already submitted the assets. So we have a report regarding the assets. Now their own document shows how the false submission is being now made. That proceedings were attended by these persons in the page number 25, may kindly be seen.
Oh, what is there to show that you have declared the assets?
Yes.
That's we have to produce. We were asked to appear through the commissioner. We have not been served with the notice. As on today, we have not been served with the copy of the petition also.
Yes.
Kindly peruse, Milords, my.
Yes, you have to tell us whether they have given the statements of assets and liabilities.
no, and so far the first leg of the submissions, my lord, whether the oath is administered, my lord, specific instruction is, my lord, that the oath is administered on 9/1/2024. Regarding assets and liabilities, my lord, I am awaiting, my lord, for the instructions, my lord, of the.
Yavaga, nale.
May I make one submission? That question, the very contention that there are assets not declared, cannot be now, my lord, urged here before this honorable
No,
director.
that is right, but the
Can
question,
only be kindly see, my lord, subsection 3 of section.
that is right,
19.
it is the commissioner who has to decide.
Not the commissioner, it is the government, and section 26 will
No,
come
no.
into picture.
No, Milords, I will
Section
read.
96 has to be read. No, this is an attempt to scuttle the entire.
No, I will, no, I will, Milords, I will read the entire judgment. I will read the entire judgment.
There is a purpose of section 19.
Yes, 19 and 26 my lord, have to be read. There has to be a decision upon the.
Therefore, question is this, when he has made a complaint, right or wrong, he has made a complaint. Shouldn't there be an inquiry?
It cannot be kindly permit. me
Oh,
to
the-
read this.
Hmm.
Look, subsection 3 of 19 and section 23. I will first read
Yes.
subsection 3 of 19.
Yes.
Any question whether disqualification under subsection 2 has occurred shall be decided on reference made by the corporation, by government, and the decision of government thereon shall be final. There is no question of anybody giving a complaint.
Correct. Question is this, if the commissioner does not, or the corporation does not take any steps,
Then
he has lodged a complaint, right or wrong, he has lodged a complaint. It was incumbent upon the corporation
yes,
to have looked into it and must have referred it to the government.
not the commissioner. Commissioner is. not-
Corporation.
Corporation has to.
So they must have looked into it.
Then one section 26 will come.
What?
You cannot now stand up and say that I have given a complaint to the corporation.
What?
They did not look into it, therefore everybody is disqualified.
What?
Section 26
Hmm.
is about general disqualification for becoming a councillor.
Hmm.
This says a person shall be disqualified for being chosen as and for being a councillor. There are several such up to A to J. Provided that no person shall be disqualified on the ground that is less than 25 years, and thereafter, my lord, we'll see after O. O, there are subclauses 1 and 2, unless a period of 6 years has elapsed since the date of finding, or the disqualification has been removed by order by the government. So here also it is the order of the government. 19(3) speaks of government. 26 speaks
No,
of
this is
government.
not disqualification.
He is saying, my lord, that.
It's not a case, no. It's a case of seizure,
Seizure of the cessation of the.
cessation of the office.
Shall be by the government.
Therefore, question is this, if the government sits over the representation, corporation also sits over the representation,
Yes.
what is it, what should happen?
The government can be directed, my lord, to look into the complaint. That's another aspect of it. But then he cannot say the entire proceedings of the corporation shall stand still.
Illa, this
Say that, let us examine this, let us examine.
this very,
But
my lord,
the election
submission,
should be stopped.
this very submission has been clarified in that judgment, my lords.
Barkul.
It is by operation of law that they cease to be members of the
Orders
corporation
on interim prayer
in my writ petition.
in both the petitions, in WP number so and so and WP number 203601 of 2024. Go to
But-
ಎರಡು file. First file ಕೊಡ್ರಿ. First file ಇದು. The petitioners in WP number 203968 of 2024 are aggrieved by the action of the respondent number 1, 2 and 5 in attempting to include the name of or a parties ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ?
Illa, they are not parties
Not-
because
they are not
petition,
party, my lord. They are
petition
not
is
party.
filed for the purpose of saying that 1 month before the date of lapse of the earlier election, they have to conduct the election.
You know, the petitioner in the petition WP number 203968 of 2021 has sought for a writ in the nature of mandamus to consider a letter hearing number so and so forwarded by the respondent number 4 and to and 4 standing committee members of the Vijaypura City Corporation. By way of an interim prayer, the petitioner has sought for a direction to the respondent number 5 not to alter the voters list for this 22nd term election of the mayor and deputy mayor to Vijaypura City Corporation. As per his letter bearing number so and so dated 24/12/2024. We'll stop. Next para. The petitioner contends that the respondent number contends that the respondent number 4 had addressed a letter dated 24/12/2024 to the respondent number 2, enclosing therewith a list of voters at the list of voters for the 22nd term of mayor and deputy mayor. However, after finalization of the said list of voters, the respondent number an attempt is made to include the name of 4 members of the Legislative Council on the premise that they are residing within the limits of the corporation. Full stop. It is therefore contended that such act of attempting to include the names of the members of the Legislative Council is not permitted under the Register of Electoral Rules 1960. Full stop. Per contra, the learned counsel for the respondent number 4 submits that under section 23 of the Karnataka Municipal Corporation Act, the electoral roll would be revised till the last date for filing the nomination. Full stop. He contends that the 4 members of Legislative Council had made appropriate requests before 24/12/2024 and their names were approved to be included in the list of voters on 24/12/2024. He contends that by mistake, their names were not included in the voters list, which prompted the political party to which they belonged to address a communication dated 4/1/25, 6/1/25, include their names in the list of voters, following which steps are taken to include the names of those members of the Legislative Council. Full stop. Therefore, the aforesaid contentions, throw up substantial questions of law which needs to be considered. However, since the elections to the post of mayor and deputy mayor for the 22nd term is round the corner, that is on 27. On 27/1/2025, it is appropriate to permit the voters whose names are found in the list prepared by the respondent number 5 as on
24.
as on Nindeli,
Petition copy.
7/1/25.
as on 7/1/25. However, the same is subject to the following conditions. Number 1, the votes cast by the 4 members of Legislative Council, namely Mr.
Tippannappa Kamaknur, Balkish Banu, Jagdev Guttedar, A. Vasant Kumar.
Namely, number 1, Tippannappa Kamakanura. Number 2, Jagadev Guttedar.
Please.
Number 3, Srimati Balkis Banu. And number 4, Vasant Kumar A. shall be received and kept in a separate box.
This is by raise of hand, madam. This is by raise of hand.
Raise of hands.
Therefore, it should not be, it can be counted, but not,
It
it should not be counted.
the votes, the votes cast by the votes cast by the members of Legislative Council, namely Tippannappa Kamakanura, Jagadev Guttedar, Balkish Banu, and Vasant Kumar A. shall be recorded but shall not be counted for the purpose of, shall not be counted, full stop. This shall be subject to the full stop. The votes so cast, number 2, the votes so cast shall be counted after further orders of this court. Next para. The petitioner in WP number 203601 of 2024 has sought for a writ in the nature of quo warranto to declare that the councillors who are elected, councillors of the respondent number 4 corporation who are elected have ceased to be councillors in view of they not complying the mandate of section 19 of the Karnataka Municipal Corporation Act. It is also contended that a complaint in that regard was lodged by the petitioner. Who is the petitioner?
Ex-corporate.
Petitioner before the corporation, and that the corporation has not taken any steps to consider the question whether the elected councillors had submitted their statement of assets and liabilities. Full stop. The learned counsel for the corporation is not able to readily place information before this court as to whether the councillors of the respondent number 4 corporation have filed the statement of assets and liabilities as prescribed under section 19(1) of the Karnataka Municipal Corporation Act 1976. Full stop. If that be so, comma, if that be so, comma, the question whether they have ceased to continue in office or not, and the corporation has to be hauled up for not taking any action against the councillors as provided under section 19(3) of the Act 1976 or not, have to be gone into in this writ petition. Full stop. Therefore, by way of an interim order, comma, this court directs the respondent number.
It's 239.
Huh?
239.
ಅಲ್ಲಲ್ಲ ಯಾರು ಎಲೆಕ್ಷನ್ ಕಂಡಕ್ಟಿಂಗ್ ಆಫೀಸರ್ ಯಾರು?
Commissioner.
Number 4.
ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ?
Regional Commissioner.
ಏನಾಯ್ತು? The respondent number 3 is directed to count the
Declarations regional commissioner, election conducted by the commissioner of municipality only. A date of
Local
events is
commissioner.
given by the commissioner.
shall count the shall record the votes cast by the respondent number
6 to 39.
6 to 39. What should happen to the result then?
That's
That-
what
that can be
judgment
declared-
subject.
That can be declared subject to the result of this court.
No. 6 to 39 ಇದಾಯ್ತು ಅಂದ್ರೆ ಅವ್ರದ್ದಾಯ್ತು ಇವ್ರದ್ದಾಯ್ತು ಇಬ್ರು ಸ್ಟಾಪ್ ಅದು
ಇಲ್ಲ, 6 to
That-
39, they are
otherwise, my lord-
ex-corporators, my lord. They are ex-corporators. They have lost their identity under the enactment as also with the mandate of the
No,
people.
60 39 are the sitting
Sitting corporators.
So ಅವ್ರು ಹೋಯ್ತು ಅಂದ್ರೆ ಹೆಂಗ್
Petitioners are the ex-corporators. They have absolutely no locus standi to even file a
that
complaint.
is okay. Councillors, if their votes are not counted,
ಹೌದು.
the MLC 4 votes are not counted. What has to be
ಮೀಟಿಂಗ್ ಆಗಲ್ಲ,
declared?
ಮೀಟಿಂಗ್ ಆಗಲ್ಲ. ಅದಕ್ಕೆ
That's what,
The vote, they can raise their hands and
ಹೌದು.
indicate their votes. But the results of the election shall be subject to the outcome of this
ಅಷ್ಟೇ,
petition.
subject to the outcome.
ಅಲ್ಲ ಡಿಕ್ಲೇರ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ ಅವರು.
Declare ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ ಅದನ್ನ that.
It may be, my lord, my request is this. Let, my lords, 4 MLCs, there shall not be a counting of their votes. The remaining existing corporators, let their votes be counted and the result be declared, which shall be subject to the result
No,
of this court.
results also.
Now
not
the ex-corporators, my lords, cannot.
13. ಆಯ್ತದ respond number 6 to
39.
39 number 39. The results of the election to the post of mayor and deputy mayor shall be declared only after disposal of this writ petition.
My lord, that will, my lords, if you are
Let
not,
that happen.
let there be a stay of that, my lord. What I am submitting is, if you are not.
We
sitting
also
after the
no
disposal of
objection,
the
my
writ
lord, if
petition,
it's a
that
stay
they
election.
may drag it on, my lord. We are not even parties in that.
I will not allow it to be dragged on.
That is true, but then
We'll
they
take
will
it
make
up-
attempts, my
We'll
lords, to
take
do all.
it up on a day-to-day basis.
Your lordships will then fix a date, my lords. Fix a date so that
On
at least
28th. Yes,
28.
28th.
Great.
Let the election happen.
Let that,
29th
let that, my lords, be placed before your lordships by
Yeah,
28th. All the
Malad-
whatever is the counting made, let
Corporation,
that counting be
Mr.
placed
Rosa.
before your lordships.
That instead
Amresh
of
Rosa.
28, that instead of 28, 29, Malad.
ಇದೆಲ್ಲ ತಂದ್ಕೊಡಿ. ಇದು Sachin Mahajan, sorry, Sachin Mahajan. Produce all the material.
Malad, instead of 28, 29, Malad.
Let that be recorded, my lords, that the Mr.
20.
Sachin Mahajan, he may,
Totally first let him bring it.
that bring ಅಂತ ಹೇಳಿ ಒಂದು recording.
Learned counsel for the respondent corporation in WP number.
4.
In WP number, R4 in WP number 203601 of 2024 is directed to secure the records relating to the declaration of assets and liabilities by the corporate, by the councillors.
And also the meeting proceedings, man. The meeting of
ಯಾವ್ದು?
27th. Meeting proceedings ಇಲ್ಲಿ ಬಂದ್ರೆ only then your lordships.
ಮತ್ತೆ ಅದಿರ್ಲಿ ಅಲ್ಲೇ ಇರ್ಲಿ ಬಿಡಿ, how does it matter?
ಇಷ್ಟ
28th, call on 28th.
Provide hand delivery of the.
Sorry.
The documents are placed before your lordships, that may be given so that we can have look at it.
ಅದು ಏನೇನು ಕೊಟ್ಟಿದೆ, everybody has given loose papers, nobody has given a memo, ಸುಮ್ನೆ loose papers ಯಾಕೆ? ಯಾವುದು? 77 ಅಲ್ಲ? 77 ಅಲ್ಲ?
ಅದು 2 ರಿಟ್ ಇದೆ, ಯಾವ್ದ್ರಲ್ಲಿ?
ಆಯ್ತು, ವಕಾಲತ್ ಫೈಲ್ ಯಾರಿಗೆ ಮಾಡಿದಿರಿ? ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದಿರಿ? ಆಯ್ತು, ಇರ್ಲಿ ತಮ್ಮ. The office is directed to show the name of Mr. Manvendra Reddy as the counsel for respond number 9, respond number 6, 9, 13, 21, 23, 25, 28, 30, 29, 32, 33, 34, 35, 37, 38. ಎಷ್ಟಾಯ್ತು ನೋಡಿ? 3, 4, 5, 6, 7, 8, 9, 10, 15 ಇದೆ ನೋಡಿ.
That
77.1 ಅಲ್ಲಿ.
that instead of 28, Malad, 29th.
ಅವ್ರೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿ, ಅವ್ರು ನೋಡಿ ನೋಡೋಣ. 28th will be what date? Monday.
28, that is Tuesday, Malad, we are in the Nice Road part in Supreme Court.
ಆಯ್ತು, ಅವ್ರು ಕೇಳಿ 29th ಅಂದ್ರೆ 29th ಆಗ್ಬೋದಾ?
29th.
29th.
Already, Malad, elections have been delayed for 1.5 months.
Malad, but
The term of the
27th
chair will be
is
only 1 year.
next day.
Malad. Already we have lost 1.5 years.
Elections is already
1.5
over,
month is
1
already-
day we are.
29th.
Mature.
Let it come on.
Even before date is okay for us, if Lord permits.
ಹಾ?
Even before 28th is fine for me.
ಏನಿಲ್ಲ.
ಸಂಡೇ ಬರ್ತೀರಾ
Because
ನೀವು?
23rd is the election, Malad.
ಅಲ್ಲ, are you willing to come and Sunday and argue?
No, 27th
27th is the
will-
election. 27th is the election.
Elections.
You-
29th
I
of-
listed
29th.
He wants it on 29th.
Please.
List on 29th.
Malad, direction may be given, Malad. What they have submitted today, Malad, we served upon us.
ಯಾವುದು?
One set of documents they have.
ಏನ್ ಕೊಟ್ಟಿದ್ರು? ಏನು ಕೊಟ್ಟಿದ್ರು? Nothing was given.
ಇಲ್ಲಿ ತಂದಿದ್ವಿ, ಮುಗಿತಲ್ಲ ಆರ್ಡರ್ ಅದು.
Amresh Rosa ಅವರು submit ಮಾಡಿ.
ಏನ್ ಕೊಟ್ಟಿದ್ರು?
ಒಂದು bunch
ಏನು ಕೊಟ್ಟಿದ್ರು?
Oh, please.
They only gave the dates when they filed the application, when it was approved.
Please.
That's correct.
Great.
Yeah, Malavati.
Serial number 43 may not preliminary hearing.
Ah.
Your lordship may not, the first prayer would be may not MA remedy is there. But the second prayer with respect to police protection, if that could be considered, my lord, because at least status quo as on today should be, which is already ordered in IA number 1. Because they are now, my lord, I'm told they are putting up construction or by blocking the road.
ನಿಮ್ದು ಇಂಜೆಕ್ಷನ್ ಇದೆಯಲ್ಲ, ಟೇಕ್ ಅಡ್ವಾಂಟೇಜ್.
They have police protection. They are taking up police and coming up, my lord, in the
ಏನ್ ಸೆಕೆಂಡ್ ರಿಲೀಫ್ ಏನ್ ಕೇಳಿದಿರ?
Second relief is, my lord, an IA number 3 is filed seeking police protection, saying that to implement the injunction, but in the grab of that, they are putting up construction.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್?
Annexure, yes, my lord, page 58.
ಬರ್ಕೊಳ್ಳಿ, ಇಶ್ಯೂ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್.
Only respondent number 1 is the contesting party. Defendant number 3 IA.
ಇಶ್ಯೂ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್
1.
1.
He is the only person who has filed IA. IA number 3, 2 is filed by only defendant number.
ಇದು ಮೆಮೊ ಕೊಡಿ ಹೆಂಗಿದೆ?
I'm filing memo.
A memo is filed seeking dispensation of notice to other
All other
respondents.
response.
Hence, notice to the other respondents is dispensed. Next para. Since the trial court has granted an order of injunction in favor of the trial court has passed an order dated 15/4/2024 directing maintenance of status quo in respect of a public street which has a water pipeline running underneath.
Yes, yes, madam.
ಕೆಳಗಡೆ
ಹೌದು, ಅಲ್ಲ ಅಂಡರ್ ಇಟ್ಟು ಇದೆ, ಮೇಲೆ ಟ್ಯಾಂಕ್ ಇದೆ. ಪ್ರಾಪರ್ಟಿ ಆ ವಾಟರ್ ಟ್ಯಾಂಕ್ ಇದೆ, ಕೆಳಗಡೆ ಎಂಟೈರ್ ಲೇಔಟ್ ಗೆ ಲೈನ್ ಇದೆ ಇಡೀ ಇದಕ್ಕೆ.
underneath. And at the same time has granted an order of injunction restraining the plaintiffs from interfering with the possession of the defendant number 3 on plot number 182 situated survey number 71, comma, it ought not to have considered the request of the defendant number 3 for police protection to interfere, for police protection to protect him to implement the order of injunction granted in his favor. Ought not to have, the trial court must have been slow in granting an order directing the police to grant protection to implement the order of temporary injunction. In that way of the matter, till the next date of hearing, comma, interim stay of the order dated 6/1/2025 passed by the first additional civil judge and JMFC Roman 2 Bidar in OS number 217/2023. List on date.
Memo dispensation ka memo de to. But if it be upload hand delivery, if I can see.
Lakshmi Menon. Lakshmi Menon. Girish Pulmani.
Please, my lord. Please, my lords.
Lakshmi Menon. Lakshmi Menon. There is no representation for the petitioner as a last chance list on date. Anand Jagirdar.
Yes.
Sudhir Singh
This
Vijapur.
is the matter pertains to the refund of the claim of my refund of tax, which is inadvertently paid, your lordship.
Mistakenly paid.
Mistakenly paid.
Sudhir Singh Vijapur.
So he is the contesting.
Who's
My lords.
online.
Yes,
I represent the respondent number 2, my lords.
Ready?
My lords, any next week, any date, my lords?
ಯಾಕ್ರೆ ನೀವು ಗುಲ್ಬರ್ಗಾಗ್ ಯಾವ ಕೇಸು ರೆಡಿ ಆಗಲ್ಲ ನೀವು?
My lords, please, my lords, next week I will surely get ready, my lords.
No, next week, what about this week?
My lords, sorry, my lords. I apologize.
No, correct, but nothing is happening. What does sorry do?
My lords, the difficulty is that, my lords, we have been given the additional charge of the Gulbarga bench matters also, my lords.
No, you should be happy that you are dealing with 2 benches matters. You should be happy.
Please, my lords, but due to some miscommunications, my lords, these difficulties are being faced, my lords. I'll get ready, my lords, by next week.
No, you are getting money from two benches, sir. You should be
My
happy.
lords. Sorry, my lords. Next time I'll surely get it ready, my lords.
Right, you know what? Yes.
Next week,
Same date, my lords, 49 and
Sixth.
50.
Whatever date that you people want.
Please,
6th,
my lord. Much obliged.
31 years, next to next, 6th it may kindly.
51.
6th,
ಯಾವ ಡೇಟ್ ಆದ್ರೂ ತಗೊಳ್ರಿ ಟೇಕ್ ವಾಟ್ ಎವರ್
Sure.
ಅಲ್ಲಿ ನೋಡಿ ಹಾಕಿದೀವಿ ಅದ್ರ ಡೇಟ್ ಯಾವ್ದಾದ್ರು ತಗೊಳ್ಳಿ 51
My lord, 51,
huh?
GMCPC file has been misplaced, my lord. Next week,
Learned counsel for the learned AGA seeks time list on ಇದೇನ್ 2016 ಪಿಟಿಷನ್
ಎಲ್ಲ
ಅಟ್ಲೀಸ್ಟ್
ಅದೇ ಅದು ಏನಿದೆ ಅಂತೂ ಗೊತ್ತಾಗ್ತದೆ.
ಯಾರು HM ಪಟೇಲ್ ಗುಲ್ಲಳ್ಳಿ HM ಪಟೇಲ್ ಗುಲ್ಲಳ್ಳಿ ಯಾರ ಅಮೆಂಡ್ಮೆಂಟ್ ಆದ್ರೂ ಮಾಡ್ರಿ ಇದೇನಾದ್ರು ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ learned AGA seeks time list on date.
This matter may be disposed of, lords, as not pressed.
Learned counsel for the petition has filed a memo to dispose of the petition as not pressed. In view of the memo, the petition is disposed of, dismissed as not pressed. Dismissed as the same is not pressed. Somebody. Dismissed as the same is not pressed.
Before I appear for the petitioner. Notice
Sanjay
application.
Patil. Yes.
Application number 26 rule 9 lots is sought for
26
appointment
rule
of
9.
court commissioner. Yes. my
Suit
lords.
is for what?
Suit is for relief of permanent injunction lots.
What is the suit property?
Suit property is a open lots constructed house.
Open constructed house.
Constructed house on a plot. Plot lots measuring. Measurement. There was inference being caused by the respondents herein. Lots that there is an encroachment to the extent of 8 feet by 4 feet. As such, my lords, cause of action arose and suit was filed. Subsequent, my lords, the defense of the defendant was, my lord, such that there is already a survey report that stating that there is an alleged encroachment, my lords, of 8 feet by 4 feet. Further, in the cross-examination of the surveyor, it was brought to the notice that, my lords, prior to the such survey report, 2 other surveys were conducted, and in such suspicion, my lords, an application came to be filed by the plaintiffs, not seeking for a fresh survey report. Because the survey was not conducted at the instance and direction of the court, it was, my lords, on an application by the defendant himself to carry out a survey. The
But ನೀವು ಅದೇ
cross-examination.
city surveyor ನ ಕೇಳ್ತಿದ್ರಲ್ಲ.
Please, my lords.
You're asking for a city surveyor to do it.
Yes, my lords.
Who was the earlier surveyor? Was it a city surveyor?
Yes, it was himself, but then, lords, the difference of opinion arose, my lords, when he states that there were 2 other earlier surveys conducted, wherein, my lords, the land of the defendant was not properly measured. And there was no such encroachment earlier in the earlier 2 surveys conducted. Further, on the 3rd survey, my lords, it was reflected that there is an encroachment by the plaintiffs to the extent of 8 feet by 4 feet.
ಯಾರು
In the
CW1
cross-examination, please.
CW1 ಯಾರು? Who is CW1? Who summoned him?
He is the city surveyor, my lords.
Correct.
actually.
Who summoned him?
Court summoned him.
Then,
Lords, he is the witness, my lords.
correct. Court has summoned him. CW1 ಯಾರು?
Allah, he is the witness of the defendant.
How can he be the witness of the defendant? Then he'll be.
Although, my lords, the court has summoned him, but because it is not at the instance of the court that he has conducted such a survey. It was an application. In the cross-examination cross-examination also, it reveals that, my lords, there was an application made by the defendant to that effect. May I read the relevant portion in the cross-examination? 1, 2, 3, 4, 5. Sixth line, my lords, in the cross-examination, page 29.
29.
Page 29. And in the survey also, my lords, he has surveyed only the plot of the defendant and not the plot of the
Where is the evidence of CW?
ಕ್ರಾಸ್ ಇದೆ. ನಾನು ಪ್ಲಾಟ್ ನಂಬರ್ 309/94ಕ್ಕೆ ಮಾತ್ರ ಅರ್ಜಿ ಬಂದಿದ್ದರಿಂದ ಹದ್ದುಬಸ್ತು ಗುರುತಿಸಿದ್ದು ಸದರಿ 309/94 ಅಳತೆ ಮಾಡುವುದಕ್ಕೋಸ್ಕರ ಎಲ್ಲ 8 ಪ್ಲಾಟ್ಗಳನ್ನು ಅಳೆದಿರುತ್ತೇನೆ. ಆದರೆ ಹದ್ದುಬಸ್ತು ಮಾತ್ರ 309/94ಕ್ಕೆ ಮಾತ್ರ ಗುರುತಿಸಿರುತ್ತೇನೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಸದರಿ ಹದ್ದುಬಸ್ತು ಕುರಿತು ಪ್ರತಿವಾದಿ ನಂಬರ್ 1ರಿಂದ 3ರವರು ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ನಾನು ಅರ್ಜಿಯ ಮೂಲ ಪ್ರತಿಯನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿಲ್ಲ. 309/94 ಹದ್ದುಬಸ್ತು ಕುರಿತು ಪ್ರತಿವಾದಿಗಳು 1 ಬಾರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ನಾನು 309/94ಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ 3 ಬಾರಿ ಅಳತೆ ಮಾಡಿರುತ್ತೇನೆ. ಆದರೆ ದಿನಾಂಕಗಳನ್ನು ಹೇಳಲು ಬರುವುದಿಲ್ಲ. ನಾನು ಅಳತೆ ಮಾಡಲು 1 ಬಾರಿ ನೋಟಿಸ್ ನೀಡಿರುತ್ತೇನೆ, 3 ಬಾರಿ ನೋಟಿಸ್ ನೀಡಿರುವುದಿಲ್ಲ. ಮೊದಲು 2 ಬಾರಿ ಅಳತೆ ಮಾಡಿದಾಗ ನಿಖರವಾಗಿ ಅಳತೆ ದೊರೆಯದೆ ಇರುವ ಕಾರಣ 3ನೇ ಬಾರಿ ಅಳತೆಯ ಸಂದರ್ಭದಲ್ಲಿ ನಿಖರವಾಗಿ ಅಳತೆ ಗೊತ್ತಾಗಿರುತ್ತದೆ. ದಿನಾಂಕ 25/4/2017 ಅಳತೆ ಮಾಡಿರುತ್ತೇನೆ ಎಂದು ನನ್ನ ವರದಿಯಲ್ಲಿ ನಮೂದಿಸಿರುತ್ತೇನೆ. ದಿನಾಂಕ 25/4/2017 ಅಳತೆ ಮಾಡಲು ಪ್ಲಾಟ್ ನಂಬರ್ 309/94ಕ್ಕೆ ಹೋಗಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಮೊದಲಿನ 2 ಬಾರಿ ಅಳತೆಯ ಸಂದರ್ಭದಲ್ಲಿ ವಾದಿ ಪ್ರತಿವಾದಿಯರ ಪ್ಲಾಟ್ಗಳ ಅಳತೆ ಸರಿಯಾಗಿತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಪಕ್ಷಗಾರರಿಗೆ ನೀಡಿದ ನೋಟಿಸಿನ ದಿನಗಳಂದು ಅಳತೆ ಮಾಡಿ ಸರಿಯಾಗಿವೆ ಎಂದು ಹೇಳಿ ಹೋಗಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಫರ್ದರ್, ದಿನಾಂಕ 17/5/2017 ನಾನು ನೋಟಿಸ್ ನೀಡಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿ. ಸದರಿ ನೋಟಿಸ್ ಅನ್ನು ಸಾಕ್ಷಿ ನೋಡಿ ಗುರುತಿಸಿದ್ದು ಅದನ್ನು ನಿಪಿ 11 ಎಂದು ಅಂಚೆ ಲಕೋಟೆಯನ್ನು ನಿಪಿ 12 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ದಿನಾಂಕ 28/5/2017 2ನೇ ಬಾರಿ ನೋಟಿಸ್ ನೀಡಿರುತ್ತೇನೆ ಎಂದರೆ ನನಗೆ ನೆನಪಿರುವುದಿಲ್ಲ. ದಿನಾಂಕ 28/5/2017 ಮರುದಿವಸ 3ನೇ ಬಾರಿ ಅಳತೆ ಮಾಡಲು ಹೋಗಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿ. ನಿಧಿ 1 ದಿನಾಂಕ 28/5/2017 ಮಾಡಿದ ಸರ್ವೆ ಆಧಾರದ ಮೇಲೆ ತಯಾರಿಸಲಾಗಿದೆ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿಗೆ ಒಂದು ಫೋಟೋ ತೋರಿಸಿದ್ದು ಅದರಲ್ಲಿ ತೋರಿಸಲಾದ ಕಲರ್ ನಾವೇ ಹಾಕಿರುವುದಾಗಿ ನುಡಿಯುತ್ತಾರೆ. ಸದರಿ ಫೋಟೋವನ್ನು ನಿಪಿ 13 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಸದರಿ ನಿಪಿ 13ರಲ್ಲಿ ತೋರಿಸಿದ ಕಲ್ಲಿನಿಂದ ಅಳತೆ ಮಾಡಿದಾಗ ಪ್ಲಾಟ್ ನಂಬರ್ 309/94 ಸರಿಯಾಗಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ವಾದಿಯ ಪ್ಲಾಟ್ ನಂಬರ್ 309/93 ವಿಸ್ತೀರ್ಣ 35/40 ಅಡಿ ಇದೆ ಎಂದರೆ ಸಾಕ್ಷಿಯು ಹೆಚ್ಚಿಗೆ ಇರುತ್ತದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. 309/93 ವಿಸ್ತೀರ್ಣ ಹೆಚ್ಚಿದೆ ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆಂದರೆ ಸರಿಯಲ್ಲ. ವಾದಿಯರು ಪ್ರತಿವಾದಿಯರ ಜಾಗೆಯಲ್ಲಿ ಅತಿಕ್ರಮಣ ಮಾಡಿದ ಅಳತೆಯು ಪೂರ್ವ ಪಶ್ಚಿಮ 3.4 ಮೀಟರ್, ದಕ್ಷಿಣೋತ್ತರ 8 ಮೀಟರ್ ಇರುತ್ತದೆ. ನಿಧಿ 1 ಅತಿಕ್ರಮಣ ಮಾಡಲಾಗಿದೆ ಎಂದು ಸುಳ್ಳು ದಾಖಲೆ ನೀಡಿರುತ್ತೇನೆಂದರೆ ಸರಿಯಲ್ಲ. ವಾದಿಯರು ಪ್ರತಿವಾದಿಯರ ಜಾಗೆಯಲ್ಲಿ ಯಾವುದೇ ಅತಿಕ್ರಮಣ ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಪ್ರತಿವಾದಿಯವರಿಗೆ ಅನುಕೂಲವಾಗುವ ನಿಧಿ 1 ಸೃಷ್ಟಿಸಿ ನೀಡಿರುತ್ತೇನೆಂದರೆ ಸರಿಯಲ್ಲ. My contention was not such that based on an application, he conducts 3 surveys. And in regards to that first 2 survey, he hasn't produced anything before the court. Only one report which goes in favor of the defendant is produced before the court. Under such circumstance.
Anyway, you said that he has issued 3 notices according to you.
Illa, only 1 notice, he himself claims.
You make a suggestion. ಮೊದಲು 2 ಬಾರಿ ಅಳತೆ ಮಾಡಿದಾಗ ನಿಖರವಾಗಿ ಅಳತೆ ದೊರೆಯದೆ ಇರುವ ಕಾರಣ ಮೂರನೇ ಬಾರಿ ಅಳತೆಯ ಸಂದರ್ಭದಲ್ಲಿ ನಿಖರವಾಗಿ ಗೊತ್ತಾಗಿರ್ತದೆ.
ಮೂರನೇ
ನಾನ್-
ಬಾರಿ ಅಳತೆಯ ಸಂದರ್ಭದಲ್ಲಿ ನಿಖರವಾಗಿ ಅಳತೆ ಗೊತ್ತಾಗಿರುತ್ತದೆ. That's what he states. But then, my lords,
ನೋಡಿ ಅದಕ್ಕೆ
before
ಹಿಂದೆ
that,
ಜಸ್ಟ್ ಒನ್ ಸೆಂಟೆನ್ಸ್ ಬಿಹೈಂಡ್ ದಟ್.
yes,
ನಾನು ಅಳತೆ ಮಾಡಲು ಒಂದೇ ಬಾರಿ
notice
ನೋಟಿಸ್
needed.
ನೀಡಿರುತ್ತೇನೆ,
ಮೂರು
ಮೂರು ಬಾರಿ ನೋಟಿಸ್ ನೀಡಿರುವುದಿಲ್ಲ.
Yes,
ಕರೆಕ್ಟ್.
yes, my lords.
ಮೊದಲಿನ ಎರಡನೇ ಬಾರಿ ಅಳತೆಯ ಸಂದರ್ಭದಲ್ಲಿ ವಾದಿ ಪ್ರತಿವಾದಿಯ ಪ್ಲಾಟುಗಳು ಅಳತೆ ಸರಿಯಾಗಿತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಇದೇನು 17.5 ಏನ್ ಹೇಳ್ತೀರಿ? ವಾಟ್ ಇಸ್ ದ ಸಜೆಷನ್ ಮೇಡ್?
17.5 ಒಂದು
Page
ನೋಟಿಸ್
number 13
ನೀಡಿರುತ್ತೇನೆ
ಅಲ್ಲಿ.
ಅಂದರೆ ಸರಿ. 17 and even, my lords, the date of notice and the alleged survey conducted, these two dates, my lords, doesn't tally each other.
ಇದು ನಿಪಿ 11 ಏನಿದು? 11 ಮತ್ತೆ 12 ವಾಟ್ ಇಸ್ ದಟ್?
ಅದನ್ನು ನಿಪಿ 11 ಎಂದು ಅಂಚೆ ಲಕೋಟೆಯನ್ನು ನಿಪಿ 12 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. It is a notice dated 17/5/2017.
And what is this 28.5?
Second notice. ಅದು ನನಗೆ ನೆನಪಿರುವುದಿಲ್ಲ ಅಂತ ಹೇಳಿ. ಒಂದ್ ಕಡೆ ನೆನಪಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, ಒಂದ್ ಕಡೆ ಐ ಹ್ಯಾವ್ ಸರ್ವ್ಡ್ ಓನ್ಲಿ ಒನ್ ನೋಟಿಸ್ ಅಂತ ಹೇಳ್ತಾರೆ.
Wait
There are
till
too
the
many
final
contradicting
arguments.
lots submissions by the surveyor.
Huh?
There are too many contradictions.
Too many contradictions in them.
And that survey, my lords, on the instance of the defendant himself. If the court, my lords, directs them, my lords, one survey. Because
Jyoti,
ಅವ್ರು ಮಾಡಿರೋದು ಕೂಡ only one plot, that is the defendant's plot ಅಷ್ಟೇ ಅಳತೆ ಮಾಡಿ ಹೇಳಿದ್ದಾರೆ. And he has conducted, although he has conducted survey of all other 8 plots.
you made a statement to CW1 that whatever survey that he conducted was in your absence. ಎಲ್ಲಾದ್ರೂ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕೇಳಿದಿರಾ? CW1 ನಮಗೆ ನೋಟಿಸ್ ಕೊಡ್ದಂಗ್ ಮಾಡಿದೀರಾ ಅಂತ ಎಲ್ಲ ಹೇಳಿದಿರಾ?
To that effect, nowhere, my lords, I have suggested.
Then you were there.
ಅಲ್ಲ, after exam, ಅಲ್ಲ, although after examination only, my lords, I came up with the contention that ಮೊದಲು 2 ಮಾಡಿದ್ದಾರೆ.
Correct ಅಪ್ಪ.
ಹೌದು.
Have you said whatever survey that was conducted by CW1
Yes.
was in your absence? Have you at least put
No,
a
no,
suggestion to him?
I haven't made any such
Then-
suggestion.
Why shouldn't his report be not accepted? ಎಲ್ಲಾರು ಒಂದ್ ಕಡೆ ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು, ನಮ್ಗೆ ಗೊತ್ತಿಲ್ದಂಗೆ ನಮ್ಗೆ ಬೆನ್ನ ಹಿಂದೆ ಮಾಡಿದಿರಿ. ನೋಡಿ, please come to this first sentence, ಇದು page number 28 one.
Please.
ಸದರಿ ಹದ್ದುಬಸ್ತು ಕುರಿತು ಪ್ರತಿವಾದಿ 1 ರವರ ಪ್ಲಾಟ್ ನಂಬರ್ 309/4 ಚೆಕ್ಕುಬಂದಿ ಮಾಲೀಕರಿಗೆ ನೋಟಿಸುಗಳನ್ನು 24/5/2017 ಸರ್ವೆ ಮಾಡಿ ಹದ್ದುಬಸ್ತು ಗುರುತಿಸಿರುತ್ತೇನೆ.
Not here 24/5 is the date referred to.
ಕರೆಕ್ಟ್, ಅವತ್ತೇ ಮಾಡಿರೋದು ಸರ್ವೆ.
25 ಅಳತೆ ಮಾಡಿರ್ತೇನೆ ಅಂದರೆ ನನ್ನ ವರದಿಯಲ್ಲಿ.
ಒಂದು ಕ್ವಶನ್ ಕೇಳ್ಬೇಕಿತ್ತಲ್ಲ, ನಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ, ನೋಟಿಸ್.
The next date, notes in the next page, he refers to 25/4/2017.
20
ನೋಟಿಸ್ ನೀಡಿ ದಿನಾಂಕ.
ಏನೋ ಮಿಸ್ಟೇಕ್ ಇರ್ಬೇಕಷ್ಟೇ.
ಒಂದು ಸರ್ವೆ ಮಾಡಿದ್ದು 24/5/2017 ಅಂತ ಹೇಳ್ತಾರೆ.
This could be a typographical error, Mr.
They have not even sought for any correction, my lords. They have not even sought for any correction in that regard.
Correction, but this survey happened in your presence. If survey happened in your presence, why
Only
this?
on production of that report, my lords, it was brought to my notice that I have encroached. so much.
ಕೇಳ್ಬೇಕಿತ್ತಲ್ವ CW1ಗೆ? should you not have asked CW1 whether the survey was conducted in your presence or not? Just go through whether you have made any suggestion somewhere.
Yes.
And you see this suggestion put, ನೀಡಿ ಒಂದನ್ನು ದಿನಾಂಕ 28/5/2017 ಮಾಡಿದ ಸರ್ವೆ ಆಧಾರದ ಮೇಲೆ ತಯಾರಿಸಲಾಗಿದೆ ಎಂದ್ರೆ ಸರಿ. This is a suggestion that you have put. Page number 13 ಅಲ್ಲಿ
Yes, ma'am.
ನೀಡಿ ಒಂದನ್ನು
ದಿನಾಂಕ 28/5/2011 ಮಾಡಿದ ಸರ್ವೆ ಆಧಾರದ ಮೇಲೆ ತಯಾರಿಸಲಾಗಿದೆ ಎಂದರೆ ಸರಿ.
So therefore you have made a suggestion to him. This is not a very
ಕಲರ್ ನಾವೇ ಹಾಕಿರುವುದಾಗಿ ನೋಡಿದಿರುತ್ತಾರೆ.
This is not an innocuous suggestion. A suggestion which is put understanding the context of that particular document. ಸುಮ್ನೆ ಏನೋ ಅಂದಾಜಲ್ಲಿ ಮಾಡೋ suggestion ಅಲ್ಲ ಅದು. You understood what is the context of exhibit D1. You understood whether it is in accordance with the survey map or not, and then you put a suggestion.
It's one suggestion, lots, they should not be benefited out of.
No.
That.
Barpul. The plaintiffs in OS number 190 of 2017 on the file of so and so.
May I request, next week I'll ascertain whether.
Dictation ಕೊಡುವಾಗ next week.
ನನ್ನ ಹತ್ರ full cross examination ಇಲ್ಲ. Next week I'll.
Non-counsel for the petitioner seeks time, list on.
There's an interim order operating in this.
Interim order granted rejection. BK Hiramat.
Right.
BK Hiramat. There is no representation for the petitioner and the respondent. List on. DP Ambekar. Kumar Kallur.
Raise time. Next week, Miller.
ಯಾರಿಗೆ?
Senior one.
ನೀವು ಯಾರಿಗೆ?
I am for appellants. DP Ambekar.
And counsel for the petition seeks time.
Interim order may be extended.
Interim order is extended till the next. Yes.
Appearing for the petitioners in this matter.
Ready?
Yes.
DP Ambekar. Yes, madam.
That's the petitioner herein is the plaintiff in suit in OS number 499 of 2014. The suit is for relief of declaration, possession and mandatory injunction. Suit property is an open area bearing CTS number 273 and bar 67 situated in survey number 3 of Dadapur village in Kalaburagi. Lodged in this matter, the defendant number 2 died on 14/11/2016 before the trial court. And the advocate for the defendant number 2 filed a memo reporting death on 22nd of February 2017.
Yes.
Subsequently, I filed an application which was belated by 9 days, and I filed 3 applications for bringing LRs of defendant number 2, for condonation of delay in filing the application, and for setting aside abatement. All the 3 applications were rejected by a common order dated 12/10/2018. It was stated in the order that the affidavit that the plaintiff and the defendant number 2 are neighbors, and the death of defendant number 2 was very much within the knowledge of the plaintiff.
Yes. ಯಾರು? DP Ambekar. Hello, ಮಾಡ್ಬೋದಾ?
They appear for the corporation in this matter.
It's not a suit for bare injunction. Suit is for possession.
Possession.
And counsel for the respondent number 2 seeks time list tomorrow.
They appear for the corporation. I don't think they appear for the corporation in this matter. I don't think they would have any objection for this writ petition.
Baker is for the corporation.
Yes, ma'am.
Yes, what is your objection?
The other defendant is served and unrepresented.
ಆಯ್ತು, ನಾಳೆಗೆ ಹಾಕ್ಬಿಡಮ್.
Please. Okay.
Varmagowda Patil, Ravan Kumar.
The order of committal to the civil prison of.
Ah,
There has been committed to civil prison for violating the.
ಆಗೋಯ್ತಾ ಟರ್ಮ್ ಆಗೋಯ್ತಾ ಸ್ಟೇ ಇದೆಯಾ
Stay ಆಗಿದೆ.
ಇಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆಯಾ ವಾಟ್ ಹ್ಯಾಪನ್ ಟು ದ ಸಿವಿಲ್ ಸೂಟ್ ಏನಾಯ್ತು
Was defeated while pendency of RA came to dismiss matter. ಈ EP violation EP ಆಗಿದೆ ಅಂತ commit ಮಾಡಿರೋ order ಇಲ್ಲಿ challenge ಮಾಡಿದ್ದಾರೆ.
ಡಿಕ್ರೀಸ್ ಫಾರ್ ವಾಟ್
Injunction.
ಇಂಜಂಕ್ಷನ್ ಡಿಕ್ರಿ
He may come tomorrow.
list tomorrow. There is no representation for the petitioner list tomorrow. DP Ambekar.
Next week, Miller.
ಯಾಕಪ್ಪ ಯಾವ್ದು ಬಂದು ಅಂಬೇಕರ್ ಯಾಕೆ
Interim order may be extended.
ಅಲ್ಲ ಈ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಇಂಟ್ರಿ ಮಾಡ್ಕೋದೆ ನೀನು
Next week,
ವೇರ್ ಇಸ್ ಅಂಬೇಕರ್
once,
ಗಾನ್
yes.
ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಇದಾರೆ ಅಂತ ಹೇಳ್ರಿ ಡೋಂಟ್ ಟೆಲ್ ದ ಟ್ರೂತ್ ಆಲ್ವೇಸ್ ಅಪ್ರಿಯ ಸತ್ಯಂ ನ ಉವಾಚ ಅಪ್ರಿಯ ಸತ್ಯಂ ನ ಉವಾಚ ಏನ್ ಮಾಡ್ತ ಟುಮಾರೋ ಯಾವತ್ ಬೇಕು ಹೇಳ್ರಿ
Next week,
counsel for the petition seeks time list on
interim order may be extended.
interim or the extent to the next. Rupa Sagar Patil.
Dispute regarding calculation of interest and all. He wanted to file the memo of calculation, Krupa Sagar Patil.
ಎಲ್ಲ ಒಬ್ಬೊಬ್ರೆ ಮಾತಾಡ್ಕೊಂಡಿದ್ರು ನೀನ್ ಹೋಗ್ಬಿಡ ನಾನ್ ಹೋಗ್ಬಿಡ ನೀನ್ ಹೋಗ್ಬಿಡ ಯಾರು
Election matter ನಡಿಬಹುದು ಅಂತ ತುಂಬಾ ಜನ ಹೋಗ್ಬಿಟ್ಟು.
There is no representation response 2 to 4 list tomorrow. Manjunath Malay Shetty. There is no representation for the petition and the respondent list on.
Threat is the infructuous. Main matter is disposed of.
Suit is disposed of.
Yes.
Yavat. The learned counsel for the response 1 to 3 submits that the suit from which the present writ petition arises was disposed of, and therefore the writ petition has become infructuous. Check madimad. Full stop. In view of the aforesaid submission, this petition is disposed of as having become infructuous. However, liberty is reserved to the learned counsel for the petitioner if the aforesaid statement is not correct. Yes.
Mr.
Mr. J. Augustine.
ನಾಳೆಗ ಅವ್ರು ಇಲ್ಲ.
ಏನು?
Application for amendment is filed in the.
Application for?
Application for amendment
Ah,
of plaint is filed at the appellate stage.
at
That
the
is appellate stage.
appellate stage.
That is rejected.
ಏನಕ್ಕೆ? What is the suit for?
My lord, we wanted to add some suit properties in the schedule,
Partition suit ಆಗಿದೆ.
partitions.
FDP ಹಾಕೊಳ್ಳಿ. Include that in the FDP. Where's the question of in RA ನಲ್ಲಿ?
If it is admitted that it is a joint family property, my lord, then only we can add it in FDP. If it is disputed.
In FDP, it's a continuation of the preliminary decree.
Of course, of course.
So all these things will be looked into.
Because they dispute about the joint family property.
Correct? Adunu
FDP ಅಲ್ಲಿ, if the both parties agree that it is also a joint family property, then there is no,
both parties agree. If both parties don't agree, the court can decide.
can decide.
Huh.
Ganduri Koteshwar Rao judgment is there. In
Ganduri
which
Koteshwar Rao alla. Shubkaran Bubna.
FDP.
Shubkaran Bubna ಅಂತ ಇದೆ ನೋಡಿ. There's one judgment of Justice R.V. Ravindran. Please go through that. Shubkaran Bubna. ಸಿಕ್ತಾ? BUB ಎಣ್ಣೆ ಹಾಕ್ರಿ ಸಾಕು ಬರುತ್ತೆ. Got it?
Shubhakaran Bhumna.
In the preliminary decree, all that the court will look into is the share. In final decree proceedings, all other issues will be gone into. Whether it is partible, not partible, whether it is available or not, additional properties, all these things they will look into.
If that observation is made, my lord, it is enough for me. I may not proceed.
Good. The appellants in RA 48 of 2022 on the file of the senior civil judge and JMFC Linga Sugur have filed this petition challenging an order dated 10/7/2023 passed therein by which an application filed by them and order 6 rule 17 of CPC for amendment of the plaint was rejected. Next para. The suit in OS number the suit in OS number 265 of 2014 was filed for partition separate possession of the plaintiff's share in the suit shall properties. Full stop. The suit was decreed in part, following which, an appeal in RA 48 of 2022 was filed. Full stop. During the course of the appeal, an application was filed by the plaintiff / petitioner herein for amendment of the plaint to include certain other properties in the plaint. Full stop. This application was contested by the defendant number 1 / respondent number 1 herein, who contended that the properties must have been included at the time of filing the suit. It was also contended that the amendment sought for was not necessary for the purpose of disposal of the suit. It was also contended that several properties situated Gadag,
Gadag.
Gadag,
GALAG.
Gadag, at Gadag stood in the name of different persons, and without impleading the said persons, the application cannot be allowed. It is also contended that one of the properties which one of the properties which was sought to be included in the suit stood in the name of the father of the defendant number one. And after his death, the plaintiff had got his name entered in the municipal records. And the same was got his name entered in the revenue records, which was challenged before the Assistant Commissioner Raichur. Full stop. Therefore, it was contended that the properties would not be included, that too at the appellate stage. Full stop. Next paragraph. The appellate court, after considering the contentions urged by the plaintiff as well as the defendant number one, dismissed the application on the ground that the application was filed when the appeal was taken up for final arguments. It perused the records that were placed along with the application and held that the claim of the plaintiff that the properties mentioned, the additional properties sought to be included for ancestral and joint family properties cannot be accepted as the concept of ancestral and joint family property is not known to Muslim, not known amongst Mohammedans. Full stop. It therefore held that the amendment application was not necessary for consideration of the suit and the appeal, and consequently rejected the application. Being agreed with the said order, the appellant is before this court in this petition. Next para. The learned counsel for the appellant contends that the plaintiff intended to bring on record two other properties which were to be partitioned amongst the plaintiff and the defendants, which were not included in the suit when it was originally filed. He submits that the appeal in RA 48/2022 was filed against the preliminary decree, and until the final decree is drawn, the plaintiff is entitled to include any other property that is available for partition. Full stop. The learned counsel for the respondent is absent. The learned counsel for the response 1 to 5 is absent, and therefore this court did not have the benefit of his submissions. Next para. A suit for partition results in two stages. One is the stage at which a preliminary decree is passed. The suit for partition results in, a decision in a suit for partition. A decision in a suit for partition give rises to two stages. The first of which is at the stage when a preliminary decree is passed declaring the shares of the parties. And the second and the next stage would arise when the court passes a final decree determining the shares, determining the properties of properties proportionate to the shares so declared. Full stop. At the penultimate stage, the possession of the properties so identified would be handed over to the respective parties. Full stop. Therefore, until a final decree is drawn, a full stop. Therefore, The shares to which the parties are entitled to can also vary depending upon various circumstances, such as birth or death of any member in the family. Full stop. Therefore, until the final decree is drawn, the partition suit cannot be deemed to have been disposed of. Full stop. The apex court in the case of Justice Nazir or judgment is the apex court in the case of Dash has categorically recorded a finding in this regard, and has held that final decree is nothing but a continuation of preliminary decree. Full stop. The apex court in the case of Shubkaran Bubna versus so-and-so, Bubna versus Bubna, Shubkaran Bubna versus Sita Saran
Sita
Bubna
Saran.
and others, 2009, Part 9 SEC, page 689, has also considered the very same question and has held that final decree proceedings are continuation of the preliminary decree. Full stop. Therefore, the plaintiff was not well advised to file an application in RA 48 of 2022 to include additional properties, while what was challenged was only the preliminary decree and whether plaintiff was entitled to a part decree in the properties which are already included in the suit. Full stop. In that way of the matter, the appellate court was justified in not entertaining the application filed by the plaintiff. Full stop. In view of the above, this writ petition is disposed of upholding the order passed by the appellate court. However, liberty is reserved to the plaintiff/petitioner to work out his remedy in final decree proceedings. Full stop. If any application is made in final decree proceedings, the final decree court shall ascertain whether the properties sought to be included are also available for partition or not. All contentions are kept open. Lead. Oblige. Sharanu is Saradagi.
Yeah, I will submit. Essentially, the
Can you recollect which is the judgment?
AIR 2022 Supreme Court 2841. Kandakan, it's a very typical Kerala name.
I am not able to.
Kandakandi Edathil Walsan. AIR 2022 Supreme Court 2841.
Yes. Sharanu is Saradagi.
Yes, I have. Lords, essentially, this is a case where the parties agreed in a particular fashion that there was a total land of around 14 acres and odd land was available. There was a dispute saying that the very petitioner, plaintiff, original petitioner, has died. Falsely it was stated, and the defendant had mutated his name in the ROR. He found that it is wrongly shown that he has died and the defendant is his LR. Therefore, appeals before the revenue authorities went on. Finally, the original petitioner had to file the suit for declaration, injunction, and mandatory injunctions, because in that 14 acres of land, several houses were also built by few persons. These defendants in the suit were around some 24 defendants. When the suit was proceeding, a joint memo is filed before the court to refer it to the Lok Adalat as per Annexure T. And the Lok Adalat says, in view of the joint memo, the plaintiff is permitted to withdraw the suit. That has become the award of the Lok Adalat now. In fact, no formal award is passed. That's the recording of the Lok Adalat before the honorable conciliators of the Lok Adalat.
Plaintiff has withdrawn the suit.
This is how it is recorded. In terms of the Annexure T, what was written is, in view of the settlement of the disputes out of the court, the plaintiff, the matter can be referred to the Lok Adalat is what the memo speaks of at Annexure T, page number 100.
Outside the court, Andre?
The outside the court ಏನಾಗಿತ್ತು ಅಂದ್ರೆ as we know it, there were constructed portions in the entire 14 acres of land. It was agreed that we would give up our right over the constructed portions. We will not disturb those persons who have constructed, but we will now retain the property which is available, which is open. But this was Annexure T, page 100. In the above case, the dispute between the parties is settled out of the court. Hence, the above case may be kindly be referred to the Lok Adalat for
Tina,
T for table 100. After this, my lords, on the same day, probably, it seems another memo is there at Annexure U, page 101. In view of the settlement, plaintiff does not want to proceed with the case. This is the memo filed before the Lok Adalat. So there is actually the Lok Adalat at Annexure V, page number 103. It doesn't record any compromise or settlement. It only permits the suit to be disposed of in terms of joint memo, which in turn says that I want to withdraw the suit because of a settlement out of court.
so now the petition is a plaintiff.
Petition by the plaintiff of the suit. The plaintiff, original plaintiff has died.
If that is the case, what prevents you from filing another suit?
Another suit, if your lordships permit that, we will.
Let me tell you, that is the law, alva.
If in the wake of the award of the Lok Adalat, which becomes final.
ಯಾವ್ದು Jet King plywood, Jet plywood. ತೆಗೀರಿ. Jet plywood ಅಂತ ಇರ್ಬೇಕು ನೋಡಿ, ತೆಗೀರಿ ಅದು. In 1997 or 98 in Supreme Court. No, once it is settled outside the court, and if you say it is not settled, you can always come back to the court, file a fresh suit.
That filing a fresh suit, my lords, now because of the provisions of the 1987 Act, once the recording of whatever sort happens before
What
the
is recorded?
Nothing is
recorded.
compromise or settlement is to be recorded necessarily, without which
I think Jet plywood, I think, is almost on the same lines. Just have a look at it. Jet plywood ಅಲ್ಲ?
Yes.
ಇದೆಯಾ?
2006.
ಹಾ?
2006.
ನೋಡಿ.
2006 Supreme Court 126.
ನೋಡಿ.
Supreme Court 126.
by mistake, if the suit is withdrawn under 151, it can be made. But I will
I
have to
think
go.
even in that case also, either nodi, you can pull it out. I think there also there was some settlement and they said
The
outside the court.
I'm saying the same also. The principle in jet plywood that says under 151, if it was under a mistaken notion, you withdraw the suit.
Taken Allah. I think it was settled outside the court.
Outside.
And thereafter they said there was no settlement, something like that. Hmm?
There are 200 houses are there. This litigation is filed after 16 years and all. And some of them, there are 7 persons is already dead, long back, as on date of litigation itself.
ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? You find out a solution, what has to be done?
Well, fresh suit.
As of the date of filing, so many persons are died. And there are 300 houses are already built. There is no.
See, some settlement you're supposed to make, give him something.
Because even may not 16 years back, it is already settled everything. There are 4 certificate changes on there. You see, it is decree and the rate petition is filed after 16 years.
ಏನಿದು ಯಾವತ್ತಾಗಿದ್ದು?
2008. Therefore,
Annexure T is 2008.
yes, no. Therefore, it is very clear.
2008.
2008.
Delay and latches.
Delay and latches. What has the, let my friend Manoj tell, what were the terms of the settlement? I will agree to that, Manoj, and I will go out. I will go out of the court. Let him explain what was the term.
Everything is in thin air.
And that's why, that is the difficult.
ಹೊರಗಡೆ settle ಆಯ್ತು.
I have no other ground other than now. I'm compelled to argue on technicalities because the terms are not known to anybody. The technicalities are that unless a settlement or a compromise is recorded by the Lok Adalat, Lok Adalat will not get jurisdiction at all to pass an award. There cannot be an award of the sort where I'm saying I want to withdraw the suit. I cannot go before the local to
But you
withdraw.
have abandoned the proceedings in 2008. You can't come in 2006.
That is
2023.
I'm aware, my lords. I have weaknesses on not only the delay and latches, but also on the point that I have given a memo saying that I want to withdraw. But then, my lord, some settlement can it be assumed that there are only 24 persons having sites worth measuring 13 to 40 feet in an extent of 14 acres of land? I would not have agreed to give up everything.
200.
Even today, my lords, if your lordships refer is to the
So, ಇದೆ?
ಅಲ್ಲಿ
ಹಾ.
ನಲ್ಲಿ ಯಾವುದು 100
ಎಷ್ಟು ಮನೆ
therefore they have said it ಈಗ third
ಎಷ್ಟು ಮನೆ ಇದೆ?
ಇಲ್ಲ 100 ಮೇಲೆ
ಇರೋಣ 20 ಅಂತಾರೆ.
24.
ಇಲ್ಲ
100 ಮನೆ ಇದ್ರೂ it will be not more than 5 acres of land, not 14 acres.
ಈ ದೊಡ್ಡ ದೊಡ್ಡ ಬಿಲ್ಡಿಂಗ್ ನಾವು ಯಾರು ಥರ್ಡ್ ಪಾರ್ಟಿ ಕ್ರಿಯೇಟರ್ ಯಾರ್ಯಾರ್ದು ಅದ್ರೊಳಗೆ 8-10 ಮಂದಿ ಎಷ್ಟು ಜನ ಸತ್ತಾರೋ 16 ವರ್ಷ ಆದ್ಮೇಲೆ ಈಗ ಬಂದು ನಾವು ಇದು ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ
ಓ ಇದು ಯಾವ್ದು ಕಲಬುರ್ಗಿ ಇಲ್ಲ ಇರೋದು ಇದು?
Yes. It is in Yadgir.
ಯಾದಗಿರಿ ಸಿಟಿ.
Yadgir.
ಸೇಲ್ ಥರ್ಡ್ ಪಾರ್ಟಿ ರೈಟ್ ಈಗ ನಿರ್ಮಾಣ ಆದಾಗ ಸೆಟಲ್ ಆಗ್ಯಾವ ಆಫೀಸ್ ನೋಡಿ ಹಾಕಿದ್ರೆ
ಇಲ್ಲ. But the dispute is only between the petitioner and 24 persons. If the 24 defendants want to now espouse the cause of somebody else, saying that there are other persons also.
I will look at this. ಕೊಡ್ರಿ ಅವ್ರಿಗೆ.
ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಿ 100 ಸೆಟಲ್ ಸರ್
ಇದೆಲ್ಲ
Now there is no limitation.
Which year? My friend has one more GPS map, my lords, which shows not these many houses. Of course, there are.
ಕೊಡಿ ತಗೊಳ್ಳಿ ಇದೇನು?
May I pass on this?
Latest photo.
This is the latest one, is what my friend says.
Which is your survey number 382? 382 na?
382 measuring 14 acres, 5 guntas. Recent last month. Last month sale.
No, at least you said there are 24 defendants. There are easily 24 houses here.
There are more, there must be more also.
So if there are 24 houses, assuming that they belong to 24 defendants, ಖಾಲಿ ಇರೋ ಕಡೆ ಹೋಗಿ ಕೂತ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ನೀವು ಏನು?
ಅಷ್ಟೇ ಬೇಕಾಗಿತ್ತು. I am not asking for it.
No court orders. We can't permit you to do anything.
That's why my proposal is, if they say that there was something which they had to give to my client, then can there be my lords, a mediation before this court at least? Because the terms are not known to anybody.
Then I think you may have to work out your remedy. Suit ಹಾಕೊಳ್ಳಿ ಇನ್ನೊಂದು ಏನಾದ್ರು ಬೇರೆ
That
I
liberty.
will not grant any liberty.
If your lordships make
We
some
can't-
observation.
You know very well, the court cannot create a cause of action.
Not that. If your lordships would
Therefore,
follow some judgment and
we
then
can't
say that.
create any cause of action. Could you read it? Paragraph number 3 ಹಂಗಿದೆಯಲ್ಲ. Paragraph number 3. Specific performance of the agreement purported to have been cancelled and for temporary injunction. Thereafter, The respondent number one applied to the court for leave to withdraw the suit on the ground that since there were talks of settlement between the parties, he no longer wished to proceed with the suit. No leave was prayed for to file a fresh suit on the same cause of action. Allowed the respondent to withdraw the suit but without liberty to file.
Yes.
After termination of the agreement and after withdrawal of the suit, Banerjee and other co-owners sold the premises to Jet Plywood. Within a month thereafter, he applied to the court for recalling the order by which the suit had been permitted to be withdrawn on the ground
He had
that
misled
he had
into
been
making.
misled into making such an application on account of the misrepresentation of Vishwarup Banerjee and the other co-owners that they would sell the property to him provided he withdrew the suit. Rejected the said application.
Thereafter, second suit is filed.
Notary, whether this judgment has been referred to in any of the subsequent judgments. No?
Yes. There are references, my lords, in,
Yeah.
it is referred in few judgments, but
Immediately,
you can't stop him from filing one more suit.
Cause of action should not be given.
ಎಲ್ಲ ಅವ್ರು ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ಕೋಬೇಕು.
Immediately other this problem could not have been arrived. All send it again, three times send it again. 2008 we have applied impact of the income and 150 share transaction.
this is referred in another judgment named Shilpa Shailesh versus Varun Srinivasan, 2023, volume 6, scale 402.
Take advantage of it. ಬರ್ಕೊಳ್ಳಿ. The petitioner has challenged an order passed by the ಲೋಕದಾಲತ್ ಇದು.
ಹೌದು, ಲೋಕದಾಲತ್. Page 103, the matter is referred from the civil court to the Lokadalat.
The petitioner has challenged an order passed by the Lokadalat
Scale mode, page number, scale.
dated 15/10/2018 in OS number 52 of 2022, Yadgiri. Full stop. Next para. A suit in OS number 52 of 2002 was filed for ಏನಕ್ಕೆ?
Declaration, injunction and mandatory injunction.
Declaration of title, perpetual injunction and mandatory injunction in respect of land bearing survey number 382 of
Yadgiri.
B. Yadgiri Taluk, Yadgiri Taluk, Yadgiri district. Full stop. The suit was contested by a few of the defendants. Later, a joint memo was filed by the plaintiff. The dispute is settled outside the court and requested the court to refer the case for Lokadalat. The joint memo was signed by the plaintiff, his advocate, as well as the defendant and their respective advocates. Accordingly, the file was placed before the Lok Adalat, which recorded a settlement between the parties on the same day, and the suit was dismissed as settled out of court in terms of the order dated 15/10/2008. Full stop. The petitioner has challenged the said order in the year 2023 in this writ petition. Next, the learned senior counsel appearing for the petitioner submitted that though the parties had agreed to settle the dispute outside the court, the settlement did not fructify, and none of the defendants
Not fructified.
stood by the settlement, and therefore the plaintiff is advised to challenge the order passed by the Lok Adalat. He further submits that the Lok Adalat could have only recorded a settlement and could not have recorded that the parties have settled the dispute outside the court. Therefore, he contends that the order of the Lok Adalat is improper, outside the purview of the Karnataka Legal Services Authorities Act.
The Legal Service Authority
The
Act.
Legal Services Authority Act. Full stop. Thus, he contends that the impugned order passed by the Lok Adalat deserves to be interfered with. Per contra, the learned counsel for the defendants contend that the parties have settled the dispute outside the court, consequent to which the defendants have constructed houses and thereafter have executed various sale deeds, and several buildings have come into being in the suit property. He also contends that several transactions are brought about, and therefore the transactions cannot be undone at this point in time. Next, full stop. He also contends that the petition is filed belatedly, that too after 15 years. 2023 file model.
15 years.
15 years from the date of the compromise recorded before the Lok Adalat. Next, I have considered submissions by the learned senior counsel for the plaintiff/petitioner and the learned counsel for the respondents. Next para. It appears that the parties had filed a joint memo before the trial court that the parties had settled the dispute outside the court and requested the court to refer it before the Lok Adalat for settlement. Full stop. The parties were referred before the Lok Adalat, and the plaintiff was represented by an advocate, and all of them stated before the mediators, before the Lok Adalat, that the parties had settled the dispute outside the court. Full stop. The said settlement was recorded by the Lok Adalat, and this suit stood disposed of. Full stop. The plaintiff did not make any attempt from the year 2008 till 2023 to get the suit restored on the ground that the settlement that was agreed outside the court was not acted upon. Full stop. Therefore, he cannot now come to this court challenging the order passed by the Lok Adalat. That too after nearly 15 years from the date of the order of the Lok Adalat. In that view of the matter, this petition is dismissed. However, if the plaintiff is with law, he is permitted to do so. Great. Like all other cases, some other.
My lord, I'm from Bangalore, Milord. This matter of serial number 47. My sincere apologies, Milord. I missed out on this preliminary hearing. Can this matter be listed tomorrow, Milord? I'm challenging order 16 rule 6 ಅಲ್ಲಿ summons to commissioner ಮಾಡಿದ್ದಾರೆ.
47.
Please, Milord.
ಆಯ್ತು ನಾಳೆ.
Lord, serial number
Grateful,
72.
grateful.
Your Lordship, serial number 72. It is an appealable order. Would your Lordship kindly have it on Monday? 72, my Lord.
Ravindra Reddy.
Not there. We have challenged that order. Order itself is without jurisdiction. On that point, it has been challenged.
ಯಾವತ್ತು ಬೇಕೋ ತಗೊಳ್ಳಿ.
Interim order.
Monday, actually.
Any date you want.
Court officer, serial number 47 ನಾಳೆಗೆ ಡೇಟ್ ಕನ್ಫರ್ಮ್ ಆಯ್ತಲ್ಲ? Hello. Court officer, serial number 47 ನಾಳೆಗೆ ಡೇಟ್ ಕನ್ಫರ್ಮ್ ಆಗಿದೆಲ್ಲ? Court officer. Hello. Court officer. ಕೊಟ್ಟಿದಾರಲ್ಲ? ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್, ಥ್ಯಾಂಕ್ ಯು. ನಾಳೆಗೆ ಬೇಕು ನಂಗೆ ಅದಕ್ಕೆ.
76 tomorrow.
76 entry order ಅಂತ ನೋಡ್ರಿ.
Serial number 72, Monday ಹಾಕಿದಾರಾ?
ಇವ್ರೆ ಬರೀಲೆ.
ಯಾರಿಗೆ ಸರ್ ನಮಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂದ್ರ? ಸಾರಿ, ನಮ್ಗೆ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಇದೆ.
ನಾವು ಸುಮ್ಮನೆ ಬಂದಂಗೆ ಆಯ್ತು ಅಂತೀನಿ.
ಸರ್ ನಮಗೆ
ಏನಾಗ್ತದೆ ಅಬ್ಸೆಂಟ್ ಅಂತ ಬಂದ್ಮೇಲೆ ನಾವೀಗ ಪಾರ್ಟಿ ಹೋಗೋತಾವ ಸರ್. ಕ್ಯಾಪ್ಟನ್ ಸರ್ ನಾನು ಐತಿ ನೈಟ್ ಮುಂದೆ ಏನಕ್ಕೆ ಹೋದೆ
ಸರ್ 47 ನಾಳೆ ಸರ್ 47 ನಾಳೆ ಕೊಟ್ರ ಅಂತ ಒಂಚೂರು ಕನ್ಫರ್ಮ್ ನಂಗೆ ಅರ್ಥ ಕೇಳಿಸ್ಲಿಲ್ಲ.
ಮಾಡ್ರಿ